Good morning, all. This hearing is in the matter of CFI 079-2023 and is being held by way of video conferencing before His Excellency Justice Rene Lemiere, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by White and Case. Lead counsel is Mr. Tom Montague Smith, KC. The defendant is represented by Habib Mullah, and lead counsel is Mr. Stephen Docherty. Thank you, Your Honour. And if I can just quickly add that only lead counsel are to have their cameras on, please. Thank you so much.
Yes, Mr. Docherty, I can't see you yet. It may be that when you speak, your picture will emerge.
Can you hear me, Your Honour?
I can hear you, but I can't for some reason.
I can.
You're not on my screen. I'm not sure.
Right, interesting. I can see myself. I don't know if others can.
Yes, now I can see you.
Okay.
That's much better. All right. Before I refer to the agreed times for addresses today, are there any applications, housekeeping or other matters to address? Mr. Montague Smith.
None from me, Your Honour.
Mr. Docherty?
No, only the first matter I'm going to address you on anyway, which is a part of substantive submissions rather than it being housekeeping.
Well, there is a matter I'm going to refer to. The defendant's legal representatives sent to the court for forwarding to me a copy of a letter sent by HI Egypt to, I don't have it in front of me, but a company in Malaysia. Now, that letter is not in evidence, and I do not intend to have any regard to it unless and until something is done to change that position. All right. Now, the times that I have been informed of that have been agreed by counsel is that the defendant will initially address for 3 hours. So I propose, in the way we have been approaching these, we take an hour and a half, a 15-minute break. The second hour and a half, on my calculations, that would take us through to 1:15, and I would propose that we would break for lunch or whatever we're doing in the place we're at until 2 o'clock. And then similarly after that, we'll proceed in blocks of an hour and a half with 15-minute breaks. All right, well, I think, Mr. Docherty, it's your turn.
Yes, Your Honour, thank you. The first part of this morning is to continue with the submissions on the claim. Dealing with the matter that you just raised, the point of sending in this piece of correspondence is it is a development which we say is relevant to the court's consideration. I mean, one of the oddities of this case was that the way that the claimants have come to the court is that they're asking Your Honour to make findings based on Health Insights Dubai's ownership of MCC. More than that, the claimants' written submissions are actually asking Your Honour to make a declaration of ownership. And I'm going to come on to deal with the evidential deficiencies in that case this morning. But you will recall during the course of evidence the fact that, notwithstanding their position before this court, Your Honour will have seen evidence on multiple occasions of the claimants consistently taking conflicting positions. And I've summarised those points at paragraph 582 of the written closings. But the claimants have asserted in cases before the Egyptian and Saudi courts that MCC is owned by Health Insights Egypt. And in the case brought by Health Insights Egypt and Health Insights Saudi, they expressly assert, and I quote, Health Insights Dubai does not own the intellectual property rights to this software.
Mr. Docherty,
that was from June this year.
May I stop you there? If I didn't make myself clear at the beginning, I'll try again. First of all, in my view, that letter should not have been sent to me in the absence of some application or foreshadowed application that it was to be put into evidence. Secondly, it is not in evidence, and I cannot properly pay any regard to it when it's not in evidence. Now, you've started addressing it. Is there something I'm missing? Do you say somehow I can have regard to it, notwithstanding it's not in evidence?
Well, at the moment, I was addressing you on other matters which are in evidence.
Yes, but
which
you did slip in a reference to the letter. I want to make it clear that absent it being formally in evidence, I'm not going to have regard to it. And any mention of it might go through my ears, but it won't do anything more than that.
Well, in that case, we make that application now orally, Your Honour. The document is relevant to material. It's material to how the claimants put their case.
What application do you make?
To have that piece of evidence included as the documentary record for this case.
Well, it seems to me, I don't want to be accused of being too formal, but it seems to me clear that it cannot, and you cannot put into evidence unless you reopen your case. The way trials are conducted are that evidence is presented before the court, the evidence is closed, and at that point, the case is determined on the evidence that's before it. If you want to put in more evidence, you have to reopen your case for the purpose of putting some documentary or other matter into evidence and then put it into evidence.
Your Honour, this is a somewhat exceptional case, we would say, where the evidence has been created some 2 days before oral closings were due to commence and after the evidence closed. So this is not some document of historical creation which wasn't put into the evidential record at the time when we were hearing the evidence. It's a new document.
Mr. Doherty, I'm addressing the you might see it as the formalities of the matter, but I regard it as an important procedural matter. That it's not simply a matter of here's an important document and it should go into evidence. It seems to me, and this is the point I want you to address first up, that in order for it to go into evidence, you must apply to reopen your case. Let me start that again. If you were conducting this case in England, not in the DIFC, you can't just slip a document in the course of closing submissions. You have to, as I understand it, I don't think English law has changed that much. You have to apply to reopen your case. You do so for the purpose of and on the basis that a document or some evidence is relevant that you couldn't have put in before and so on. But at the moment, you haven't applied to reopen your case. You're just sort of making submissions that it's an important document and I should have regard to it. But I think the formalities, if you call it that, have got to be complied with. Or am I missing something?
Well, I take Your Honour's point on the formalities. Let me put it in, because I don't want to take up all this morning's time on it, and you're correct. There's no application to reopen the case, and if that's Your Honour's view, that's Your Honour's view, of course. What we will say.
Let me again stop you. I have not said you can't apply to reopen your case. What I have said is you haven't.
Yes, Your Honour, and to the extent that that's what needs to happen, we would make the application this morning, ask Your Honour to put that document into the evidential record and that it stand as documentary evidence in the case on the basis that it's relevant and material to the way that the claimants put their case. So I accept that no application was put in last week during the course of closing. There's no documentary application before you. That's the way that I'm asking Your Honour to treat the document this morning and the basis on which we seek to refer to it. It's a newly created document. It was
let me be clear,
in the middle of last week.
Let me be clear. I want you to say in words that you are, if this be what you want to do, that you are applying to reopen your case. I want you to state what it is you want to do. That is, it is to tender or put into evidence that document and whether there's anything else you want to do with it. For example, to recall witnesses to be questioned about it, or I just want to know exactly what your application is.
Yes, it's to reopen the case for the purposes of adducing that document as evidence of what that document says. It's not a matter of putting it to a witness. It's a matter that we seek to adduce to make submissions on what the document says in light of how the claimants frame their case.
Right. Now, do you want to say anything further in support of that application?
It's simply to point out the relevance of materiality. We've had 3 hours of closing on Friday, which related to an assertion by the claimants that MCC is owned by Health Insights Dubai. The relevance and materiality of this document is that 2 days before closing, there are letters being sent on behalf of Health Insights Egypt, which assert a completely different position. And we say that's consistent with the way that other areas of this case have unfolded, particularly positions taken before the Egyptian and Saudi courts. So it's further support for the submissions we make on that.
All right. Mr. Montague-Smith.
Your Honour, I'm taken by surprise by this application. I don't understand why the application hasn't actually been made properly on notice in advance, so I don't have instructions on the application. We doing the best I can. We resist the application. It's pretty extraordinary to try to introduce new evidence after the close of evidence. There's a number of principles at play. One is finality. I mean, every case is decided in the context of developing facts, and there has to be a cutoff, and the cutoff is the end of trial. Why is that? For the purposes of fairness? I mean, it's shocking, quite frankly, that my learned friend should say it's not a question of putting these things to the witness. And that's been his approach, we would say, all along. He doesn't think he needs to put the case to the witnesses, but he does. And so if he wants to make submissions about what these documents say, firstly, we need to understand what the case is, precisely what the case is. And he just says, oh, well, it's relevant. But secondly, he then needs to put it to the witness to say that's what it shows, whatever the proposition that's being asserted. And it's very difficult to understand what that proposition is, because he says in a very aside way in his closing, well, there might be a question of whether or not we're entitled to do this or are stopped from asserting that Health Insights Dubai owns MCC because of statements made in other sets of proceedings. He doesn't say we are stopped. And if one thinks about estoppel, well, estoppel is a principle that prevents you from denying an asserted fact.
I don't think he's claiming an estoppel, Mr. Montague-Smith. He certainly hasn't said so.
Where does it go?
He's put it on the basis that it's material evidence. No, that's
but material to what issue? Material to what issue? Which is right. He's asserted that it's material, but I'm trying to understand what the issue is. But what
I'm going to do, Mr. Montague-Smith, I'm sorry to rudely cut you off, but I am conscious of the time. What I propose to do is to defer the application till later in the day when Mr. Doherty has made his submissions. Then, Mr. Montague-Smith, you will know what his case is, how, if at all, it fits in. You may even have received some instructions by then. But if I can say at the outset, the position that I take is first that I have jurisdictional power to admit the document into evidence, both I think in this court and in the courts of England. One can reopen the case at any time before judgment, including even after submissions. The questions, of course, are to balance, as you've said, Mr. Montague-Smith, on the one hand, finality against fairness, where and the sort of matters that court must have regard to is not just the relevance, but the materiality of the evidence to be put in. Secondly, whether this case the defendant could have put it in earlier, and thirdly, any prejudice that's caused to the claimant. So with those matters in mind, I'm going to defer resolving the application until Mr. Doherty has expounded upon how he puts his case, and then Mr. Montague-Smith, you can see it in context. So, Mr. Doherty, please proceed on the basis that I'll deal with your application later.
Thank you, Your Honour. I take it by that you're content to hear what I have to say about the documents, and you'll decide later what to do about that.
Yes, I think
Yes.
I'm in that luxurious position of not being a jury and being able to take them into account or not as I see fit.
Yes. Thank you, Your Honour. I'm grateful for that indication. The point really is a pretty short one. I'd started referring, Your Honour, to these contradictory positions taken in other cases. Health Insights Dubai doesn't own the intellectual property rights in the software. That was from June this year. Communications have been repeatedly sent to third parties asserting ownership of MCC by Health Insights Egypt. The registration was procured for the IP in MCC by Health Insights Egypt. That happened in August 2022, as soon as the claimants were able to get their hands in control of the company. In cross-examination, the second claimant just refused to answer whether MCC was owned by Health Insights Dubai or Health Insights Egypt. I think I asked him it 9 times, at least. The first claimant expressly said in his cross-examination that Health Insights Egypt is owned by MCC.
Mr. Doherty, do I understand you to be telling me that there is already evidence of Health Insights Egypt claiming to hold the copyright over MCC?
Correct. There's evidence of Health Insights Egypt raising that claim, but also there's evidence of the claimants asserting that position that Health Insights Egypt owned MCC. I expressly asked the first claimant about this in cross-examination using the precise names of the company. Does Health Insights FZ LLC own MCC? Answer, no. Does Health Insights for Software Design own MCC? Answer, yes. So he's expressly said in his cross-examination in this case, Health Insights Egypt owns MCC, not Health Insights Dubai. And the path taken by the claimants on this point is genuinely baffling. And the correspondence over the weekend, we say, is just one further addition, which continues that slightly absurd course. So the communication, it's from solicitors in Malaysia. They say they're acting for Health Insights Egypt. It appears to have been sent as a consequence of matters disclosed to the court during the course of these proceedings, and in particular questions that were asked of Mr. Shehata during cross-examination about the identities of a number of businesses who've then clearly been contacted. And what the letter is a demand to cease and desist from the unauthorized use of software. This comes 2 days before the claimants are closing their case, in which I remind Your Honour they're asking you to positively find that MCC is owned by Health Insights Dubai. And what's said in this letter is that Health Insights Egypt, quote, holds the intellectual property rights and exclusive financial exploitation rights to the software Medica Cloud Care, as paragraph 3.1. Paragraph 4, in view of the above, the company has reason to believe that your organisation is operating the software without valid authorization issued by the company. Please note that any use, installation, operation of the said software without the company's authorization constitutes unlawful use and amounts to infringement of the company's intellectual property rights. And one of the questions John was pondering last week as well, I don't have the evidence on ownership. Is this an issue I can just come to and decide at a later stage of proceedings? But given how little conviction the claimants appear to have in their own case, for a letter like this to be sent 2 days before they close it, it's difficult to see in my submission why the claimants should be permitted to waste more of the court's time on this issue. They clearly don't believe the position they're advancing in these proceedings. They've repeatedly contradicted it elsewhere. There's also another point buried in this, which I'm going to come back to, which is one of the answers proffered to the unfair prejudice petition is to say, well, a company doesn't have some kind of proprietary right to demand that companies keep contracting with them. There are a whole number of levels in which that's wrong, which I'm going to come to. But really one of the key points is set out in this letter itself, which is if you're the owner of a piece of IP and an end user wishes to use that IP or that software program, of course, they have to have a license to do it. And that license has to derive from some kind of license or right to distribute the product. You can't just say, well, I'm not going to pay you for this product, I'm going to pay someone else. It's contingent on who owns the license to distribute. And really, that's the whole point about diversion of business away from Health Insights Dubai and why it's improper and why it's unfairly prejudicial. And so that's why we say the letter is relevant for Your Honour's consideration, because it's just so fundamentally against the tenor of what this claim is being pursued on the basis of by the claimants. And that's what I have to say. The claimant shouldn't be permitted to waste any more of the court's time than is necessary on this. Beyond the contradictions, Your Honour, if I could just come back to the series of what we say are other fundamental problems with the claim. And the first is, we say, the failure to properly plead a position on ownership, which isn't trivial and has introduced substantial prejudice into these proceedings. In effect, what we're saying is the claimants are now seeking to impermissibly advance a case on the development of MCC, which they've never pleaded and they've never properly prosecuted. And we would invite Your Honour to dismiss it on that basis alone. And just to contextualise this, the first time an assertion of a collective work appeared in these proceedings was in the claimant's skeleton argument. It's nowhere in the pleaded case. It's not even obliquely referred to in the evidence. And that's an important point for two reasons. One, first, obviously, the claimant's ability to succeed in its case is contingent on it being properly pleaded in the first place. I'll go through the pleading requirements on that. But the second is a related evidential issue, which is the way in which a case is framed and pleaded obviously has a material effect on the court's ability to dispose of it properly, because it informs all of the subsequent steps that a court takes in determining a claim, dealing with evidence, what type of evidence is needed, and so on. So addressing those points in turn, so I think that's someone needs to mute there. Anyway, dealing with the pleading point first. The case advanced in closing is that MCC is developed by the combined efforts of employees of Health Insights Egypt and Al Khalij. It's said that that work is carried out for the benefit of Health Insights Dubai, and therefore the rights to MCC vest in Health Insights Dubai. And that's based on the operation of the legislative provisions that we went through last week. When you actually then work backwards through the evolution of the claimant's case, you can see that that doesn't bear much, if any, resemblance to how the case was initially put. So even now, in closing, we obviously make the point that the claimants haven't been specific about what law they say applies to create this outcome that they assert. There are three sets of legislative provisions, but Your Honour isn't told which is relevant. Beyond that, the suggestion that MCC was, as a matter of fact, developed by the combined efforts of employees of Al Khalij and Health Insights Egypt, that hasn't emerged until closing. So the claimant's skeleton argument for trial asserted that MCC was developed by employees of Health Insights Egypt at Health Insights Dubai's direction. Al Khalij wasn't a part of the picture at that stage. Clearly that emerged during the course of cross-examination of the claimant's witnesses, because when any scrutiny was put to the suggestion that this piece of IP was created in Saudi Arabia, it emerged that Health Insights Egypt didn't have employees in Saudi Arabia, and so they must have been employed by Al Khalij. So that's forced a transition in the claimant's case. But if you go back even further, it wasn't actually even until the reply witness statements that the suggestion was made that MCC was developed by the employees of Health Insights Egypt. And so that's the first time that a case like that was positively advanced, because prior to that, in their initial witness statements, both claimants simply asserted that there was that MCC was created by a team of programmers at, quote, Health Insights, end quote. So no one had specified that this is created by Health Insights Egypt. The assertion is it's created by Health Insights. The claimants didn't wish to put their cards on the table as to what exactly it was they meant by that. And there certainly wasn't a positive case of development by employees of Health Insights Egypt. And then prior to the reply evidence and prior to the witness statements which made the bare assertion of involvement of programmers at Health Insights, there just wasn't a positive case about how MCC was developed at all. There was no positive case advanced as to how it was that Health Insights Dubai acquired ownership. And for example, when the claimants applied for the production of documents in these proceedings, one of the assertions made in that document was, and I quote, pending disclosure, the claimants do not know whether D1 is the genuine author of the MCC software. So in other words, we've gone from the suggestion, well, the claimants just don't know how this was developed. You've got to show that Mr. Shehata was the author because we just would have no idea. We've gone from that proposition to now offering a pretty extensive and detailed positive case on the issue. And the position as it was put back then, pending disclosure we don't know, obviously contradicts what's now the primary case, which is Mr. Shehata didn't have anything to do with the development. It was all carried out initially by a team in Saudi Arabia and then by employees of Health Insights Egypt. Mr. Shehata knew nothing about it. That is respectfully a remarkable evolution.
I'm so that's just not my case. I mean, Your Honour's got the point, but it's just extraordinary.
Well, I don't particularly welcome the interruption. I'll go to the point of your closing submissions where you say that Mr. Shehata wasn't involved in the development, but we'll come to that. But just dealing with this for the time being as a pleading point, the claimants have known from the outset what they were going. Well, they also have known from the outset what they were going to have to prove in terms of ownership. They can't say they thought it was uncontroversial when they pleaded, because the contested ownership of MCC was integral to the first set of applications that came before Your Honour in this court, which is when this was a Part 8 claim, in which it was asserted there are no disputes of fact, and the decision was made that this aspect of the case should proceed on the Part 7 basis. But if we can pull up, for example, F2 at page 12, scroll down to paragraph 58 and 59, please. This is the decision that was made on the application that this should be a Part 7 case. What we can see here, paragraph 58, the claimant's case is premised on the following factual assertions. Mr. Shehata moved a substantial part, if not all, of the business to a company owned by him. 59, the defendants deny these assertions, and the court's going to have to resolve some disputes, including point 2. The rights to medical cloud care have never been owned by Health Insights. Health Insights Dubai was not the author of medical cloud care. And if we go to page 16 at paragraph 85, scroll down please to 85, thank you. And this is part of the rationale as to why it should continue as Part 7 claim. It says the taking of account will require determination of facts, in particular be necessary to determine the ownership of medical cloud care. What, if any, interest Health Insights Dubai had in medical cloud care and the intellectual property rights assigned or purported to be assigned under the agreement. So it's been known since the outset that one of the issues is going to be how, in the first instance, Health Insights Dubai acquired the IP rights. And that was known before the claimants put pen to paper on their particulars claim. The new ownership and authorship was contested. And so in pleading that, particularly where they're relying on an issue of law, and an operation of law to give rise to ownership, that had to be set out. And it's in that context we say the pleadings are non-compliant with the court's rules. You've got to actually specify the facts on which you rely, and the relevant facts here would have been not just the assertion.
Mr. Doherty, may I draw your attention to you went to paragraph 85, you left out the last sentence, which said that may turn out to be inconsistent with facts found in taking the account. It may be a matter you're going to address later, but it's a point that I've raised before. My both at the time I addressed that issue and later when I raised the question of bifurcating the trial, it was at least a matter in question whether the question of ownership of or rights to Medicare Cloud Care would be determined on the taking of the account rather than the trial for whether an account should be ordered. I'll just draw that to your attention.
Yes, Your Honour. So bear with me. If we can look up that the taking of the account was one of the areas in which Your Honour concluded that this was going to be a factual dispute, but it was also in the substance of the case itself. So, for example, if you scroll up to page 15.
Yes.
And to paragraph 73. Where we talk about the same point of ownership being an issue in the context of not only the taking of the account, but also the merits and the resolution of the substantive issues of the dispute. So I've shown you one extract to give a flavour of what was required, but it's not just on the account side, it's also on the substance. And so what we say they had to plead was not only a bare assertion of ownership, but the reason it was owned. So the reason being Health Insights Dubai's first ownership of the copyright in the software, and that it became the first owner because, as a matter of fact, it directed the creation of MCC. And beyond that, the facts giving rise to that ownership are that it directed the creation of MCC by directing development work carried out by individual contributors. You know, those are the facts that would have sustained this cause of action or this issue, and a compliant pleading should have set all of that out. The second point is that where you have a case that's premised expressly on the operation of statutory provisions, you have to specifically plead that. And that's true both of matters of DIFC law and foreign law. So RDC 17.44 says that any legislative provision on which an allegation is based must clearly be identified and the basis of its application explained. And when it comes to principles of foreign law, RDC 17.45 says any principle of foreign law or legislative provision in which a party's case is based must be clearly identified and the basis of its application explained. So in this instance, if what's said is that ownership of MCC is based on the application of non-DIFC law, whether it's UAE federal law or Egyptian law, there was a mandatory obligation to identify those provisions and then to explain their application to this case. So what would have been required here, given that the default position under the copyright law is that a legal entity can't be the author of the copyright and only natural persons can, for Health Insights Dubai as a company to acquire ownership in that scenario, you'd have to show one of two things. One, that there's been some assignment of IP rights, which complied with the terms for assignments under the copyright law, so that's Article 9. Or two, this is one of those exceptional cases where the effective Article 26 leads to the vesting of the IP rights of the first ownership rights in a legal entity, irrespective of who the natural persons were who contributed to the work. And if it was one of those two routes, the route that it actually was needed to be set out and explained. And the pleadings don't do that. So the relevant pleading is at B3, page 3. And scroll up to paragraph 13. We see that all that's said is that all material time the second defendant owned the IP in MCC. It's a cloud-based system. And that's it. It's a bare assertion. No reference to the rights being created or operation of law. And we pointed that out in the defence and counterclaim. For your references, it's paragraph 22 of the defence and counterclaim. Subparagraph B, we say the claimants have asserted no positive pleading as to the ownership of MCC or associated rights by the second defendant, or how it is said that the second defendant came to acquire such rights. And so the claimants had the opportunity and were put on notice that they hadn't advanced a positive case in the reply and defence to counterclaim. Again, they declined to take that opportunity. So this is a B5, please, page 4. Subparagraph 3 just says it's not admitted that the first defendant was the author. It's denied that the first defendant was the sole owner of the MCC rights. But that's just a denial of Mr. Shehata's case. It's not advancing any positive case. And perhaps that's consistent with what the claimant's position was back then, which is, well, we just don't know if Mr. Shehata was the author or not. We need disclosure in order to determine that. But that's not the position that the claimants come to this court at trial. They come to this court at trial with the positive case as to how MCC was developed, which was introduced in reply witness evidence, and which they say that Mr. Shehata was not involved in that process. And what we say the conclusion Your Honour should draw from this is that the claimant's case on ownership, which is said to have vested as a consequence of the development process, was first advanced on the 17th of September 2025. That's the first time the legal basis was actually almost specified in the 3 sets of laws, but at least by then there was some understanding of how the case was being framed. And we say the court shouldn't entertain a claim like this being advanced for the first time of trial. And the reason is it's not just an issue of form. It's an issue that gives rise to substantive prejudice. And really, this is the evidential issue, the second point that I referred Your Honour to. The function of a proper pleading, of course, is so that a party understands the case it's being asked to meet. Because you can't identify and produce relevant documentary evidence or tender relevant factual witnesses or provide expert evidence on issues that are required unless the case has been properly pleaded. What failure to plead your case does is present the party facing the allegation. It denies them the opportunity to actually investigate and respond to the allegation properly, to furnish the court with relevant evidence in connection with the allegation, and so on. And what that means is that the court ends up in a scenario, which we say Your Honour is in, where you just haven't been provided by the claimants with the evidence you require to make a decision on the case that they're now advancing. And if the case had been pleaded as being about development, it would have progressed in a radically different form. As I said before, IP rights could accrue to a company in a number of ways. If this was a case where it was asserted that there was an assignment, obviously the nature of the factual investigation the court would undertake is different, because what you'd be looking for is a contract and whether that contract complied with the requirements of the law. That's one thing. It might also be a case advanced that IP is developed by a particular individual who contractually had committed to assigning a piece of IP for the work they'd carried out to a company. And again, if that was the case that was being advanced, you could look at the contract, you could make that determination. This case, as now advanced, is a different species altogether, because what is being put to you is that the process through which the software was written and its code was created means that by operation of law, first ownership rights vest in a company. And we say that that's not just an issue which would require the court to interpret the effect of a legal document. It's a highly fact-sensitive and complex factual investigation that would need to be undertaken. So what one would actually need to look at is complex and highly technical evidence around how the software was coded, when the code was written, who wrote the code, by whom and for whom and at whose direction, and so on. And Your Honour is in effect now being asked to determine those issues without, amongst other things, the benefit of expert evidence of a technical nature, and also without the claimants having produced so much as a single line of code. And that's just on the factual side. The claimants are also inviting the court to consider complex issues arising in a specialist area of non-DIFC law, also without the benefit of expert evidence. So this isn't the question of intellectual property ownership, where it's advanced 3 different iterations of how it might have arisen without being able to explain precisely to the court which framework applies. And my learned friend said on Friday, well, we have direct evidence from the people who did it, but that's incorrect. We don't, or at least not in any agreed form. It's disputed that the 4 additional witnesses developed MCC. The defendant's positions of work they did was on implementation of the system. But the key problem is that we don't have any evidence of the work that those individuals have actually done. You can say on the one hand, I sat down at my computer and I did this, but ultimately the evidence of what you did and whether it's the same thing as creating IP or something else, to determine that, you've got to actually look at and be able to interrogate the work product itself. We don't have evidence of a technical nature provided by any of those witnesses. And no doubt those individuals will say they were doing work of some kind, but whether it's system implementation or whether it's development, in order to resolve that factual dispute, what the court needed was the actual work that they did and whether it involved coding the MCC software. But we don't have code written by these witnesses. We don't actually have the underlying work materials that they say they produced. And just to read back some of the criticisms that were made by my learned friend last Friday in an attempt to answer the evidence produced by Mr. Shehata when it came to the development of MCC. So that's the 2014 demo. What was suggested is said that because Mr. Shehata produced it, it shows he developed it, he must have written this. That's pure assertion. It's just because he's got access to it, it doesn't mean he did it. We would have to take his word from him on that as well. It's unsupported by anything else. He didn't give us the files. He produced a video of them. He didn't produce any files. Ultimately, there is nothing behind Mr. Shehata's word for it to support the position that he wrote, authored, and owns MCC. I don't see why that's the position that the claimants take on Mr. Shehata's evidence without any self-reflection about the way that they presented their own case, particularly that it is their case that they are advancing in which they bear the burden of proving. At least Mr. Shehata has shown us in the week that was afforded to him to produce this evidence, he's shown us the actual folder, which did contain the work product and a working demo of MCC. We got nothing from the claimants. And the claimants just want you to skirt over that. Their assertion is fine as long as it's coming from them. But the really critical point, the substantive prejudice, is because if the claimants had actually pleaded this case at the outset, this case could have been advanced in a way that allowed the issues to be properly explored. For example, what one would have obviously expected in a case like this is that there would have been consideration at the CMC stage to what forms of technical documentary evidence needed to be provided. There would have had to have been consideration of what was actually outside the court's expertise and whether that needed the introduction of technical experts in order to explain, for example, looking at lines of code when they were written, interrogating some of the metadata behind that. All of that could have been considered if this was the way the case was advanced. But more specifically than that even, there would have been the opportunity at the document production phase for the defendant to request the production of relevant materials that it could have interrogated. So, for example, if the claimants had been upfront about their case that MCC was developed by Health Insights Egypt and Al-Khalij, production could have been requested in respect to the technical documents that were held. So when it comes to the progress spreadsheets, which really the claimant's case seems to hinge on. So these are the 40-odd progress spreadsheets that were disclosed to the court the Saturday before trial started. If those had been pleaded as being relevant, or if it had been known that there was some issue concerning the development of MCC, obviously what would have been requested is not only those spreadsheets which spanned a grand total of 2 days progress of what was said to be a 2-year process of development carried out by up to 100 employees of both Health Insights Egypt and Al Khalij. The documents would have been requested that lay under those progress spreadsheets. So if what they're supposed to say is, well, here was a conversion process from one form of software to another form of software, and that's what is indicated by these tick boxes. I mean, we say that's wrong, but I'll come to that. But even if you take that case as asserted, obviously, if this case was going to be about the technical development of MCC, what would have been requested is the work product that sits under that. So you say you were converting this to MCC. We say this was a Medica Plus project and it's an implementation project. Show us what the work is. Show us what work you say went into the development of MCC so we can properly interrogate that and we can challenge it. But none of those documents were disclosed. The spreadsheets themselves, as I say, they came the Saturday before the trial. And if this is what the claimants say is the critical piece of evidence in their case, that entirely, I think as it was put, destroyed Mr. Shehata's evidence on this. It doesn't show us anything. It had to be properly interrogated. And if this case had been litigated properly in the way that the issues are now advanced, Your Honour would have had the benefit of documents concerning development over this 2-year process because we would have requested it. The intricacies of those documents would have been interrogated because we say that if you'd looked at the detail of it, they almost certainly would show themselves as having nothing to do with the creation of MCC. But what we have is this technical case advanced in this woefully inadequate way. And what we say is that it's materially, well, it's two things. One, it's materially deprived the defendants of any fair opportunity to defend it, but it's also prevented the court from having any proper opportunity to decide it. And the purpose of a proper pleading is to stop the introduction of these sorts of issues late in the day, 11th hour introduction of a highly technical issue, which the defendants are given a week to respond to, in which the claimants then say, well, why didn't you provide documents in response to this case earlier? Well, the simple answer to that, which is it was never advanced. So on that basis, we say that the court should not entertain the claimant's late case on ownership. We say that that is highly prejudicial in the way that it has been advanced and it has prevented the court from having the evidence that it needs. And that feeds into the next issue, which I want to address, Your Honour, on, which is the consequence of the way these issues are being introduced, being that Your Honour just doesn't have anywhere near sufficient evidence to make the finding that the claimants invite you to. As I say, this issue of ownership falls to be resolved as part of the claimant's case, not the defendant's. It's their burden of proof. They ask you to positively find that MCC is owned by Health Insights Dubai, that Health Insights Dubai is the owner because it directed the creation of a collective work, and that Mr. Shehata therefore impermissibly sought to sell its rights at an undervalue. The state of the factual evidence provided is, we say, so unsatisfactory that even if everything the claimants assert by that evidence is taken as true, Your Honour simply can't make the finding you've been asked to. And what we also say is that given that Mr. Shehata was given, in effect, a week to respond to a new case that was put, that he has in that short space of time provided a clear narrative of how MCC was developed and when it was developed, but also evidence which just completely undercuts everything that the claimants have said about it. And if Your Honour is not satisfied on the balance of probabilities that MCC is owned by Health Insights Dubai, that's really as far as you need to go on the question of ownership in this case. And that is a decision that you should take now and not subsequently. So I'm going to deal with this in 3 points. I'm going to look at the documentary evidence. I'm going to ask you I'm going to deal with the claimant's approach to plugging what are the obvious gaps in its evidence, and then I'm also going to address you briefly on the evidence that Mr. Shehata has provided. So looking at the case on the facts put by the claimants, we say it is pretty remarkable that they haven't provided any technical evidence of development. When you actually look at the totality of what's there and what's introduced by the 4 new witness statements, and what my learned friend said on Friday demolished the narrative put forward by Mr. Shehata. Well, Mr. Al-Shinawi's witness statement refers to some WhatsApp messages from January 2022. Mr. Al-Shami refers to some same sets of messages. Mr. Bashir refers to some WhatsApp messages from December 21 and January 22. And Ms. Hagee refers to a small handful of WhatsApp messages from August 2019 to 2021. None of that is relevant evidence in connection with the process of how MCC was developed. The claimants seem to suggest that Your Honour should be swayed on a highly technical argument they're running, but by what are effectively oblique references to modules or oblique references to source code contained in those WhatsApp messages many years after the claimant's own case is that the software was actually developed. The claimant's positive case, and the reason they say that their narrative around the development of MCC is the correct one, is that they say, well, we've provided evidence from fact witnesses who were involved in the actual development of MCC, and you're invited to conclude that that's significant. If that analysis is correct, and that's genuinely the case, Your Honour can quite rightly ask, well, where are the modules that they developed? Where is the source code for any of that? Why have the claimants provided copies of communications that they say refer to development work going on in the background instead of actually producing the work product itself in its native form so that you can actually look at it, see what it is, look at its metadata, see what it says about who developed it and when. So on the claimant's own case, with the process of development they say took place in 2016 or 2017, it's difficult to see what a tiny number of communications sent 5 years after that process say about the development work that took place. How that's helpful or relevant is really very unclear. And the points that the claimants make about this is in paragraph 182 of their written closings. I'm not going to go to it now, but I would invite Your Honour to read it, because when you read it, you can see that actually there's very little to be gleaned from any of this, and that the case on a highly technical factual issue is really extremely flimsy indeed. And when you remove that from the equation, what you're looking at is being, in effect, the totality of the claimant's documentary evidence and witness evidence. What we have is, in effect, bare assertions made by witnesses. And the point that seems to be repeatedly taken is that the evidence of these 4 witnesses was barely challenged. We don't accept that. That's not correct. If you actually go to witness statements, they say very little indeed. The aspects of what are actually dealt with in the evidence were challenged in cross-examination, but they didn't say anything. I mean, a lot of the evidence that was introduced was either introduced as something brand new said for the first time under cross, or in many cases, and you can go through my learned friend's written closings to look at this, most of the evidence of a technical nature is referred to in answer to re-examination. That's not the way to conduct a technical case like this. If you're going to rely on technical details, you put it in the witness statement. The scant detail that was put in the witness statement was cross-examined on, but the fault lies in not including the detail in the witness statement, not the fact that I didn't cross-examine on a case that wasn't actually dealt with by any of those witnesses. And when one then tries to think about, well, what do we do about these witness statements? like we say, absent documentary evidence, what you've effectively got is bare assertion. And we make many observations about the quality of the evidence that's before Your Honour in written closings, but in truth, this isn't even really a credibility issue. It's a matter of the witness evidence taking at its highest, just being completely insufficient for the court to determine anything meaningful about how MCC was developed. So fundamentally, what the copyright law seeks to protect, as I dealt with last week, Your Honour, is source code, object code that's written in respect of a software program. And the witnesses might say, well, I developed several modules within the MCC system, like Q system, but they don't give us any insight into the technical details of that work or the code that it produced, which is ultimately what the protectable IP would be. And that's what we would need to look at in order to determine whether that assertion is true or not. And the closest the claimants seem to get, and which they place a really significant amount of weight on, are these set of spreadsheets, which were at E83.1 of the bundle. So that was a covering email which included a number of individuals, and then the progress monitoring spreadsheets that sat below that. So those came into the case, like I said, 2 days before the trial opened. When you look at the spreadsheets and you actually consider what they show, they say next to nothing relevant about the development of MCC. So first, what the spreadsheets profess to do on their face is to track the progress of some project. And if you look at the dates of the progress on there, what you have is an email chain that runs from between the 18th to the 22nd of December. But you then have two spreadsheets buried within there, which show effectively the consolidated progress that's been made on whatever this project is. And the dates of those consolidated spreadsheets are the 21st of December 2016 and the 23rd of December 2016. So in respect of this project, which is said to be the development of a new piece of software, or the conversion, as it's put, of this piece of software, which the witnesses say took place over the course of 2 years with 100-odd developers over that time. What Your Honour is being presented with is a snapshot of something. It's not exactly clear what, over the course of 2 days. So that's the first point we make, is that we're looking at a minute amount of evidence. The second point is it's quite difficult to tell who's actually involved in the work. If you look at the covering emails, what you'll see is addresses from Health Insights, some addresses from Al-Khalij, and also addresses from some individuals who appear to be freelance consultants and whose email signatures link to their own website. The third is, if you look at the documents on the face of it, what they say is that they're part of a Medica Plus multi-tenancy single instance project. And so taken in face value, we say that about all Your Honour is able to do with these documents is to find that they are what they say, which is it relates to the development of Medica Plus and a single instance project, not to MCC. The fourth is really addressing the point that the claimants try to convey during evidence, which is that these spreadsheets show a progression from an old system to a new system, and that the intention was that you would tick boxes as you converted one old type of code to a new type. So that was the suggested progression from VB6 through to HTML5. And when we say that that assertion is actually just unfounded, there's nothing in the documentation which suggests that's the case. So in the 2 days where we're actually able to compare entries, you can actually see that there are items which move from being pending in one column to being done between the 21st and 23rd without there being any change in the tick box. So something that starts as HTML5 finishes as HTML5. And the references to that, just so I can give them for your honour, because you might want to spend some time looking at these spreadsheets, but it's E.83 19, page 17, and then E.83.20, page 17. For the most, that's one of the rare examples of where there's actually a change. For the most part, the progress, understandably, from pending to done is limited because we've only got 2 days. And what one can also see is that many of the pending boxes begin ticked with HTML5. So this isn't some conversion process by changing from VB6 to another form of code. It's unclear at best what those tick boxes are meant to mean. So what the spreadsheets actually tell us is next to nothing. What might have been useful to the court is, instead of the spreadsheets, which the claimants clearly have possession of, if they disclosed what they say was the underlying work done. And if what they're saying is this is a progression of taking old source code and writing new source code in a different form, they haven't produced any of the source code. That might have helped, assisted by experts, but we don't have it. And what the claimants might also have disclosed, instead of a handful of WhatsApp messages from 5 years down the line, is some of the broader context around what this project was, what it related to, and critically, for the consideration of this case, who directed the project. And we say that when you look at this, it falls miles short of where it needs to be. And what that leaves the claimants in is in this position, this is the second point in the evidence, where they're effectively trying to plug these enormous gaps in the evidential record by their assertion and evidence. But we say that that approach on the case as it's now advanced is nonsensical. So this is a point which is laboured throughout the closing. It's summarised in paragraph 13 of the claimant's closing document. But what they repeatedly seek to do is to criticise Mr. Shehata for the way that he's provided evidence in respect of the development of MCC. And we say that that's a pretty confusing proposition in a couple of respects. One is the obvious point, which is until they filed their reply witness statements, the claimants never advanced a positive case on this issue, that ownership was dependent on the process through which development took place. The fact that Mr. Shehata introduced this evidence with a statement in reply to that is because up to that point in time, of course, he was responding to the case that was actually advanced. And it's difficult to see why he can be criticised for replying to evidence which he was given permission by the court to reply to over the space of a week. So we take serious issue with what's asserted in paragraph 13 of the written closing submissions. And I'll come on to the state of the defendant, the claimant's own approach to their disclosure obligations in due course when I deal with the counterclaim. But the first point really is that the state of the evidence is actually just a direct consequence of the claimant's failure that I've already addressed to properly plead and advance their own case. But the second and probably more significant point is that the assertion that's made at paragraph 13, which blames Mr. Shehata for the lack of contemporaneous documents, actually just doesn't make sense in light of the way that the case is now put. So I referred, Your Honour, earlier to what was set out in the document production requests, which is the claimants asserting that, well, we don't have any knowledge of how MCC was developed pending disclosure. And during opening, a similar line was put out there by my learned friend that part of the problem with the claimant's case is that Mr. Shehata controlled the company and he did things behind closed doors. But that submission is just inconsistent with how the claimants are now putting their case. The position actually advanced by the claimants at trial is that Mr. Shehata couldn't have developed MCC on his own. And in fact, they do go further and say that Mr. Shehata didn't have anything to do with the development of MCC. And this is the point I said I'd come back to earlier, Your Honour. It's paragraph 178 of the claimant's closing. And what's said is the documentary evidence demonstrates that D1's case that he single-handedly developed MCC is inherently implausible. In addition to being inherently implausible, it's a brazen lie. Quote, far from developing MCC on his own, D1 was not even involved in the development of MCC. MCC was developed by developers employed by Health Insights Egypt and Al-Khalij. So it is the claimant's case, now advanced in closing, that Mr. Shehata didn't have anything to do with this. And if that's their case, one wouldn't expect Mr. Shehata to have the documents, because development wasn't in his hands, as far as they're concerned, even Germany. The positive case now is that the development of MCC started in Saudi Arabia. That's its origins. It was worked on by developers from Al-Khalij and then subsequently Health Insights Egypt. That work on the claimant's case, based on the spreadsheets, was directed either by this individual engineer Farhan, or, as was suggested by one of the witnesses during cross-examination, another individual, Mohammed Mustafa. Both of those individuals were employed by Al-Khalij and not employed by Health Insights Dubai. So on the claimant's analysis, this work, which was done by 100-odd individuals and was coordinated by these employees, apparently of Al-Khalij, if that is the case that is being run, how can the claimants possibly say that it's Mr. Shehata who possesses the relevant documentary evidence, and that the reason that there's so little before the court is it's all his fault? On their own case, the documents must reside, at the very least, with Al-Khalij. And if what the claimants assert as being the process of development and closing is correct, the party responsible for any strategy of depriving the court of relevant technical evidence is the claimants, not Mr. Shehata. So they can't, on the case they're advancing, have any cause for complaint about the state of the documents. Because if their own factual case was true, they would have them. And the fact that they haven't put forward a positive technical case, and the fact that they haven't provided this evidence, we say speaks volumes. And so, one, they haven't provided the technical evidence. Two, they can't seek to plug that gap by inference in the way that they, in the light of how they advance their case. And the third point we make on the evidence is that the contemporaneous material contradicts the claimant's case. So I'll give Your Honour one example of that. So we go to E139, page 1. If we scroll down, this is a series of documents which have been put before the court, which are contained within the entirety of this file. If you go to the middle of the page, but in effect, what this document is dealing with is the replacement of the old version of Medica Plus with MCC, and this run of documents shows this process through which end users are undergoing this conversion from Medica Plus to Medica Cloud Care is taking place between 2019 and 2020. That's when Al-Khalij start this implementation process. And what this suggests, we say, is that the conversion process that the claimants are describing to you is not something which is taking place from 2016 through to 2018. It's implausible that there would be this mad rush this frenzied rush to convert Medica Plus between 2016 and 2017, and then you've got a 3-year gap before it's actually being implemented commercially. The reality, we say, is that prior to 2019, what Al-Khalij was interested in was continuing to generate revenues from Medica Plus. That's what they did, as a matter of fact. And it's only subsequently, once the system has already been developed, that they show any real interest in actually converting the system and converting end users over. And so this contemporaneous evidence does not support the theory put forward by the claimants. And then, of course, there's the defendant's evidence, which we say, by contrast to what has been put forward by the claimants, actually provides Your Honour with some technical insight into how this new piece of software was in reality created. And I'm not going to go through all of this. There's plainly a fundamental disagreement about what MCC is. The defendant's case is that it is the architecture of the system itself, is that it's a customizable piece of software. It's something that can be built to be adapted to the needs of different healthcare facilities. And the customization is an integral part of the system itself. And that's the evidence that Your Honour has on the tools.
You've told me that the software consists of the source code.
Yes.
Now, it seemed to be what you were saying there seemed to be a little different from that.
No, so the way that on the defendant's case, the way the system works is that you have the core components of a system that allow you to build functionality without writing source code. So the system itself is inherently customizable. That's in effect the USP. That's the whole point of it. You can take this system and then you can tailor it to fit the needs of an end customer. And the way you do that is using the tools of the system. So things like Dynadocs or Dynax, as it's sometimes called, and rules at work. So that allows you to build functionality in a way that is visual, and in the sense that it involves any sort of further technical input behind that. It's not something which requires you to go back to square one every time you want to create something. So you're not having to go consistently back to writing source code anytime you want to make a change to the system.
But I did have evidence that, I've forgotten which witnesses said this, but when they were developing modules, they were writing source code and they weren't using Dynadocs or rules at work. They were writing source code using the tools, but not Dynadocs or rules at work.
Yeah,
they were just writing it in programming language.
Yeah, well, the first point is that to the extent that's said, it's bare assertion. We don't have any evidence of that. If they say they were writing source code and that became protectable IP, they've got to provide the source code so that that can be challenged. But the second point is that it's not to say that the work performed in implementation isn't in some way technical in nature. There is, of course, in the implementation process, some need to have a level of technical skill, whether that's to embed rules of logic, which are important in making sure that the system is integrated and that the different bits of the system speak to one another. That can be technical work, but what you're not doing is designing the underlying system that functionality is built on. That's the distinction.
It's not your case, is it, that Medicare Cloud Care consists of rules at work and Dynadocs? That's not your case, is it?
No, those are examples of what we say are part of the core components of the system, but it's not all of it. No, that's not our case. The point is that
the system's got to include the platform on which all of the modules operate, doesn't it?
Yes. Well, there's obviously the platform. There are obviously the different core components that one can see, for example, on the home screen, and that link across towards one another. And if you want to build out functionality of that, you can, but you build out that functionality from the core of the system. So, for example, and I'll come to this in a second, we say that one can see the origins of that core part of the system already when we've got the introduction of coding that was on the evidence written before the middle of 2012, but also this demo that was produced in 2014, which I'm going to come on to. But the point is that there is a distinction to be made between the technical work that is involved in building the system in the first instance, and then the technical involvement in, I suppose what you might say is implementing the system to meet the needs of end customers. So it might well be that there are tweaks to bits of coding that go into an end customer's, whatever the way they want their screen to be configured. But for the most part, it's actually visual and it's built out using tools. And the logic is pre-existing logic as part of rules of work, and that's what makes the system communicate. But that's the point
Mr.
about what the
Doherty,
system is.
you've made extensive submissions to the effect that the evidence doesn't permit me to make a finding that H.I. Dubai developed or owned the MCC software. Do you put a positive case? Do you say that I'm able to find that Mr. Shehata did? And aren't all of the submissions you've made equally apply to considering whether Mr. Shehata wrote the software?
No, so the case that is before you is, did Health Insights Dubai own MCC through the process of its development? In
So
order
you're
for
not
us to
putting-
defend,
You're not
Correct.
putting the case that Mr. Shehata developed it.
yes, I
Or
mean
not-
that
and
is
you're not calling upon the court to make a finding that Mr. Shehata developed as the original creator of Medicare Cloud Care, or are you?
correct, because if that was sorry, when I say correct, I mean the former proposition. It's not integral to
Right.
our counterclaim for you to make a positive finding on who
Right.
developed this. And I mean, really, that's
Okay.
it's probably not the function of the DIFC court anyway. There would be another court who would be more likely vested with jurisdiction to deal with that sort of issue. What we say is that where you need to get to is that you're not satisfied that Health Insights Dubai directed its development, and once you've reached that conclusion, you don't need to go any further.
Okay.
And if we were advancing a positive case that we need to prove that Mr. Shehata developed it, then obviously the case similarly would have been presented differently, because it would have had to get into the technical ins and outs. But the technical elements that Mr. Shehata is dealing with only arise as a consequence of the way the claimants put their case.
Okay.
And really the critical point, which we say that the claimants just don't have an answer to, is the issue around timing. So the first claimant says MCC was developed by Health Insights in 2017. That was his witness statement. The second claimant said it started in Saudi Arabia in 2016. Mr. El-Shanawi says it's between 2016 and 2018. Mr. El-Shami says it's between 2016 and 2017. Mr. Bashir says that it was developed in the hiatus of his employment, so from when he left in 2015 through to coming back in December 2017. And Ms. Heggie says that she learned development started in 2016. And of course, the progress spreadsheets are from December 2016. And what none of that can answer is why there is this working web-based demo in 2014. That's the file at I-16, which I would invite Your Honour to revisit in the process of determining this case. But
And
one can see...
Does that prove? What does that prove, that demo video?
What it shows is that you have, and we looked at some of the files that were part of this. And what one can see is the date modified means the last date on which something is modified means it was created on or before that date. And when you go into that, what you can see is that there are files containing source code written in C#, which is the programming language that MCC is written in, and that those files go back to mid-2012. And then you've got the demo file, the working web demo itself in 2014. And what we say is that it's objective, contemporaneous evidence of work going into the development of a web-based, cloud-based medical record system, which predates by years the claimant's earliest date for saying that they started work on MCC. So they say that the earliest point in time when the work originated, when the idea was come up with, was in 2016. But you can see that some of this code is being produced in 2012. And, you know, it seems to be that a point is taken, well, you know, this was a prototype. And, well, of course, in the development of any complex system, you're going to have iterations of it. The point isn't whether it's a prototype or not. The point is that 4 years before the earliest time the claimants say this work started, there was clearly work being undertaken and work being done and a system which was cloud-based being developed. And there's just no answer to that. And what we say is that that evidence is consistent with what Mr. Shehata says about development, which is that it took place 4 years, it started to take place 4 years prior to the window identified by the claimants. And we also say that it brings to the fore the consistencies between the work that was being carried out in that window of time, so 2012 through to 2016, and some of the documents that subsequently end up being created, such as the licensing agreement in November 2015, which say that Mr. Shehata was the author and owner of MCC, and in which a license is granted to Health Insights Malaysia, and then subsequently the partner reseller certification from August 2017. So, well, bringing that point together, as we invite Your Honour on the issue to say that the claimants claim that MCC was developed for the benefit and owned by Health Insights Dubai is just not made out, and the facts are at law, and that's where you need to go to. And then if I can deal with how that interacts with some of the specific points made on the claim. So dealing with the purchase order, and I'll go through this giving you the points that we make. First is, when it comes to the authenticity of the purchase order documents, there's no genuine reason to question that. First of all, the documents were voluntarily disclosed, and the claimants seek to draw out what they call are inconsistencies in the documents, what they're intended to do, the fact that they don't make sense. But we would make the point that the very fact that documents are imperfect, and in some instances raise questions as well as answers, is something which strongly points away from this document being some fabrication or invention or forgery created for the purposes of litigation. Because if you're going to go to the effect, if you're going to go to the effort of forging a document, you'd probably craft something that was more neat and more helpful and actually more clearly was directed at your case. And it's also something you would have expected to be put front and center of the case, as opposed to, as it was, being slipped in amongst, I think it was 80-odd pages of invoices and purchase orders, with the claimant's first witness statement. We say that it is not plausible that if you were going to pen some forgery, you would have done it in this way, particularly when you look at the fact that there are other versions of the document in the bundle, for example, which aren't countersigned. And again, one would ask, if these documents aren't legitimate, why is it?
How many versions of the document are there in the bundle?
So there's a version at, I think there's E60 and E70. So I don't have it in front of me, and E73, I think.
Yeah, I recall seeing two. I didn't know that there were more than that.
Sorry, I don't. I can try and dig out the page reference for Your Honour for
Right.
the files. I think it's E60 and E73, but I don't have it in front of me. But really, the point we make is that if you were going to fabricate a document, you wouldn't. It would be unusual to expect to see that there was another version, one countersigned, one not countersigned. That just doesn't really seem to make a great deal of sense. And then what one should also do is sit it alongside the other contemporaneous documents which relate to it. So, for example, at E60, page 30, this is an invoice. I don't understand this to be one of the 4 documents which is said to have been inauthentic or forged. What you have is an October 2016 invoice, which makes reference to the purchase order number. So that's HA 0507 2016. So it's specifically relating back to that purchase order. And there's another invoice which does the same at page 31, just over the page from here. And so what these documents would suggest is that the purchase order existed, at least at some point on or prior to October 2016. So again, it's not plausible, we say, to assert that these are documents which aren't genuine and which were created for the purposes of litigation, if that is what's suggested. And again, even if one were to go so far as saying, well, we do assert that the invoice itself is forged, that would be difficult to explain for some of the reasons I've already outlined, which is if you were going to forge a suite of documents which you said proved the existence of a state of affairs, why would you have the invoice post-date the purchase order? Why wouldn't you just have the documents being contemporaneous and issued on the same date? Why is it you would have these sorts of imperfections, which if you wanted to create a document in order to prove a point, you would never introduce? You wouldn't post-date it to another time. You wouldn't design your fictional narrative to be quite as messy as this is, and the messiness is in itself what points Your Honour in the direction of these being authentic documents, because sometimes people in the way they run companies are imperfect, and that's often reflected by the documentary record. It's not an indicator of inauthenticity. To the contrary, we say it's an indicator of it being genuine. And of course, then we also have the bank account statements. We say those show that the payments were made. They include handwritten narratives. Mr. Shehata's evidence is that the narrative on it was written by the accountant, Mr. Abdulaziz, where he's tracking across the payments being made in respect of those invoices. And we say that none of
it was made in 2 payments. Is that right?
Yes. So there's one payment which is split between 2 invoices, and then a subsequent payment of the balance. So there was.
And did the purchase order itself make any reference to them being split like that?
It doesn't make reference to them being split. On the terms of the purchase order, the payment terms make reference to payment being made when work is done.
Okay. And does the bank statement refer to the invoices?
The text of the actual entry on the bank statement doesn't. What there is a handwritten entry, which Mr. Shehata says is by Mr. Abdulaziz, the accountant, when he's tracking back through which invoice relates to which. So those are the manuscript notes. That's what that document looks like.
Did Health Insights Malaysia make payments to HI Dubai for any other purpose? Were there other payments that were made by HI Malaysia to HI Dubai?
Yes, which I'm going to come to. I'm going to show you the payments we say were made. But there are documents showing not only these payments but other payments across. It's between I think it's between 2013 and 2020. But I'll come back to. I'll show you the document which
So the
summarises
bank
it.
statements themselves don't prove that the payments were made in respect of the purchase order.
Well, we don't say that. Well, we say that that is what the payment was made for. The statements show that there is that flow of money. It's just that the entry in the bank statement isn't expressed.
No.
But the manuscript note is.
There's no. That's said to have been written by who?
Mr. Abdulaziz.
But we have no evidence from him.
No, but what we obviously have is the record of there being an invoice and the record of there being a payment made from Health and Sites Dubai, and there's no other invoice during the relevant period in respect of or explaining those payments.
And do we know that all of the other payments reflect an invoice which is before the court?
So the bank statements refer. So the manuscript notes and the bank statements go through each payment and refer back to the invoice.
No, you told me that there were other payments.
Yes,
other than the
so I mean
payments
that's. Let me see if I can find some examples for Your Honour. But there are manuscript notes on other portions of payments flowing from Health and Sites Malaysia to Health and Sites Dubai, which are sort of traced out by reference to the invoice, the corresponding invoice.
Does the evidence tell me whether this was some retrospective exercise done for the purpose of litigation, or whether for some reason they were contemporaneous? Or is there any evidence about when these notes were written and for what purpose?
The manuscript notes, you mean?
Yes.
No, I don't think that there is, but I can come back to you on that if that's the case.
Right. I'm sorry,
but
I've just noticed. I'm sorry, Mr. Doherty, I've just noticed we've clicked over the 90 minutes mark. I'm sorry to interrupt you at this stage, but I think a few of our rules with the transcribers, we should break at this stage, and we should resume then at 11:45.
Yes, Your Honour.
Thank you. Yes, Mr. Doherty. You're on mute, Mr. Doherty.
Yes, thank you, Your Honour. Can we bring up E60, page 33? And this is just in reference to the point we finished on, Your Honour. One of the things we do point to is the description in the additional narrative in respect to the payment. And so you can see it says software for hospital information system. So we say that that's what establishes the connection between the invoice and the payment with the purchase order.
Are there other payments with similar notations?
There are others which refer in the past to different invoices, I believe. So I think, for example, there are other examples should have E60, page 27.
Could we go to that, please?
Sorry, no, bear with me. That's an incorrect reference. That's a payment from someone else. But in short, there are bank statements which show other payments flowing from Health and Sites Malaysia to Health and Sites Dubai. Some of them refer to specific invoice numbers and some do not.
And do they give a description besides invoice? I'm trying to see if to compare the entries.
Can I come back to that, Your Honour?
All right.
I'll see if I can dig you out some references.
And whilst we're on that, remind me, did Mr. Shehata say why he had redacted the statements in this way?
I don't know if that's
No.
been expressly stated
Okay.
or not.
All right.
No. Okay. So if I can then deal with the points that we take on the legal analysis of the claim. So with the purchase order, what we say is that first, Your Honour should accept the documents bear the date they say, and at the very least, the purchase order should be seen as dating no later than the date of the invoice that it cross refers to. So that's October 2016. What that means is that the regulations that are relied upon don't apply because they came into force on the date they were published. That was the 1st of February 2017.
There is a threefold attack on it, if I recall properly. So the first one I think you've dealt with is the first attack on it is that it's not a genuine document. Insofar meaning it wasn't executed on the date it purports to have been executed, and secondly that it wasn't intended to affect the legal relations it purports to. And I think you've dealt with that. The second attack was essentially lack of authority, in that the agreement was, I think it was, I forget exactly how Mr. Montague Smith put it, but even accepting that Mr. Shehata had express authority to enter into contracts on behalf of Altai Dubai, it was a breach of his duty to enter into a contract from which he derived personally some benefit. And I'm not sure, I don't recall exactly how that was put, but I think I'm assuming it's on the basis of the usual equitable principles that a fiduciary is not permitted to enter into a contract in which he has a personal interest, and it makes no difference, of course, even if it does benefit the company, he's still required to account for any personal profit he made. And then the third attack was made on the basis of the regulations which you were about to go to.
Yes.
I think.
Yes, and just to deal with it in a slightly different order, basically with the regulations, the point is we say they don't apply because they weren't in force at the time of the relevant conflict arising.
Okay.
And that really is the important point in time, is at the time that the transaction was entered into, was there material conflict caught by the regulations. Really the point about authority, there are two answers to that, but the substantive answer is the same as what we would say even if Your Honour was to take the view that the regulations did apply. So effectively deal with those points together. The first point we make about the way that the authority case is put is that the precise framework through which this claim is presented to the court is a specific ability of shareholders to refer to the court on the application of Regulation 79. So that is specific instances in which the shareholders can come to the court and say, you should set aside this transaction because of an undisclosed conflict. What it doesn't entitle the shareholders to do is to more broadly stand in the shoes of the company, or for that matter, a counterparty to a contract. So we say that the shareholders don't have standing to make the arguments that are made about authority, because it would have to be the company, if it wanted to make those sorts of arguments that made it. So they're effectively trying to stand in the shoes of the company in a way that they're not permitted to do so as shareholders. So that's the legal answer to that framing of the case. And then the substantive answer really comes down to points of materiality. So what we say is in the substance, there's no conflict or no material conflict. And really
What do you mean by that?
Well, the regulations.
And let me tell you the background against which I'm asking that question is really what I was putting to you before. It's a breach of fiduciary duty to enter into a contract in which you have an interest, even if it is for the benefit of the company, and even if the company does benefit from it.
The way that it the way that it is put in respect of the case on authority is in effect that the nature of the transaction is one in which the company would never have desired it to be bound by. Obviously, Regulation 79
that's not a necessary element of the application of Regulation, what is it, 79.6, or have I got it wrong around, 76.9, forgotten the numbers.
What we say is that the requirement under Regulation 79 is of a material conflict. And when we say material conflict, we mean one which could actually objectively be viewed as being in conflict with the company's interests. And so the materiality threshold, we say, isn't made out because
I don't understand that. So you say it doesn't, for example, it is different from the usual rule that applies to fiduciaries. So is that what you're saying, that even if there is a conflict of interest in the sense that the director has a personal interest in the transaction, notwithstanding that, if there is no detriment or no significant detriment to the company, then there is no conflict? And I'm not sure I understand that, because that's not the way it's developed in equity.
Yes, well, the way we would frame it is to say that the regulations, I suppose, presuppose that they could only be engaged where there is, I suppose, what one might call self-dealing or being on either side of the transaction. But the very nature of the very fact of being on the other side of the transaction is not in itself enough to set aside. There are other requirements. So one, we say is materiality. Two, we say is awareness of the conflict. And the way
where do you read that into the regulation?
So
the words don't say that.
Well, Regulation 79 says. I want to get the text in front of me so I can put it accurately to Your Honour. So where the director of a company is in any way directly or indirectly interested in a transaction or arrangement that has been entered into by the company or proposed to be entered into, which, and this is point one, to a material extent conflicts with or may conflict with the interests of the company. And then the second part of that is to, and of which he is aware, he shall declare the nature and extent.
I'm sorry, so that of which he's aware is expressly
in the wording
regulation.
Yes.
Okay.
And so what we say is, and to put this in context, so E331, if we could open that up. The underlying context is that the consideration of this issue ought to take into account the ownership of MCC. So this is a list of payments which Health Insights Asia have made to Health Insights Dubai, spanning multiple years, but it runs from 2013 through to 2022, and the total amount is $7.681 million. So Health Insights Dubai has received payments from Health Insights Asia, totaling that amount between 2013 and 2022. And so we say that Health Insights Dubai is benefiting from payments, in that this is an income stream that otherwise it wouldn't have had. And the purchase order itself is part of this. It's a payment of $1 million to Health Insights Dubai, which is money it otherwise wouldn't have received. And it's also money that, in the event, was booked as revenue by Health Insights Dubai. It was distributed, or it was part of distributions that were ultimately made to shareholders. And what we say is that, well, the first point is the only way you get to this being a material conflict is if the analysis is correct that Health Insights Dubai owned MCC. And so the purchase order is leading Health Insights Dubai giving away something that is worth more than $1 million. And so we say that you should consider this issue in the context of findings about MCC's ownership. Because if the claimants are wrong about ownership, we say the conflict is immaterial because Health Insights Dubai stands to gain.
So
But
the purchase order, remind me, Mr. Doherty, the purchase order requires what? HI Dubai to do work for
Yeah,
HI
it says
Malaysia?
work. Yeah, work for
So
hire.
it's not just a matter of receiving money, it's got to do work. And then secondly, it's saying what? I forget exactly how it's put. It acknowledges or agrees that the right to that work will go to HI Malaysia. Is that the way it works?
It effectively reflects an understanding that in doing work you don't own IP effectively.
I'm
But
sorry, say that again.
It would be an understanding that in performing work for hire services you don't acquire intellectual property rights as a company, which is a matter of law, can only be correct from the perspective of a company.
Well, if you agree to that, it's all a matter of agreement in the end, isn't it?
Well, no, because the company, even if the company was directed to do work for hire, it itself wouldn't acquire the IP because the development work is done by authors, so the individuals who are authors, and that brings you back to the whole analysis of whether it's a collective work and so on. So there's no.
But is it the case that HI Malaysia only acquires the rights because the agreement either provides that they are or doesn't provide that they're not?
I think, as I said, I mean, this would obviously need to be dealt with as a matter of what presumably Malaysian law, but one of the ways that you can, as a company, seek to, in effect, protect your position when it comes to IP is to put in place those contractual arrangements.
Yeah.
And
who actually did the work?
Well, I mean, that's obviously an issue that's disputed. Mr. Shehata says that he developed the MCC program, which was then later taken up and implemented.
The work done under that contract, it provided, I think, does it provide for a certain number of hours work or certain? Mr. Shehata doesn't claim he did that work, does he?
Well, I don't think that we have evidence on what was performed. What Mr. Shehata said was that this agreement, in part, was entered into to assist with cash flow issues. That was the evidence that he gave.
But we come back to the work. The work, as I recall it, HI Dubai didn't have employees who could have done this work. The work had to be done by HI Egypt employees, didn't it?
Perhaps, but I mean, I think what it's slightly losing sight of is the case that's been put on this point, which is to say that the way that the claimants are advancing their case is to say that the reason that there's a material conflict is because in this case, what you were doing is giving away valuable intellectual property rights at a substantial undervalue. So that's the case that we're answering, and the point we make is to say that it's not giving away IP rights because MCC was never owned by Health Insights Dubai.
I'm not sure that you can confine it in that way, can you? I thought the case that's been put against you as I thought the words Mr. Montague-Smith used more than once, was that Mr. Shehata, was on both sides of the transaction. I thought that was at the heart of the claimant's case.
So paragraph 290 of the claimant's submissions.
290, okay.
Yeah, says D1 was conferred broad authority. However, that authority did not extend to acts which were not to D2's benefit and which could not reasonably be inferred to be desired by D2.
Right.
So dealing with the first point, that's what we say is what this was and could reasonably be construed to D2's benefit or desired by D2 because it's an inflow of money that D2 otherwise wouldn't have got. So that's point one. The second is the purported effect of the purchase order was to vest the MCC rights. However, it significantly undervalued MCC, which is a highly valuable product, as evidenced by revenues. And we say that that's incorrect because that presupposes that Health Insights Dubai had or could ever have acquired the rights to MCC, which we say is the incorrect analysis. And then three also deals with the substantial value.
If you're right, and the HI Dubai has not made out that it owned the MCC rights, and if they belong to HI Egypt, has HI Dubai exposed itself to action and potential losses by entering into a contract where it purports to be giving rights to HI Malaysia?
Well, it's not purporting to give rights to Health Insights Malaysia. It's just acknowledging that it doesn't assert ownership of the rights.
So is that as far as it goes?
What is acknowledged by the purchase order is on its face is if you do this work, you as the person doing the work do not thereby acquire a right.
I see.
And so the point we make is that if MCC isn't owned by
well,
Dubai,
I don't know, that's quite right. I'm just reading it now. It says it's fully understood and consented by HI Dubai that the intellectual property rights for all the work for hire as per this purchase order will be the full and sole exclusive ownership of HI Asia. So the second part, next sentence, I think, is what you were telling me, that HI Dubai consents not to claim any rights. But the first sentence there, that HI Dubai understands and consents that the intellectual property rights for all the work for hire will be the full and sole exclusive ownership of HI Asia. If the software belonged to HI Egypt, then HI Dubai doing this work wouldn't confer ownership rights on HI Malaysia, would it?
well, I suppose two things we would point out is there's no case before this court that MCC is owned by Health Insights Egypt. And we'd strongly point out, Your Honour, that that's not a finding that this court could make. It may well be the subject of litigation elsewhere, but it's not the subject of litigation here. But if we're in the realm of dealing with counterfactuals, one also has to look at the perspective of the desirability of this being set aside, because if this agreement has been entered into and money is being paid, if it's set aside, then money that's been paid would have to be returned.
Alternatively, the court could order an account without setting it aside, couldn't it?
My understanding of the way the claimants have put their case, they say that can't happen, and it has to be set aside for the ordering of the account. I think that was what was said about Article 79. I think that's a point, in fact, that was taken against what we say about Article 79. So in the claimant's case, it's a matter for Miss Montague-Smith, but on the claimant's case, potentially not. But in any event, we would also point out the fact that if your honour was to proceed to ordering an account, that you shouldn't respectfully set aside the agreement anyway, because the case as put is that if the agreement was entered into either without authority or it is liable to be set aside under Article 79, it's voidable at the option of the company. And here what we're really dealing with is the election of the shareholders, not the election of the company. So really the company ought to have a voice in what it wants to happen.
Well, we have the complication that the company is a party to the case, but because of the conflict over it, has not taken a position.
Yes.
It is a party to the case.
It is a party, but it's not a party who's expressed an election.
No.
If I could put it in that way. And then the other point in this, and I should say that these points cross over with the assignment agreement, we effectively make the same points, is that
Right.
Mr. Shehata in any event was not aware of the conflict because from his perspective, he didn't consider or know that Health Insights Dubai could be said to have owned MCC, or that he was giving away valuable IP. And so there was no material conflict of which he was aware, because what he was, or the state of his awareness, is that this is a contract which is going to lead to the payment of money to Health Insights Dubai.
So does that, I'm trying to understand what that means. If Mr. Shehata enters into an agreement with a company, HI Malaysia, knowing that HI Dubai doesn't own the software, is that engaging in some sort of misleading at the very least? Does that expose HI Dubai?
Well, I mean, if what we're talking about is a director in other ways not complying with their obligations or doing something which would be undesirable from the perspective of the company, that's a cause of action which would be mounted by the company against the director if so exposed to such a loss. But it doesn't mean that this framing of the cause of action is made out.
But the conflict of interest includes a breach of the duty of loyalty.
But I guess the point would be that it's not in the scenario that Your Honour is postulating, the problem is not that Mr. Shehata is personally interested. The problem is that in acting in this way, he potentially has exposed the company to another liability as relates to a third party. But that's not to do with his personal interest. That's to do with other aspects of his duty which are not in issue in this case.
Well, there's no doubt he's personally interested in the contract, is there? At least indirectly. And that HI Malaysia is going to make payment and receive the work and apparently receive the intellectual property rights to it.
The point we make is that that's not the duty that would be engaged in this counterfactual you're proposing, where it exposes you to a risk. The fact that it exposes you to a risk might engage other components of the director's duty, but not this conflict issue. And so if that were to arise as an issue, it would be a potential cause of action by the company against Mr. Shehata, but that's not the case here in these proceedings. And the same points we make in respect of the assignment agreement, so I'm not going to go through it again, but the point is that it's not a transaction which is conveying anything of material value, because MCC wasn't owned by Health Insights Dubai in the first place. And as regards Mr. Shehata's...
My recollection is that, and please tell me if I'm right or wrong or you're not sure, that agreement, I think, contains a warranty, doesn't it, that HI Dubai owns the intellectual property rights?
It does, but it's incorrect on its face, I guess, is the point. I mean, Mr. Shehata's evidence on the assignment agreement was that the IP registration itself came about because debts were being held over the company, and he wanted to ensure that the debts of the company were
But
paid.
again, I know you say this is the claimant has framed it differently, but Mr. Shehata, if you're right on the MCC rights and ownership, Mr. Shehata has caused the company to enter into a contract warranting that it owns the intellectual property rights when it doesn't. And that alone, well, put it either way, if it does own them, then you would say they've got material value, which gives rise to his conflict. If the company doesn't own them, well, he's causing the company to give a warranty, which exposes the company to potential very great loss.
Yeah, so it's the first point of those we say is material to what Your Honour is being asked to consider. So if it owns the rights, then it'd be difficult to answer that aspect of the claim, but we say that MCC rights were not owned by Health and Sites Dubai. And then on the other, if it doesn't own the rights and you're causing the company to enter into a warranty which could expose it to loss, that's not a product of acting where you have a personal interest. It might be a breach of a director's duty, but it's not a breach of the particular director's duty that is engaged in this case. And so if that is correct...
Why not? I don't understand that. The conflict is that he's causing the company to enter into a contract with another company in which he's got an interest. He's on both sides of the transaction. That in itself is the conflict. Now you were going on to, I understood, to be saying, oh, well, it's not material because it doesn't give rise to any loss, or couldn't give rise to any loss, but it could. So it's not the conflict. There, it seems to me, indisputably, there's a conflict. The question is whether that's going to give rise to any loss.
Okay, well, I mean, the pleader case is that it's selling it under value, and we say that it's not selling it under value. But even putting that to one side, what we say about the state of Mr. Shehata's knowledge is that the assignment agreement was not known by him to actually be impacting on Health and Sites Dubai's ownership of the rights, because he never understood Health and Sites Dubai to have owned the MCC rights.
But what he must be aware of is the conflict. And he's aware of the conflict. He knows he's on both sides of the contract. So in 79.1 refers to agreement that has been entered into by the company or proposed to be entered into by the company, etc., which to a material extent conflicts or may conflict with the interests of the company and of which he is aware. That is, what he must be aware of is the conflict.
Well, Your Honour, I suppose what we're saying is that the point of the regulations is that there is some filter. It's not every single instance where someone might be on the other side of the transaction which leads to it being set aside. And we would also make the point that if what Your Honour was proposing to do is to order an account, that in any event, as I've already said, the transaction ought not to be set aside. One, because again, there's an issue of payment. And payment having to flow back if you were to do that, but ultimately it really being the election of the company, not the shareholders, that matters in this context. But those are the points that I wanted to make to Your Honour. If I could deal very briefly with some of the aspects on the closure of the HSBC account, we say that claim is difficult to understand because effectively there are two components. One is transactions predating closure of the account, which is the accrued salary payments, and then there's the actual block transfer when the account is closed. This isn't is a claim.
Misunderstood. So it's not all of the impugned payments are not ones after the closure of the account, are they?
Correct. That is not a case that's been pleaded. So this is not a claim to set aside a transaction between Health Insights Dubai and a law firm that had engaged and paid. It's not a claim to set aside payments made after the closure of the account under the terms of an employment contract, or a claim to set aside transactions paying auditors after the closure of the account. The transactions, as specifically pleaded, are the two payments made before the closure of the account, which Mr. Shehata says were salary payments to himself, and then the payment which is the transfer out of the HSBC account when it's closed.
Right.
That's actually what's pleaded, and that is the narrow framing of this case, which Your Honour asked to consider. As much as the claimants wished to advance the case based on other premises. And we made the point when the application to amend was made on the 11th of September that at trial they had to advance the pleaded case, and that all of these points about misappropriation subsequent to the closure wasn't what was pleaded. So when it comes to the salary payments, I mean, they're really straightforward answers to both of these claims. So it's common ground that Mr. Shehata was entitled to draw a salary of $15,000 a month. That's pursuant to a board resolution. There's no factual basis to support an allegation of wrongdoing, let alone the allegation that was put but not pleaded that he'd stolen the money. The claimants have evidence establishing Mr. Shehata's entitlement to payment. That's the board resolved that he should be paid that amount. And what we also have before the court is copies of the HI Dubai bank statements from 2021 through to the date that it was closed. And when you look at the bank statements, what you can see for most employees is their monthly salaries go out every month when they're due. And what you see is during that window of time, unlike the others, Mr. Shehata wasn't drawing his salary on a monthly basis. And instead what happens is there's a 20-month period from January 2021 to August 2022 when you can see no money goes to Mr. Shehata. And then it resumes in September 2022. So 20 months of a $15,000 a month allowance is $300,000. That's what's ultimately withdrawn in two tranches. And it's unrealistic to contend he wasn't entitled to that. And it's also unrealistic to contend that it was somehow concealed. And we say that the fact that it was accruing but not paid is reflected in the 2022 financial statements. So when you analyse this through the...
Is that all he paid to himself by way of salary? I thought it was put against you that he'd paid himself salary in respect of the period after which he ceased to be the general manager.
That was put to him in cross-examination, but that's not what the pleaded transactions are. The transactions which are sought to be set aside are not those. The last payment, or the last transaction or arrangement which the claimants have pleaded as being susceptible to being set aside is the transfer out of the HSBC account when it closed. Whatever happens thereafter is not part of the claimant's pleaded case.
I'm not sure I understand that. You mean, but he transfers money out. If he kept any of that for himself, then that would be a misappropriation of them, or a transaction for which he had a conflict which could be set aside, wouldn't it? Unless he had a legal entitlement to it.
Yeah, that could have been a case that was pleaded and run, but it's not. And if you're going to assert a case of misappropriation, you've got to expressly plead that, and it's not. Okay. We made this point when the amendment application was made, and we've made this point in respect of the evidence advanced, which is that if you're going to make allegations like that, you've got to specifically plead it. And so the narrow questions are those which are the pleaded questions. So on the salary, there's no material conflict, because the director of a company, if they pay themselves a salary that they're entitled to by a board resolution, it's not a material conflict to pay yourself that money because the board has said you can. Mr. Shehata couldn't have been aware of that.
The way I would understand that, Mr. Doherty, is it is a conflict, but it's an authorised one because the board has authorised it.
Yes, and of course there would be no failure to disclose, of course, because the board would have previously authorised it. So on the salary payments, it doesn't work. And then when it comes to the transfer on the closure, the that isn't a payment made by Mr. Shehata to himself or to a third party under a contract. It's not a case where he's making the payment and saying, I own this money. What it is a consequence of the circumstances that were.
But doesn't he pay it into his own bank account?
Well, it goes into his bank account, but he's never saying I'm paying this bank account as a payment to me. What happens is that, and all of the evidence is here for this. So HSBC tells them on the 23rd of June the account's being closed. He tried to engage them to keep it open or to delay its closure unsuccessfully. There are a series of documents in the bundle which show an attempt to set up an alternative account with Mashreq, but that account can't be opened during the summer of 2023 because you've got to be on the ground to do it effectively, and Mr. Shehata couldn't. And so when HSBC said, well, your account is closing, ultimately he's faced with limited options, which leads to the money being transferred to his account, and thereafter Ledger is maintained to record expenditure.
The money being transferred to his account, it leads him to transfer the money to his account.
Yes, but when one actually looks at what the requirements are to make out a case here, one, there's got to be a material conflict with the company's interests. Mr. Shehata isn't paying it to himself and saying, this is mine now. What he's doing is
he pays it into his own bank account. It's not a trust account. It's just paid into his own bank account, isn't it?
But he's not asserting ownership of it. He never puts forward the case which says this money's in my account and therefore it's mine. What he is authorized to do, and I can pull this up. So E41.
Right.
If you scroll down, it's 3 lines up, where broadly as the general manager of the company, sorry, no, scroll up to the main paragraph. As the manager of the company, he's got the right to deposit, borrow, endorse, and withdraw funds to or from the company's bank accounts or safety deposit box.
Yes.
So the act of putting the money somewhere isn't in itself an unauthorized act. It would be unauthorized if he took the money and he purported to keep it for himself. And that, of course, would be a material conflict.
Himself, didn't he?
Well, there are salary payments, which again we would say are not transactions at a conflict for the reasons I've just addressed. But
are some of those salary payments for a period after he ceased to be general manager?
Yes, they are, but that's...
Well, he had no authority to pay himself that money, did he?
Well, it's not the pleaded case. The question Your Honour has to ask is, at the point of time when the HSBC account is being closed, did Mr. Shehata operate under a material conflict of which he was aware? And what happened when the money was transferred is that the circumstances necessitated the money was going to have to go somewhere for safekeeping, faced with limited options and the inability, which he tried to do. He tried to open another account, and there's evidence of that. Faced with being unable to do that and presented with limited alternative options, the money was transferred temporarily to an available account which happened to be his, and ledgers were maintained recording the company's expenditure.
Does your case on this depend upon me accepting Mr. Shehata's evidence of what he did with the money, and that being what he had intended to do with the money? And put it another way, if, for example, I did not accept that the payments made to said to be employees were made to them, if I was not persuaded that Mr. Shehata had accounted for the money, does that not lead to the conclusion that Mr. Shehata paid this, may it lead to the conclusion that Mr. Shehata paid it into his own bank account, of which he was the beneficial owner, and then used it for his own benefit, and that was a conflict?
No, we say that is not a finding that's open to you, because what would have to be impugned is those specific transactions themselves. And if those were going to be impugned or set aside, there would need to be a pleading to that effect, because that frames the evidence that Mr. Shehata provided. I mean, this amended case was introduced very shortly before trial, with a very short period of time for Mr. Shehata to actually provide responsive evidence. If it had
Okay.
been pleaded that through this transaction, we don't believe that you paid this individual this amount of money for a salary, then that case could have been addressed if it was pleaded. And it's an allegation of theft, in effect. It's an allegation of misappropriation. So if you are going to put that case, you have to plead it so it can be
Okay.
properly answered. So the only relevant consideration is, at the time the decision was made to transfer the money out on the closure of the account, was that a transaction where there's any evidence to suggest that Mr. Shehata was trying to misappropriate the company's money? We say no, there's not, because what the evidence shows is that he tried to open another bank account to put it in there. He was unsuccessful in that, and that he
Could I
put
not,
the money in the only place available.
am I not entitled to look at what he did with the money and from that draw an inference about what he intended to do with the money?
Well, no, because there's direct evidence which explains the payment. The direct evidence which explains the payment is the circumstantial evidence of the account being closed. If the account was not going to be closed, that payment would have never been made, and the money would have just stayed in the HSBC account. So that's the element of the transaction we're looking at. Your Honour, with the time I've got left, I want to take you through the counterclaim, and really the focal point for this has to be the legal issues.
Right.
And so you're under no misapprehension as to what the case is.
Okay.
We say that the way that the claimants sought to address this really is to try and pick up a number of procedural issues which you don't agree with, to be clear, but which in any event are just sidestepping the case that the claimants have to answer. It's just another attempt to distract the court and duck the issue that actually confronts the claimants on the law. The propositions I'm going to go through are, first of all, that the starting point, Your Honour, is the law of unfair prejudice. This isn't a director's duty case per se, and in fact we expressly accept that, because part of what is being sought in the relief is permission by Health and Sites Dubai to bring a claim for breach of director's duty, but it's Health and Sites Dubai who have standing to bring that kind of an action. The starting point, the test Your Honour has to apply, is whether the affairs of the company have been run in a manner which is unfairly prejudicial to Mr. Shehata. That's the issue that's before you. The director's duties owed by the claimants feed into that analysis, but what the claimants do is misidentify the issues and don't tackle the substance of the counterclaim as it's put. It's quite right that the claimants owed various duties to the company, including a best interests duty, but the focal point of both this case and other cases in this area which are concerned with the diversion of business and opportunity is effectively what Your Honour has just been talking about. It's the corollary duty that a director has not to place themselves in a position of conflict. And the underlying conduct, which we say give rise to unfairness in this case, is that the claimants took business and contracts and opportunities which historically were, and ought to have continued to be, the business of Health and Sites Dubai, and they diverted that business and opportunity to entities in which they had a personal interest. So from Mr. Shehata's perspective as a shareholder, this is conduct we say is obviously sufficient to find an unfair prejudice petition. So the claimant's actions are concerned with the management of Health and Sites Dubai, because it was Health and Sites Dubai's existing business that is being moved on, as well as opportunities for new business, which plainly ought to have been put in front of the company.
I'm sorry to stop your flow, but I'm not sure if you're going to come to it. But the first basic question you've got to answer is what jurisdiction or power this court has got under Regulation 89. And of course, it's been raised before, where Regulation 89 says the authority may make one or more of the following orders and so on. And you have to overcome that problem, that the regulation specifically gives the jurisdiction and power to the authority and not to the court. So how do I get jurisdiction and power?
It might not be lost on Your Honour that if you were to go to the DIFC law, or if you were to go to English law on this, it also says that the court may order such and such.
Where does it say that?
So no. I'm drawing a comparison between DIFC law and English law. So if you go to provisions of the DIFC statute when it comes to the DIFC company law, the provisions are set out in comparable terms, and it says that if the affairs of the company have been managed in a way which is unfairly prejudicial, the court may ... order this form of relief.
Right.
What that doesn't confer is some exclusive kind of jurisdiction on any one court or any one authority to resolve those issues if the parties have agreed otherwise. So that's the first point. It's not.
You're talking about arbitration, are you?
Yes, well, arbitration is one example of this being the case. I'm talking about two things. One, how the courts have approached this question in the context of arbitration, but also looking at the nature of what unfair prejudice is and why it can be resolved in this way. So,
So can you help me with that? Give me a case that
I'll work
what
through
you're
it.
saying.
I'll work through it, Your Honour. So we say that the headline points of this: you've got jurisdiction, which is conferred by the articles. Two, when the counterclaim is filed.
How do the articles give me jurisdiction over the to make orders under Regulation 89? Just because the regulations are incorporated into the articles.
Yes, and well, I mean, this is the claimant's pleaded case as well, and this is the basis on which they sought the relief of the court on the Part 8 claim.
Well, they might be wrong too. I really need you to tell me why.
So we go to E100, page 7. So Article 28.2, DFC courts have exclusive jurisdiction to settle any dispute from or connected with these articles.
Yes.
So the primary starting point is that the DFC court's jurisdiction to settle disputes under the articles. The members are required to settle their disputes or to raise their disputes with the DIFC courts. And this is a claim by a member concerning the way in which the company has been run. And we said something that falls within the scope of that exclusive jurisdiction clause. And if you look at 29.1, that's where it makes the point. Subject to these articles, the provisions of the DCC private companies regulations that are not expressly set out shall apply. And what we say is that the position common to both parties is that a breach of the regulations constitutes a breach of the articles. So if you breach something that's set out in the articles, that can give rise to a contractual claim under the articles. And for reasons I'm going to come to in the case law, that's consistent with what really unfair prejudice is.
But
As a matter of law.
It's not a breach. It's not a breach of anything, is it? It's under Regulation 89. It is where that those circumstances exist, then the authority has got the power to do certain things. It's not that anybody has breached anything.
Well, the context in which you can compare this with the arbitration cases is important. So if we turn up H82, this is the Fulham Football Club and Richard's case.
Right. So, sorry, where is this? In the
H82. And if we can start at page 12.
Right.
And paragraph 44, please. Where we see the context set by, these are the UK provisions. So section 994 provides that a member of a company may apply to the court by petition for an order under this part on the ground that the company's affairs being conducted in a way that's unfairly prejudicial.
Yes.
Now, the court in that context is also given an expressly defined meaning. So what it means is the relevant UK court.
Yes.
So if what the claimants are saying about that is correct, it would mean that, for example, in section 994, you would have to read that as being the court and only the court can resolve issues concerned with unfair prejudice. But we say that that assertion is unsustainable, and really this is the point that was being argued in the Fulham case. So what they said was that an unfair prejudice petition is not suitable for disposal by anything other than a judicial process because it relates to statutory provisions and statutory rights governing the operation of companies. But that argument was expressly rejected. If we go to page 23, please, and to paragraph 77. So the determination of whether there's been unfair prejudice consisting of the breach of an agreement or some unconscionable behaviour is plainly capable of being decided by an arbitrator. It refers to being common ground that arbitral tribunal constitute the rules with the power to grant the specific relief sought in the petition. We're not therefore concerned with the case in which the arbitrator is being asked to grant relief of a kind which lies outside the powers or forms that may form part of the exclusive jurisdiction of the courts, nor does the determination of issues of this kind call for some kind of state intervention in the affairs of a company, which only the court can sanction. A dispute between members of a company or between shareholders and the board about alleged breaches of the Articles of Association or a shareholders' agreement is essentially a contractual dispute, which does not necessarily engage the rights of creditors or impinge on any statutory safeguards imposed for the benefits of third parties. So that's to draw a distinction between where you've got what is in effect a private dispute raised by a minority shareholder that their rights are being interfered with, for example, the powers of a court when it comes to making orders like winding up, which might affect the generality of members. There's an obvious distinction there. And what's said in this case is that the character of an unfair prejudice petition is that essentially what we're dealing with is a contractual dispute. It doesn't engage the rights of creditors or impinge on statutory safeguards. What we're talking about is contractual in nature. And we say that that applies equally in this case, where the right as a minority shareholder to be protected from unfair prejudice is codified in the regulations, but is also incorporated into the articles. And we say the framing is if you breach the regulations, you also breach the articles. So it is a breach of the Articles of Association to conduct the affairs of the business in a way which is unfairly prejudicial. And there's no way that that argument is inconsistent with the nature of these proceedings. And if it was...
You use the expression again, Mr. Doherty, if you breach the regulations, was that just a shorthand way? Because, of course, that's not the way Regulation 89 works.
I'm using it as shorthand. I think what I'm saying is if the affairs of the company are conducted in a manner which is unfairly prejudicial and therefore engages the regulations, and if the company is conducted in that way, it would constitute a breach of the articles as well. And the point really is this: if you remove DIFC court from the articles and instead you started an arbitration agreement, it seems really difficult to foresee a scenario in which you could say that only the DDA can look at this issue. An arbitral tribunal couldn't possibly resolve a claim asserting unfair prejudice. And if that's the case, then there's simply no reason, based on the nature of the right, why the same couldn't be said of including an exclusive jurisdiction clause in favour of the DIFC court. There's simply nothing which would preclude that. This isn't an area which is impinged by some public interest or public policy concern in a way that you might say of winding up. And that's the approach the English courts and the Australian courts have taken when it comes to unfair prejudice. Courts, an arbitral tribunal can determine unfair prejudice, but it can't, for example, order a winding up of a company. But there's nothing which would prevent the parties here from resolving their disputes in a particular forum, be it arbitration or before the DIFC court, or for that matter, any other court. Your Honour will have noted in paragraph 464 of my closing, I've also referred to an Australian case, so it's ACD Trident and Trident Australia. And there it's held that the statutory powers of a court under the Corporations Act are comparable to the powers exercised by the court under the general law. So they're not special powers to be exercised by reference to the public interest. And so in the analysis in that case, it came to the same conclusion as Fulham, which is there's nothing to prevent parties referring a claim for oppression, as it was in that case, to arbitration. So it's a matter of principle. This court can plainly resolve an unfair prejudice petition. But there are also provisions within the regulations, which we say make clear that really this dispute could not sensibly be resolved in any other way. So The DDA is not a court or adjudicative body. It doesn't issue orders which can have the effect of being a binding judgment. And unlike an arbitral tribunal, there's no mechanism for taking some direction issued by the DDA and turning it into an enforceable court order. Courts of Dubai are not going to recognise a direction of the DDA as though it was a judgment. So when we say it's not an adjudicative body, that's what we mean. And it's for that reason we say that the regulations have express provisions which allow, amongst other things, the DDA to refer matters to the court if there's been a breach of regulation. So if you look at E69, page 54, if you go to Article 108, please, at the bottom of the page. So applications to court, where a person intentionally, recklessly, or negligently commits a breach of a requirement, duty, prohibition, etc., imposed by these regulations, the authority shall be entitled to refer the matter that it deems appropriate to the Dubai courts, or if all the parties to a dispute have agreed in writing to an arbitral body. I mean, that obviously contemplates the DDA acknowledging that it is not an adjudicative body, because if it was, it would have no need to refer matters to the Dubai courts or to an arbitral body to make that sort of a decision. And if you look at the bottom, 1084, what it says is nothing in this regulation affects the powers that any person or the relevant court may have apart from this regulation 108. And that is also equally telling. So when it says that the powers that any person or the relevant court may have apart from this regulation 108, that's a small c court. It means a court of any competent jurisdiction in that context. And what it's expressly envisaging is that disputes arising from the regulations could be resolved by a court, not by the DDA, and also that it's not specific to the Dubai courts. It could be another court of competent jurisdiction. It could be an arbitral tribunal. And so what that obviously leaves open to the parties is to agree that what the relevant court is going to be for the resolution of their disputes. And that's why the jurisdiction clause in the Articles of Association is important. And that's why the DIFC court is competent to deal with this dispute. And one of the points that's taken is to say that, well, this must be wrong. This is 372 of claims closing, and that must be wrong because taken to its logical conclusion, that means that any power conferred on the DDA could also be assumed by the court. But I mean, that's obviously wrong because, again, just drawing the analogy with unfair prejudice petitions being capable of being determined by an arbitral tribunal, the fact that an arbitral tribunal can determine a case under Section 994 of the Companies Act doesn't mean that an arbitral tribunal can confer statutory powers which have some wider public interest. So, I mean, that's expressly acknowledged in those lines of cases. An arbitral tribunal cannot order the winding up of a company. That's uncontroversial. So there's no suggestion that this is some kind of, there's no genuine suggestion this is some kind of floodgates in which it means that the court can decide anything the DDA is empowered to do. That's incorrect. What the case law establishes is that courts, other than the native court, we say, and arbitral tribunals are capable, if the parties so determine, to agree that their unfair prejudice claims or other types of claims arising under the statute should be resolved in a forum other than the one specified by the legislation. And again, if we look at over the page at 109, sorry, page 55, Article 109. Power to enforce orders made by any court or arbitral tribunal under these regulations may be enforced as orders made in an action pending therein. So an order made by any court or arbitral tribunal under these regulations, court there means any court of competent jurisdiction. Properly construed, what that means is any competent court of competent jurisdiction can make an order under the regulations, because that's what Article 109 says. So there is no conceptual difference in this context between what an arbitral tribunal could do and what the DIFC court can do. If the articles say that dispute should be resolved by the DIFC court, the DIFC court is a court of competent jurisdiction, and there's simply no reason why it can't resolve this dispute. And so that's the jurisdictional point. When you come to the substance, if you're happy for me to go back to that.
Yes, please.
The test is not what the claimants have identified. So if we can start with, so we go to page 79 at page 20. This is a case called Financial Technology Ventures and ETTFC. It's a Jersey Court of Appeal case, but it's a succinct summary of the constituent elements of a unfair prejudice petition. So paragraph 55 of the ABC. So complaint must be directed to the conduct of the company's affairs. The question of whether a particular act has been performed is one of fact. The capacity in which it's performed will be mixed fact and law. The plaintiff must establish that the acts are prejudicial, prejudice to their interests as a member of the company, prejudice in some other capacity is not relevant. The question is whether there's prejudice is one of fact. The capacity in which it's suffered is mixed fact and law, and then the prejudice must be unfair. That's an evaluative judgment involving both issues of fact and law. So the conduct of the claimants in their capacities as directors is important for reasons I'll come to, but this is the test that Your Honour is actually tasked with applying in this case. Unfair prejudice is wider in scope than, for example, a company's claim against its directors would be. And it asks Your Honour to view the claimant's actions from the standpoint of whether or not they show that the affairs of Health Insights Dubai were being run in a manner which is unfairly prejudicial to Mr. Shehata. So you work through that by saying, well, is the conduct complained of conduct of the company? If we scroll through this, paragraph 57 of this judgment addresses that question, but essentially says it's a broad enough concept to capture anything which can be brought before the board and the members. Paragraph 58 deals with the question of prejudice and says it's not to be narrowly construed, but obviously financial prejudice would be caught. It can also include things like losing confidence in management and so on. And then paragraph 60 deals with unfairness. That is context specific and is an evaluative exercise. And if I can just draw Your Honour's attention to 2 points. If we go to E, which is on page 23, the test is objective, so the plaintiff doesn't have to prove that conduct was deliberately intended to be unfair. We say that's central to Your Honour's analysis, viewed objectively with the affairs of the company being managed in a way that's unfair. The claimant's position seeks to direct Your Honour to the subjective views of the claimants. That's wrong, and it's a red herring in the context of an unfair prejudice petition. Mr. Shehata's claim isn't founded on subjective intentions of individuals. And that point obviously cuts both ways. So, for example, in an unfair prejudice petition, just because someone intends to disadvantage a particular shareholder doesn't invariably mean unfairness, but also the corollary of that is true. And then at G, which is the bottom here, sorry, not G, at H, unfairness doesn't even necessarily mean unlawfulness. So having identified the parties' legal rights and duties as the starting point, the test is one of unfairness, not unlawfulness. A breach of a legal right may constitute unfairness, but a finding of unfairness is not necessarily dependent on establishing violation of a legal right or duty. So where the claimant's duties fit into this is that a breach of a director's duty is one example of a finding that is likely to lead to a conclusion of unfairness, but it's not an essential element, nor is it actually necessarily even something that invariably leads to the conclusion. You could have a case where there's a breach of a director's duty that doesn't lead to unfairness. But the really critical problem for the claimant's analysis is that they've missed the central point around diversion of business opportunity. So there are two aspects to a director's duty not to put themselves in a position that conflicts with the interests of the company. And one of those we've looked at, That's the Article 79 provision. And that covers a scenario where a director is entering into a proposed transaction on behalf of the company with themselves. So it's where they're dealing with the company. But that's not the full extent of the no conflict duty, because you also have conflicts that arise where your direct or indirect personal interests conflict with the company's wider interests. So instead of it being a case of self-dealing with the company itself or entering into a transaction with the company itself, that conflict can arise where you divert an opportunity which otherwise would have come to the company somewhere else in a way that it engages your personal interest or your personal benefit.
So what you've got to come back to all the time, Sir Doherty, is the company's affairs are being or have been conducted in a manner which is unfairly prejudicial.
Yes.
So you've got to be looking at the conduct of the company's affairs.
Yes. And for reasons I'm going to come to, in the context of an unfair prejudice petition, what that means is if you, as a director, find yourself in a scenario where you have come across an opportunity in your personal capacity or in some other capacity, but you accepting and taking on that interest conflicts with a duty that you owe to the company of which you're a director, and you nevertheless choose to exploit that opportunity in your personal benefit, that is you conducting the affairs of the company in a manner which is which engages your director's duties. You can't just turn your duties on and off and say, well, I was acting in this capacity, so it doesn't have anything to do with the company. And the case law establishes that, and I'm going to work through it as quickly as I can with Your Honour. But the point really is that if you're a director of a company and an opportunity comes to you, which is relevant to that company, and you decide to keep that opportunity for yourself and present it to another company, which you're also a director of, you breach your duty not to put yourself in a position of conflict.
And I understand that in the context of looking at whether a director has breached their director's duties. Does that also apply to the unfair prejudice context, where the question is not has the director breached his duties, but is his conduct of the affairs of the company unfairly prejudicial?
Yes, and the way that plays out in the cases, which I'll show you, is that
Okay.
if I'm a director of a company, the opportunity comes my way and I put it somewhere else and not to the company, that obviously negatively and unfairly affects the shareholders because the company is losing the opportunity. That has an effect on their value of their shareholding. It has an effect on what they'll be paid in dividends and so on. So you can't just siphon off business for your personal benefit, because that is directly going to impact the bottom line for any members. So just working through some of the law, because it is important. So I'm going to start with Bullar and Bullar. It's H68. It's an English Court of Appeal judgment. At page 12, please. And at paragraph 27. So paragraphs 27 and 28. So I agree with Mr. Berrigan. The concept of a conflict between fiduciary duty and personal interest presupposes an existing fiduciary duty, but it doesn't follow that it's a prerequisite of the accountability of the fiduciary that there should have been some improper dealing with property belonging to the party to whom the fiduciary duty is owed. That is to say, with trust property. And then continues just below that, no fiduciary, and this is the quoted bit, shall be allowed to enter into engagements in which he has or can have a personal interest conflicting or which may possibly conflict with the interests of those whom he's bound to protect.
Yes.
28. In a case such as the present, where the fiduciary has exploited a commercial opportunity for his own benefit, the relevant question is not whether the party to whom the duty is owed, the company in the instant case, had some kind of beneficial interest in the opportunity. In my judgment, that would be too formalistic and restrictive. Rather, the question is simply whether the fiduciary's exploitation of the opportunity is such to attract the application of the rule. And just pausing on that point first, one of the things that's said is that The claimants can't have acted in breach of duty because Health Insights Dubai didn't have some proprietary right or right in perpetuity to the benefit of contracts that it had with Al-Khalij, because it's ultimately a question for Al-Khalij whether it continues to contract with the party or not. And we say that that proposition is wrong in its application to a case like this. Well, it's wrong in fact, which I'll come to, but the legal analysis is wrong because a director doesn't just breach their obligations on the transfer of company property or interfering with a proprietary right. The point is that if an opportunity presents itself, which the director exploits through some channels which are not the company, so in this case, other companies which they own, it doesn't matter whether the company of which their director had a proprietary interest in it or not. It's whether the director's discovery of the opportunity engaged their duty not to place themselves in a conflict, or for that matter, engaged a duty to put the opportunity before the company of which they're a director. So it's not, the breach of this duty isn't contingent on establishing that Health Insights Dubai had some proprietary right to continued business. The point is that the goodwill and the prior course of business that had been built up had been through Health Insights Dubai. So you can't just take that, transport it somewhere else and say that that's not in breach of your duty as a director. If you go to page 13, paragraph 30, we see the test that applies here. So it seems to me the rule is a simple one. And then the quoted bit is the phrase possibly may conflict requires consideration. It means that a reasonable man looking at the relevant facts and circumstances of the particular case would think that there was a real sensible possibility of a conflict. Not that you could imagine some situation arising which might, in some conceivable possibility in events not contemplated as real sensible possibilities by any reasonable person, result in conflict. And then it refers to the strictness of the rule below. So the test here is objective. The application of the test is strict. And the claimants seem to accept that those are the correct principles at paragraph 294 of its closing. So we're not concerned here with, well, what was the subjective interest of the claimants? Where they're operating in conflict with the company's interests, it's an objective test. Another point that is taken deals with the capacity in which the claimants were acting. So what seems to be suggested is that, well, some of these steps were taken when the claimants were acting for Health Insights Egypt or for Al-Khalij, rather than it being the undertaking of acts on behalf of Health Insights Dubai. We say that that assertion doesn't make sense when one is considering the conduct of the affairs of the company. So the very fact that a director wants to exploit an opportunity privately to the exclusion of the company can't be a defence on capacity grounds. I mean, the very fact that you're excluding the company is what engages your director's duties in the first place, not to put yourself in a position of conflict. So, I mean, if in the context of exploiting opportunities that should have been passed on to a business, a director could just say, well, in exploiting that business, I was actually acting in my capacity as a director of my own company. It would completely render the duty meaningless. It would allow a director to, in effect, turn their duties on and off as they please. And it would negate the protection that the company has against its directors in the first place. The whole point is if you're caught between conflicting interests, your duty is to avoid those conflicts. And where an opportunity presents itself in your personal capacity that might interfere with your duty to a company, you've got to tell the company about it. And Boulard looks at this capacity point as well. So if we go to page 14, paragraph 36. So starting at the second line, refers to an authority that's been cited, so that's Industrial Development Consultants. In that case, a commercial opportunity was offered to the defendant, who at the time was the managing director of the plaintiff company, and the opportunity was offered in his private capacity. The defendant subsequently obtained his release by the company in order to exploit that opportunity for his own benefit, and said had the company known that he'd been offered the opportunity, it would never have agreed to release him. And as we continue over the page, he was held accountable for the benefits which he had received by exploiting the opportunity. The opportunity in that case was not one which the company itself could have exploited. And if we scroll down to C, C through to E. Yeah. So the bit that's quoted here is the first matter that has to be considered is whether or not the defendant was in a fiduciary relationship with his principals. Counsel for the defendant argued that he was not because he received this information which was communicated to him privately. With respect, I think that argument is wrong. The defendant had one capacity only in which he was carrying on business at the time. The capacity was as managing director of the plaintiffs. Information which came to him while he was managing director and which was of concern to the plaintiffs and was relevant for the plaintiffs to know was information that it was his duty to pass on. And then it continues that the defendant had embarked upon a deliberate policy and course of conduct which put his personal interest in conflict with the companies. And that's the reasoning that was applied over on page at 16 in upholding a first instance decision that there was a conflict. So, but in short, the framing of the issues in the counterclaim, we say, is wrong. At paragraph 484 of our closing, to refer Your Honour to, at least for your note, we refer to other authority which makes clear that the duty doesn't depend on fraud or the absence of bona fides or honesty and good intentions. That's not an answer to a director putting himself in a position of conflict.
But your case is not one of breach of director's duties.
Yes, that's correct. That's the point I'm coming to, which is the breach of the director's duties can be relevant, but not an essential element of an unfair prejudice petition.
And the corollary, breach of director's duty in the sense you've put it, doesn't necessarily lead to conducting the company's affairs unfairly. Yes,
but the point is that if you look, which I'm going to take you to now, the authorities in this area on unfair prejudice, they repeatedly established that conducting the affairs of the company like this is sufficient to find unfair prejudice. So H115,
right.
This is a statement of basic principle in Hollington, first of all, at the bottom of the page. This is 766. So the final paragraph, it's clear that deliberate diversion of the company's business by those in control of the company to another business owned and controlled by them is capable of amounting to unfair prejudice of the shareholders who have no interest in the other business. This is a classic example of conduct which excludes the minority from full participation in the profits of the company.
Yes.
And really that's a pretty neat encapsulation of what it is we're alleging. But if we go over the page, there's reference to the Scottish Cooperative Society case and a large extract from that if we can go down to it. So the Scottish Cooperative case, I've summarised the facts of this in paragraph 488 closing. But in short, the society is the majority shareholder of a company. It attempted to purchase the respondent minority shareholders at less than their true value. And when that didn't work, they then adopt a policy of directing supplies of materials that had previously gone to the company to a new department within their own organisation.
Right.
And that then reduces the value of the respondent shares. And then this extract from the judgment says, what's the position of the nominee directors here? Under the articles, it refers to the basis of their appointment. So there were 3 nominee out of 5 directors, and they assumed their role. The nominee directors were therefore directors of both companies. And this is 6th line down. The nominee directors can do their duty by both companies without embarrassment if everything was in harmony. But as soon as the interests of the 2 companies were in conflict, the nominee directors are placed in an impossible position. And then 2 lines below where it cites the Lowry case, it says, when the cooperative society determined to set up its own department, competing with the business of the textile company, the duty of the 3 directors to the textile company was to do their best to promote its business and to act with complete good faith towards it, and in consequence not to disclose their knowledge of its affairs to a competitor. And then 1 line below the Hivac case, says it's plain that in the circumstances, these 3 gentlemen could not do their duty to both companies, and they did not do so. They put their duty to the cooperative society above their duty to the textile company, in the sense, at least, that they did nothing to defend the interests of the textile company against the conduct of the cooperative society. They probably thought as the nominees of the cooperative society, their first duty was to the cooperative society, in that they were wrong by subordinating the interests to those of the cooperative society that conducted the affairs of the textile company in a manner that was oppressive to the other shareholders. And then in this case, it points out that it is said that the three directors were at most only guilty of inaction by doing nothing to protect the textile company. But the affairs of a company can, in my opinion, be conducted oppressively by the directors doing nothing to defend its interests, when they ought to do something, just as they can conduct its affairs oppressively by doing something injurious to the interests when they ought not to do it. And then it refers to how nowadays this would fall to be cited under section 994. But in that context, even non-action in the event of a conflict can be unfairly prejudicial conduct. And we say that this is a much more pronounced case in which the claimants are active participants in conduct which has been harmful to the company. And there are other thoughts.
Are you going to come before you finish to what the conduct was?
Yes. But just to give another example, there's a case, Cook and Deeks, I refer to paragraph 491. The directors there are...
Sorry, which paragraph which paragraph?
This is 491 of my closing.
Yes, thank you.
The case itself, for your notice, is H70, page 10.
Thank
but
you.
the directors and shareholders of a construction company are the defendants. The claimant is also a director shareholder. So everyone, like in this case, are director shareholders. The company had previously carried out work for the Canadian Pacific Railway. The company did that work. It continued to tender. It was successfully awarded subsequent contracts. And those contracts came to be all that the company did. What happens is that the parties then fall out. As the fallout starts, the company had tendered for and won already another contract from Canadian Pacific. But whilst performing that contract, the defendants become aware of another upcoming project. And what the defendants do is they enter into a contract on behalf of the new company that they've set up, which had excluded the claimants. So that's a company called Dominion Construction. And if we go to page 10, the point of principle, the second paragraph, it's quite right to point out the importance of avoiding the establishment of rules as to directors' duties, which would impose upon them burdens so heavy and responsibility so great that men of good position would be hesitate to offer. But on the other hand, men who assume complete control of a company's business have to remember they're not at liberty to sacrifice the interests which they are bound to protect, and while ostensibly acting for the company, divert in their own favour of business which should properly belong to the company they represent. And in that set of circumstances, the defendants were guilty of a distinct breach of duty. And similar lines, this I'll just refer Your Honour to it, but I refer to the case of Vidori Plumbing, as well as this as an Australian authority in my closing submissions. But the same points and the same principles all apply, where the directors are putting themselves in a position where their personal interests have conflicted with the company's interests, such that it leads to the diversion of opportunities, or in the case of Vidori, it's about the diversion of the goodwill of the old company to the new company, which the directors had set up and sought to exclude someone from.
Was that a breach of duty, breach of director's duty?
Yeah, so yes. Well, it was an unfair prejudice case.
Right. So which case is this? This is
Vidori. So it's at H84.
H84?
Yeah. So
and which
three business partners
of your submissions is it in?
I will dig that up. I'll just take Your Honour there, and I'll give you the paragraphs briefly.
Right. Yeah, take me to it. Yeah.
So H84, page 31, but it's three business partners. Two of the three set up another business. Once the original company's business has ceased, one of the shareholders brings an unfair prejudice petition, the allegation being that the former business of the company was transferred to the new business, including all work in progress and goodwill.
Yeah.
So paragraph 161 it says the directors took it upon themselves to decide how the assets and business of the company should be disposed of.
Right. And
failed to turn their minds to the question of whether any value could be derived from the benefit to the shareholders of the company. And that makes the same point at 162 about the irrelevance of motivation or bona fides. If we keep going to 164, it makes the same point about applying objective facts. If we go over the page to 34, 176. by taking it upon themselves to determine what was to happen to the business and assets of the company without regard to the shareholders' position. And this is Mrs. Vidori's position. It seems to me there was a clear breach of Section 232 of the Act. And at page 35, 184, setting up business or diverting business from the company to companies in which the oppressor has an interest, but the applicant does not, has been recognised as conduct capable of constituting oppression. And that then refers back to some of the cases we've looked at, like Scottish Cooperative. And it refers at 185 to an extract from Bright Pine Mills, which is a Supreme Court of Victoria case. And it says that a director of a company is obliged at all times to act in the interests, in the best interest of the company and its shareholders, and to refrain from making decisions without regard to the interests. And in order to divert what otherwise might be profitable enterprise to another concern, particularly to one in which he himself is a proprietary interest, refers to the real purpose of his action being to prevent a minority shareholder from participating in that profit. And then over the page at 36, paragraphs 186, refers to other Australian authorities in which diversion of business finds an unfair prejudice petition. And I won't go through the rest of the detail of that, but the point is that the breach of a duty not to put yourself into conflict and acting contrary to the interests of the company by accepting an opportunity which ought to have been put to the company of which you're a director can find an unfair prejudice claim.
Yes.
So the claimant's analysis of the case we say is wide of the mark. So if directors of a company are simultaneously acting for another company, they operate under a duty not to place themselves in a position of conflict. The diversion of existing lines of business or future business opportunity that otherwise would have been generated in this context to the goodwill of Health Insights Dubai would have been a breach of the no conflict duty, and it's irrelevant whether they act in
what is
good
the
faith
business
or not.
they diverted?
Yeah. So the first and fundamental point is how Health Insights Dubai generates its revenue. This really gives rise to the irreconcilable contradiction in the claimant's case. So they say the claimants own both MCC and Medica Plus. The defendant's case is that Health Insights Dubai owns Medica Plus and is the licensed distributor of Medica Cloud Care in Saudi Arabia and the UAE. But in either case,
sorry, now this where I've got to understand your case. Your case that HI Dubai does not own MCC.
Yes, but it is the licensed partner reseller. It possesses a license to sell.
License from who?
Well, the way that the license operates is that the ownership is with Mr. Shehata. Mr. Shehata licenses Health Insights Asia.
So all of this depends upon proving that Mr. Shehata owns the copyright, that it has been legally assigned to HI Malaysia and a license has validly been given back to HI Dubai. So you then have to prove that Mr. Shehata owns it, don't you?
No, we say that we don't.
Why not?
Well, there are two ways to the analysis. One, we assert, both parties assert, however you get to the answer, that the party that is licensed to commercially exploit MCC in Saudi Arabia is Health Insights Dubai.
No,
that's
but you've
consistent
denied
across
that.
both parties' cases.
But
no,
the claimant's case, I'm sorry, I can't get hold of this. Fundamentally, you've spent most of your submission saying that HI Dubai has no rights, does not own the copyright.
Does not own the copyright, but is licensed to commercially exploit the license to MCC within Saudi Arabia and the UAE.
But the claimant doesn't accept that. The claimant's case is that HI Dubai owns the copyright, not that Mr. Shehata owned it, who's transferred it to HI Malaysia, and HI Malaysia has licensed HI Dubai. Claimant doesn't accept that.
No, I know that. The point we make is that whichever analysis is correct, the entity which is entitled to exploit the markets that we're dealing with here, so Saudi Arabia and the UAE, is Health Insights Dubai, whether it's by virtue of a license or whether it's by virtue of ownership.
Well, you've urged me not to accept the claimant's case, so that's taken out that right. And if I'm not persuaded that Mr. Shehata owned it, then the conclusion I come to is HI Dubai has no right to license it. Isn't it?
Well, no, because one has to look at the evidence of how the business was operated as being evidence of how as a matter of fact, MCC was commercially exploited, and really that's the core evidence,
But
which we refer Your Honour to.
I'm struggling with this. I think it's common ground. I think it seems to be the case that up until a certain point, HI Dubai was, use your expression, commercially exploiting it. It was licensing the software, but at that point, the claimants believed that HI Dubai owned the copyright. Then, as I understand the evidence, then it all comes into issue. And if I conclude they didn't own the copyright, and if I am not persuaded that Mr. Shehata owned it, then they could not have licensed it to Al-Khalij or anybody else. I think, aren't you in effect inviting me to, first of all, find that HI Dubai did not own the copyright? And in saying that, you want me to look at the legal basis, not the basis on which people acted, because it seems to me the way there's much to be said for the argument that everybody acted on the basis that HI Dubai had the right to the copyright, but you have spent considerable time telling me that I must look at the legal basis for copyright and entitlement to it, and that HI Dubai doesn't have it. So I cross out HI Dubai does not own the copyright, and then if I'm not persuaded that Mr. Shehata did, and therefore I'm not persuaded that there was any legal assignment to HI Malaysia or any right for HI Malaysia to license HI Dubai, I'm left with the position that HI Dubai had no right to license it. The fact that people had operated for some time on the basis that they did doesn't overcome that problem, does it?
Well, we say it does because we say that there's evidence both direct of the license being granted, so that's the licensing agreement, but also then the indirect evidence from which you should infer that the license was given, and that is the fact that Health Insights Dubai, over the course of it will be since
you mean license given by HI Malaysia?
Well, we say that the license originates from Mr. Well, sorry, there are two things. When it comes to Medica Plus, first of all, and really this is a cut-through point, Medica Plus, its common ground, well, we think its common ground is owned by Health Insights Dubai. Health Insights Dubai, through its...
I thought you didn't accept that. You do, sorry.
Medica Plus, yes.
Medica Plus. Yes, yeah.
Sorry. Medica Plus, by its implementation of Health Insights Dubai, by its implementation of Medica Plus, through to and up to 2019 and 2020, has generated the benefit of these contracts and goodwill, which are then extended. And once MCC is ruled out, Health Insights Dubai continues to be the entity that does that. As we say that from the factual circumstances and the long history of dealing, the business lines, so that is the benefit of the contracts and the business relationships with Al-Khalij in these circumstances is part of the goodwill. It is part of the established business of Health Insights Dubai. The evidence that we point, Your Honour, towards has a number of sources, but one is, I'll give you the reference to it. One is the contracts. Two, it's the annual revenues which are recorded in the financial statements. Three, it's all of the contemporaneous evidence.
But supposing I'm persuaded that up until whatever the date was, Al-Khalij contracted with HI Dubai and paid HI Dubai, but then at some point Albulaihid stopped dealing with HI Dubai. And as I understand your case is, that then involved a diversion of business from HI Dubai to HI Egypt. And that is, the claimants should have caused Albulaihid to contract, or you would say continue to contract, with HI Dubai but they could only do that if HI Dubai had the right to grant a license. So I then have to find, did HI Dubai have a right to license? It doesn't matter what had happened in the past, surely.
Well, Your Honour, just to make sure that we're dealing with the proposition from the same standpoint, because the point you make now would apply, or the point you made earlier with respect to the strict obligations when it comes to conflict, and whether potentially it means that
yes,
that the affairs of the company are being managed in a way which is unfairly prejudicial, is obviously relevant here. You know, that has to cut both ways. If that applies on the claimant's case, it applies in the defendant's case.
But your case is not one of breach of director's duty. Your case is one of conducting the affairs of the company unfairly.
Yes, and if one is taking what is decades worth of, even if you just narrow it down to decades worth of business goodwill, and the assistance of prior contracts, the administrative organisation that goes into the implementation side as well as the licensing side, all of that business is stopped. There's a hard cut-off at the end of 2021. Not a single payment, despite years upon years of millions of dollars of revenue flowing to Health Insights Dubai, suddenly stops. The value in the company goes from being a profitable business, returning and paying distributions year on year, to paying shareholders nothing.
But if it stops because HI Dubai does not have the right to license the software, that's a complete answer, isn't it? Or are you saying the directors must cause Albulaihid to enter into a contract to take a license from an entity which does not have the right to grant licenses?
This is, I mean, this is the particular audience. The point that we would refer Your Honour to, in particular in this context, is when you look at what the claimants have actually done, is not that they are saying that they're diverting the revenue to an entity which actually owns the license or that actually owns the IP. The evidence that's actually before the court is that, and I can give Your Honour the references to it, the evidence actually before the court is that the substantial payments that have been made, in at least based on the documents that have been disclosed to us by Albulaihid, have been paid to Health Insights Saudi Arabia. Health Insights Saudi Arabia didn't exist until 2024.
But your point is not who they've diverted the business to, but that they've diverted away from HI Dubai. And again, you've been telling me it's an objective test. And if HI Dubai had no right to grant the licenses, I'm struggling to see how business has been diverted away from it.
But that's not what the claimants have come to the court asserting that Health Insights Dubai does own the IP and the licenses. But what they have nevertheless done.
If I find their case and reject yours, then you're halfway there on your diverting a business case. But you've told me to reject that case.
But it applies anyway, because
I can't sort of do it one way and then swap over, can I? I can't on the claimant's case find you've not proved that HI Dubai owned it, and then when I come to your counterclaim say, oh well, the claimant said HI Dubai owned it, so I go forward on that basis.
But it's not. It's not for the reasons of the authorities I took you to earlier. The unfair prejudice position is not preconditioned on there being some underlying proprietary interest.
No.
There is more to it than just the IP ownership. There is a long history of contracting, which in itself has value, and business relationships, which in itself has value, which has been reduced to nil because, and this is the important thing. So if you take the way in which the company's affairs are being managed, the claimant's stated position in this case is Health Insights Dubai owns the IP. Nevertheless, the position that they have taken, and notwithstanding the decades of revenues flowing from Al-Khalij to Health Insights Dubai and distributions being paid on that basis, have taken steps to direct Al-Khalij not to make any more payments to the company. Full stop. That was a direction issued in August 2022.
But you've told me, I understood you took me carefully through some cases to make out it's an objective question. If their motives were bad and they were, wrongly acting towards HI Dubai, that doesn't get you there.
Well, the point is that it's not conditioned on the ownership of the IP. There are different ways. There are different ways in which Health Insights Dubai can be entitled to generate this revenue, and has in fact generated this revenue over the course of many years. And what has happened objectively,
but in a way, it had no entitlement to. If I find that HI Dubai did not own the copyright, and if I'm not persuaded that Mr. Shehata owned it and licensed it in the way you've said, then it leads to the conclusion that HI Dubai had earned all that revenue by licensing something which it had no right to license.
But we would submit that there's no basis on which Your Honour could make that finding on the facts.
Right.
And just it's one thing to say that I don't accept your analysis and I don't accept your analysis, but it's another quite apart from that to say that the evidence doesn't establish that Health Insights Dubai had the rights in some way to economically exploit NCC. I mean, that's the basis on which the company has been run since effectively its inception. The contracts that were entered into, which we refer to in our closing from as early as 2005, are all contracts entered into by Health Insights Dubai. Those are contracts which concern the exploitation of Medica Plus, which is owned by Health Insights Dubai. I mean, if putting it in other terms, the commercial opportunity that opened up to deploy a new piece of software that is MCC, regardless of who owned it, is a commercial opportunity that was generated off the back of the goodwill of Health Insights Dubai, implementing a software system which there's no dispute it owned. And for one to have that position where the shareholders of the company, and this is just looking at it in objective terms, the shareholders of Health Insights Dubai have been drawing millions in distributions, and we've got all of the evidence of that. The company has been generating millions in revenue. We've got all of that. And what happens is that the claimants bring about a scenario in which the revenues go from being such that it is a profitable business to no payments whatsoever being made by Al-Khalij to Health Insights Dubai after 2022, accrued debts for the period prior not being paid by Al-Khalij, so that's the amount of 5 million, to business being clearly diverted. Because we've got the bank statements for Health Insights Saudi Arabia. Health Insights Saudi Arabia over the course of 6 months.
Apologies for interrupting. We are now 16 minutes past the break.
We have.
I'm afraid it's been going well over time.
I just looked at the clock. You're right. Mr. Doe, you think you better wind up? We'll give you a few minutes, no more.
Yeah, I'll wind that up. Health Insights Saudi Arabia are, as a matter of fact, now receiving those amounts of money from Al-Khalij. The only way that could have happened is, well, I mean, Health Insights Saudi Arabia, first of all, cannot own the IP in NCC because Health Insights Saudi Arabia did not exist until 2024. The fact that the money is now being paid to Health Insights Saudi Arabia rather than Health Insights Dubai means that we say there is direct evidence of a diversion of an income stream that previously went to Health Insights Dubai, which has now gone elsewhere. and that the claimants, in deciding to manage the company in that way, have taken business which was both previously Health Insights Dubai's and opportunities which should have become Health Insights Dubai, so that's where there are new hospitals, and they have siphoned off that business from the company, resulting in the fact that Mr. Shehata does not derive any value of his shares and has not received any distributions, and has caused that revenue, that income, to be paid to another company, which can have no conceivable basis to claim ownership of IP or a license to economically exploit IP, and which they together own to the exclusion of Mr. Shehata. And when viewed objectively, particularly in light of the case law I've referred Your Honour to, in which both in these oral submissions in which were set out in written closing, that is objectively conduct which is management. It's about the conduct of the affairs of the company. It is prejudicial to Mr. Shehata because he's gone from having a valuable shareholding to shareholding that's worth nothing, and it's unfair because the way the business is being managed is to his exclusion. And I make the final point that that's not the only basis on which we assert unfairly prejudicial conduct. This is, we also say, one of those cases where there is a legitimate expectation in the involvement of management. So this is one of those quasi-partnership cases where everyone's a director shareholder, and since its inception, Mr. Shehata has been involved in the management of the company. And there's a long line of cases that it says, regardless of anything else, generally the exclusion of someone who's got a legitimate expectation to be involved in management of the company is conduct which can sensibly find an unfair prejudice petition. And all of the underlying facts I've referred to in quite a lot of detail in closing. So that's on who owned the contracts, on where the payments went, on the revenues, and so on. So Your Honour has all of that.
Right. All right. Thank you.
Sorry, there's one other point which I'll deal with very shortly because this is dealt with in writing, and it's the last point I said I was going to address Your Honour on, which is the how Your Honour should deal with the claimant's approach to do their disclosure obligations. Now, we set out extensively why their disclosure obligations were breached, the fact that they were on notice that Your Honour would be drawing adverse inferences if they didn't correct that, and the nature of the documents being such that we're looking at underlying contracts with healthcare institutions, documents which show the transfer of payments, documents which show the communications exchanged between the claimants. None of that is disclosed. And to the extent, to deal with the point Your Honour was addressing earlier of, well, what am I to do if I can't find positively for either of you on this? We say that given that wholesale and extensive failure to produce documents which were clearly relevant to this issue, Your Honour should be drawing adverse inferences that those documents would have supported the claimant's case, the defendant's case.
All right. All right. Thank you. So I've let matters go beyond the time that we specified. Might we allow half an hour for lunch and resume at say 5 minutes past 2? Is that not inconvenience either of you?
Perfect,
I'm sorry to the court staff. I'm only giving you half an hour, but I think it's better than we finish too late. So we'll resume again at 5 minutes past 2. Thank you. Yes, can you all hear me?
Yes, thank you.
All right. Mr. Montague-Smith, do you have any instructions on the defendant's application to reopen and admit the letter from Raja Reza and Associates?
I think I'm instructed to resist that.
Okay.
And the primary basis, and I'll come on to what I say about statements about Health Insights Egypt in due course, is that it's not material. But anyway, I don't want to give the impression that we're afraid of it. But
I can deal with them that now. So the application was by the defendants to reopen their case, to tender into evidence the letter of 16 December 2025 from Raja Reza and Associates to Subang Jaya Medical Centre, in which the lawyers on behalf of Health Insights for Software Solutions made a demand to cease and desist from authorised use of the Medicare Cloud Care software owned by Health Insights for Software Solutions. The court has power and jurisdiction to reopen and permit it to be put into evidence. The primary considerations are, on the one hand, finality, and on the other, fairness. The court must have regard to the relevance of the document, its materiality, whether it was available earlier, and whether there's any prejudice to the claimant. In this case, I'm satisfied that it's relevant but not sufficiently material. It's not sufficiently material because Mr. Doherty, in his submissions, told me that it is that there is other evidence that Health Insights for Software Solutions have asserted that it owns the IP rights to the Medicare Cloud Care software. So the evidence is cumulative rather than being sufficiently material in this case. So I will refuse that application, will not receive it in evidence. Mr. Montague-Smith.
Thank you, Your Honour. All right, I wanted to focus in my reply, if I deal with the reply first and then come on to the counterclaim with your permission.
Yes.
I wanted to focus on the issue of ownership in the main. I'm going to have to move at a fair clip to get through the points because there's quite a lot of new points raised by my learned friend. And it's slightly surprising, we've had 200 pages of written submissions, but then he raised a whole load of new points about things that I have to prove but haven't proven to establish ownership. And I'm a bit concerned that Your Honour has quite the wrong impression of the legal framework because of the way it was presented to you. But just dealing with this, Your Honour asked the question, do I really need to decide the issue of ownership at this stage? Can I just remind Your Honour of how this arose? If we can bring up, please, bundle F2, F-tab 2, page 14, and it's paragraphs 71 and 72. Now, if you recall, I invited Your Honour to deal with this liability aspect, if I can put it like that, on a Part 8 basis, on the basis that it didn't involve any disputes of fact. My learned friend's position, my learned friend's position, which Your Honour accepted, was that the question of whether or not, so it's paragraphs 71 and 72, was whether or not Health Insights Dubai had an ownership interest could affect the question of whether or not the assignment agreement ought to be set aside. Now, and you deal with it onwards from there. Now, that was one of the reasons why it was said that it was not appropriate for the Part 8 process, and Your Honour accepted that, and that is why we've gone on to deal with that issue at some length, and it has, to be frank, become the central issue in the proceedings. Now, if Your Honour reaches the conclusion that you cannot decide one way or another, and it has to go on to the next stage, then so be it. In principle, you also asked the question, could there be further evidence? In principle, the parties could submit further evidence for consideration, but obviously the evidence so far would also be admissible. However, we do say that there is plenty of evidence for Your Honour to go on here, and I mean, we've set it out in our written closings, but really the framework, the legal framework into which it fits, has, we say, been pretty comprehensively mischaracterised. It may also be the position that Your Honour has to consider the issue for the purposes of the counterclaim, but I'll come back to that at that stage, if I may, because it may be Your Honour just says, actually, I can dispense of the counterclaim in one of a number of different ways that we invite you to do so without ever actually getting to the question, well, was there any right in the hands of Health Insights Dubai to use this software in the first place? My learned friend, in his submissions, rather try to dodge the question, but it must be right that he is running two inconsistent cases, because on the one hand he's saying Health Insights Dubai did not acquire ownership through the process of development, and then if you don't accept Mr. Shehata's evidence that that is how they acquired a right to use the software, then there's no other candidate for how they have a right. And actually, the focus of my own friend's submissions, most of it, certainly yesterday, was not to say Mr. Shehata has the ownership. It was to say, well, you haven't proven that Health Insights Dubai has the ownership. It could be someone else. It could be Health Insights Egypt, could be Al Khalij, it could be all of the individual developers who actually did the work. And if any of those conclusions were reached, then the counterclaim doesn't, or at least large swathes of the counterclaim don't work at all. But just taking a step back, the dispute at trial was essentially factual. How, in fact, was MCC, Medical Cloud Care, developed? Now, we've set out at length, both orally and in writing, why our factual case, we say, should be preferred. But and in his submissions yesterday, my little friend didn't really address that position. Today, he rather resorted to mischaracterizing the evidence quite significantly. So in relation to the video, for example, he persists in calling it a demo. He persists in saying that because these are C# files, ... the implication that he's inviting you to reach is that these files somehow made their way into MCC. He persists and he's, for the first time actually, called it cloud-based, the demo. Now, none of those things are true. And how do we know that? Mr. Shehata himself accepts it. That was a Silverlight program. Silverlight is obsolete, according to Mr. Shehata. He said it himself. None of those files made it into the software. And if you want to check that, you can go through the file listing in I2 and you can see none of those files are in there. It was a dummy. But he nevertheless persists because that's all he's really got. In relation to the spreadsheets at E83, you'll recall those spreadsheets for development. Those are about, they describe themselves as Medica Plus development progress reports. And my own friends denies that they're about development, and I would invite you to browse through the attachments to the email at E83. If we could bring up E83.4/1, for example, we can see a spreadsheet there, which is a submission by Mr. Adel Al Nasser. And if you go down to the bottom, scroll out, please, a bit, yeah, and scroll to the right so we can see it. I don't think this is quite the one. It's E83.4/1. Well, there we are. Oh yes, if you look at the top right, for example, you can see pharmacy IR under development using HTML5. You'll see that this spreadsheet is littered with statements to that effect. And I won't repeat my submissions as to how we say this just has to be what the witnesses says it was. Now, my learned friend says that was pure assertion, but what he didn't do was actually challenge those assertions with the witnesses. Now, I'm not going to go back through all of that evidence, but that there is abundant evidence about how it was developed. You don't need to see the source code. What would you get from the source code? What could this court look at that? What you have, individuals who say this is what we did and this is what was going on. Now, before this dispute erupted, Mr. Shehata made a series of admissions that MCC was owned by Health Insights Dubai. As we know, he registered MCC in favour of HI Dubai with Interoco, and although he now denies it, it's clear that those certificates cover the whole of MCC. And in these proceedings, he admits that something was transferred under the terms of the assignment agreement. Something was transferred. That's day 7, page 169, lines 16 to 18. Now, he said it was just a few modules, but that means that he is implicitly conceding that at least some parts of MCC were owned by Health Insights Dubai, and there was some interest assigned. Now, that may be enough for present purposes, for the purposes of the set-aside, but we do say that you can decide, actually, that HI Dubai owned it. Now, my learned friend challenges me to explain precisely how ownership arose. But as I've explained, his client was in charge, Mr. Shehata was in charge of the company. The evidence that we rely on is to the effect that he removed all the records. His client's the only person who could explain why he said repeatedly and in documents that Health and Sites Dubai owned MCC. Instead, on our case, and again, I won't go back over the evidence, but we say he has chosen to give dishonest evidence, pretending that he was the sole author of the software, and then falling back at trial to saying that he authored various critical elements. So his case changed. And in all evidence, we say he was simply evasive, made speeches, refused to answer questions, and changed his account repeatedly to try to explain inconsistency. So the court has been deprived, from his perspective, from his side, of an honest account of how this came about. Now, in that context, if we're right about that, and of course those are factual assertions, and of course they're disputed, but we say there is abundant evidence for you to decide that, we say it's not surprising that our explanation is tentative as to how ownership arose. And so we say where a director first claims a company owns the software, then registers that software in the company's name, then purports to sell that software from that company to another company he controls, then falsely claims that he owned it all along, and he removes the documents which might explain that issue, is it fatal that I cannot show you all those documents one by one to say, here is an assignment agreement, or here are the terms under which this team of developers produced this particular software? We say no. There is obviously in that context a complaint that this is really where it comes in, that Health and Sites Egypt claims that it owned MCC as well. And it's, I think, in some ways said I can't run alternative cases, or these assertions are inconsistent, and that somehow evidentially affects the outcome. Our position, to be clear, in these proceedings is that Health and Sites Dubai owns MCC. But Your Honour may agree, or Your Honour may not agree. It's not possible to run the alternative case in favour of Health and Sites Egypt in these proceedings. But until that is decided, it has to be kept open. And statements, so we say that statements by Health and Sites Egypt are irrelevant. They don't go anywhere. They don't take you anywhere. At most, at best, that is effectively hedging, which until everything is decided finally is perfectly acceptable. And once it is decided finally, will be determined by reference to issue estoppel. So why do we say that there is ownership? Well, first, there is abundant evidence that MCC was attributed to Health and Sites Dubai. Now, I won't labour this, but Your Honour said, I think one of your observations just now was, you know, I can see strength or force in the submission that everybody assumed, everybody understood that Health and Sites Dubai owned MCC. And we say, yes, that must be right. Predominantly, Health and Sites Dubai was the party exploiting MCC. The man in charge of both Health and Sites companies registered it with a copyright office, and then he purported to sell it to Health and Sites Asia, and all the other ways that we say registration ownership, was asserted in favour of Health and Sites Dubai. And you'll recall that Mr. Shehata was extremely defensive when it was discovered that the registration of Medica Plus was with Health and Sites Egypt. If we could bring up E160, page 2, you've seen these email exchanges. This is the one that was characterised as threats, and his response to it. He said he'd forgotten all about in his email, E/160, page 2, and at the bottom, top, that's the one. Medica Plus was registered a very long time ago, and so forth. So effectively, he says, don't worry, Medica Plus, it was all a bit overlooked, but don't worry, because MCC is being registered. And it's quite clear from the context that he's saying in favour of Health and Sites Dubai. Now, he's tried to explain this away by saying this was a response to threats, and we've said that explanation is false, and that is something that Your Honour can take a view on. Because even if you characterize what was said as threats, they came after, they came before, after the promise to register, the statement that we're in the process of registering. They come on the page previously, which is the responsive email. So the inference is that there's some other explanation for why he's doing this, and the obvious explanation that is he knew the facts which gave rise to Health Insight Dubai's ownership, and that, we say, is enough. Now, in his recent submissions, my learned friend effectively supports that at least logical approach in his submissions. He says, well, you can conclude that Health Insights Dubai was entitled to exploit MCC because that's the way it had been operating for decades, was effectively his submission. But that's essentially, at least in part, what my case is. But in any event, we say there is a presumption in favour of the person to whom the work is attributed. Now, you were shown the focus of the submissions was on the old law under the UAE law. There was a little bit of reference to the Egyptian law. I think everybody agrees that it is the UAE law which applies, but there's a difference between us about whether it's the new law or the old law. My learned friend says it's the old law. We say it's the new law, and I'll explain that in a moment, but it doesn't matter for these purposes. Can we bring up H16, page 2, please, which is the old law? And you will see there the definition of the author is the person who creates the work and the person who has his name mentioned on the work or has the work attributed to him as its author at the time of publication unless proved otherwise. Now, the effect of that, according to Mr. Hansen, which is the textbook that was produced rather recently, if we go to bring up page H116, H tab 116, page 4. And if we scroll down, please. That's fine. Yeah, sorry, down we go. Sorry, scroll down, please. Just clicked on the wrong button. Bear with me. Sorry, my highlighting is not on this page, it's on my page, so I don't want to waste your time with reading other bits. Yes, here we go. So at the top of it, the person who puts his name on a work is deemed to be the author unless proven otherwise. And then we can skip down. He talks about the Berne Convention. And then if you look at about 5 lines up from the bottom of this page, nevertheless, the named author provision is that in the definition of author should probably be seen as creating a presumption of authorship for the purposes of instituting legal proceedings. If the plaintiff's name is on the work, no further proof of authorship need be evidenced unless the defendant can bring evidence to rebut the presumption. And then over the page, please. The presumption also extends to persons to whom the work is attributed upon publication. So that's the old law, and the new one is materially identical. If we can bring up H tab 15, page 3, please. So if you accept that MCC was attributed to Health Insights Dubai, then that is enough. That we don't have to prove how ownership arose. Your Honour can presume it. But if I'm wrong about that, we say Your Honour can infer it as well. Now, we do have a variety of ways in which we say ownership could have arisen under the law. And it's not just as a collective work. But it's in this context that my learned friend introduces a raft of new assertions about the law. So he says, for example, no ownership follows if MCC was derived from Medica Plus. He says it's just a new thing and it's got nothing to do. There's no ownership that transfers across. He says an author can only be a natural person. He says that collective works can only be directed by a natural person, that direction needs to have some creative quality and various other things. He says only source code is protected, so it's irrelevant whether the code is the product of other work. Now, all these points are new, and we say all of them are either wrong or irrelevant. If we start from the beginning, Your Honour asked me on Friday, how do I know that Medica Plus was owned by Health Insights Dubai? And that's been conceded. And I will show you, if you want me to, the various bits of the evidence where that is conceded, but given that Mr. Doherty confirmed it, I don't think I need to do that, but I can give you some references just for purposes in the future. In Shehata 6, we don't need to bring it up, but that's if we look at if for future, Bundle C, tab 4, page 9, paragraph 30. Bundle C, page 4. Sorry, Bundle C, tab 4, page 11. Under the heading, it says HI Dubai's ownership of M+. Bundle C, tab 4, page 13, paragraph 46. And then in his second witness statement, D, tab 3, page 10, paragraph 29, Mr. Shehata says, I transferred the rights in M+ to HI Dubai. But my own friend has said, yes, on Friday, that the rights were, quote, assigned. That's the case. We've not seen the assignment. We've got no particulars of the assignment. We don't know the when and the where of it, but you can accept that that is what happened, and we have the presumption as well. Now, it was agreed in the evidence that Medica Plus went through continuous development after Health and Sites Dubai was established. So the source code in 2016, when we get to this process that we say is upgrading effectively, or it's translating, perhaps is one way of putting it, is not the same as the source code in 2003 when it was first registered. There are whole modules that are new, but existing modules have also changed. But there's no debate that all of that belongs to Health and Sites Dubai. So where does that all take us on Medica Cloud Care? And we say essentially the upgrade to MCC is essentially the same thing as everything that had gone before. So just as everyone accepts that when modules were added between 2006 and 2016, those belonged to Health and Sites Dubai, there's no reason to make a distinction between what happens next. Now, it's here that my learned friend makes submissions that are flatly wrong about the applicable law. We agree that UA law is likely to be the applicable law. We can dig out, if you need them, the relevant bits of DICE which would support that, but the parties agree on this. So there's no need to look at it. So which one applies, the old one or the new one? My learned friend was extremely cagey in the way that he dealt with this. But in fact, the 2021 law had retrospective effect, and we see that in cassation case, which you'll find at bundle H122. We could bring that up, please. Bundle H122. It's cassation 458 of 2024. And if we go to page 3 of that, if we go to page 2 of that and look at the background. Thank you. You will see that this was about an animated movie. If you can look at the background section, please, at the top of page 2. Thank you very much. You can see it's about an animated movie, and you can see that when you look at that in the claimant had authored a story in 2005. You'll see that in the second paragraph. In 2005, they authored the story of the movie Bilal and presented it to the first respondent for production. The respondents took it and turned it into a movie, which was then published in 2015. So you see that in the final paragraph of the background. And then on page 3, so this is those facts occurred before the new law came into effect. And then page 3, second paragraph down, the court noted that the contested judgment was reserved for ruling on 19th February 2024, and the 2021 law had come into effect on the 2nd of January 2022. Therefore, this new law was applicable to the case before the Court of Appeal before the closing of pleadings, necessitating the direct application of its provisions to the facts and subject matter of the case. So you had facts that predated the new law, but because the decision and the pleadings weren't closed before the new law came into effect, and then the case continued in effect after the new law came in, it had to be decided in accordance with the new law. So it has retrospective effect. Now, in fact, we say it doesn't make much difference, but I will show you the relevant parts. The new law is at H15, and if we could go to H tab 15, Page 18, please. Thank you very much. Now, you asked the question, Your Honour asked the question on Friday, if an employee creates a work in the course of his employment, does that belong to the employer? And the answer you were given was no. That is wrong. If we look at Article 28, subparagraph 2, if an employee or worker during his employment creates a work related to activities or business of the employer that is directly or indirectly mandated by the employer, or uses to reach the creation, expertise, information, tools, machinery, and so on of the employer at his disposal, the author's economic rights shall be attributed to the employer, taking into consideration the intellectual effort of the workers. So 28.2 says that in terms. 28.1 is also important. If an author makes an innovation in favour of another person, the copyright shall be attributed to such person. So that's why now, these are just, if I can put it like this, rules of attribution made express in the new law. So this is one of the points that's made, and I'll come on to it, is it said, well, only a natural human being can be a creator. Only a natural human being can be an author. My own friend said that in terms. Now, the original law will come. I'll show you back to it. It doesn't have express rules of attribution that we see here, but that doesn't mean nothing can be attributed to the employer. So the innovation in the new law is simply to make solid, particular and discrete rules of attribution. You want to also ask the question, well, if this is a derivative work, doesn't that mean the original owner continues to own it? And again, the answer to that question you were given was no. And again, that answer is wrong. If we just scroll down the page, please, to Article 29, you will see under the heading co-author, subparagraph 2, Article 29.2, if the work is derived or extracted from a previous work, the previous work author shall be deemed a co-author in the new work. So pausing there, if, as we say, MCC is derived from Medica Plus, then Health and Science Dubai is at least the co-author of MCC. But as we've seen from Article 28.1, if we could go back to that, please. If the innovation which distinguishes MCC from Medica Plus was made in favour of Health and Science Dubai, then that innovation will also be attributed to Health and Science Dubai. Now, just going back to Article 29.2, this point that derivative works carry with them the ownership interests of the author, that also appeared in the old law. Could we please bring up Bundle H, tab 16, page 11? Thank you very much. And it's Article 27. We scroll down and see as much of that as possible, please. And you will see Article 27, a joint author in the audio-visual work can be 1, 2, 3, 4, 5, and then underneath 5, in case that the work is derived or extracted from a previous work, the author of such work will be a partner in the new work. So if you accept that MCC is derived from Medica Plus, then Health and Science Dubai is at least a joint author. And if you accept that the conversion, the innovation, was done for Health and Science Dubai's benefit, or in favour of Health and Science Dubai, then Health and Science Dubai was the sole author. Now, we say this innovation, this change to cloud-based system was obviously done for the benefit of Health and Science Dubai. Why do we say that? Why? Because it was upgrading Health and Science Dubai's software, Medica Plus, and because Health and Science Dubai paid money for it. They paid fees, Health and Sites Dubai paid fees to Health and Sites Egypt for software development. And my learned friend tried to minimize this, but every year Health and Sites Dubai paid Health and Sites Egypt fees for software development. So in all of the accounts, we can see that, but we cannot see the documents underlying it because we don't have them because they haven't been produced. So if we bring up E86, tab 86, page 21, please, we see accounts that cover the relevant period or refer to the relevant period. And if you see revenue at the top there, and then underneath revenue, cost of revenue, software development in Egypt for the year ending 2017 and for the year ending 2016. So now my learned friend says, we've got no evidence of what these are for. That was his submission. And that is simply not true. You can see it in the accounts. This was for software development. Why do we know that? Because the accounts say so. It says software development in Egypt. In Egypt means that it was paid to Health and Sites Egypt. That's essentially conceded. Why? Because Mr. Shehata accepts that the money was paid to Health and Sites Egypt, but he says it was for something else. He says it was for integration and training. And that was day 6, page 120, lines 15 to 18. So, and that was repeated by my learned friend in closing. That was day 9, page 189, line 11 to page 190, line 10. So it's accepted that this money, entitled Software Development in Egypt, was paid by Health and Sites Dubai to Health and Sites Egypt during the relevant period. And then the question just goes back to the what does the evidence show? Does it show that this was for development? Or does it show, as my learned friend suggests, that this was for integration and training? And we say plainly it was for development. It says so in the accounts. There are other documents which help you determine this as to the general nature of the relationship between the two companies and what these sorts of things refer to. So I won't have time to take you there, I'm afraid. But for example, we have the 2004 tax audit, which was a report. There's a report at Bundle E, tab 105, page 45, which is dated 2020. So at a time that Mr. Shehata was in charge. And if you read that report, you will see that what it is dealing with, what these fees are dealing with, is fees for development of software. It says that in terms in a report which was issued by Health and Sites Egypt at a time Mr. Shehata was in charge of that company. And it says that there are other documents available which show precisely what it's for. We are missing those documents, but the thrust of it is 100% clear. Health and Sites Egypt developed software in the relevant period and was paid fees by Health and Sites Dubai for doing so. Now, if the defendants wanted to show that these payments were not for development, they could have produced the documents which would have shown precisely what these payments were for. And it's not surprising that these fees were paid every year. Why? Because, as I say, M+ was being constantly upgraded. Health and Sites Egypt was carrying out all the upgrading and developing of M+ prior to this and after this. It was all development. And the amount is irrelevant. If you accept that this is for development, then the upgrade of MCC is the only development anyone is saying happened in this period. Nobody's saying there was something else being developed. So this is essentially clear evidence that the development that took place, if you accept my factual case, of course if you don't, then it's different. But if you do, that work was development work that was going on, that it was upgrading Medica Plus from Medica Plus to MCC, then this shows you that those were payments, that was pursuant to payments being made by Health and Sites Dubai to Health and Sites Egypt. Now, you'll recall Mr. Shehata produced the purchase order saying that was work for hire. And that, now my learned friend, you asked my learned friend some questions about what that was all about. And he wasn't really, he struggled to answer really, because there's no coherent way that he can account for that purchase order anymore, because the purchase order was produced to demonstrate that Health and Sites Asia owned the software. And implicit in that explanation was that because it was work for hire, then what that meant was that although Health and Sites Dubai did the work, Health Insights Malaysia owned the work product. Now, that doesn't make any sense for a variety of reasons, but implicit in that is the acceptance that work for hire confers ownership on the person paying for it. And it demonstrates that Mr. Shehata understood that position because he was the one who produced that document. And that is one reason why you can rely on all of his explanations and his statements about ownership to conclude that this did happen, right up until the point when he starts to lie about it, which is when these proceedings start. So it's only if you don't accept that Medica Cloud Care was derived from or based on Medica Plus that we get into collective works. And it's only if you don't accept that the work was being done effectively for hire or for the benefit of Health Insights Dubai on the evidence. If you accept those, any of those propositions, you can find ownership in favour of Health Insights Dubai without ever getting to collective works. And it's in relation to collective works that we get a raft of new points. The first point is that only natural persons can direct collective works. Now, you were taken to this textbook on it. I've shown you a short passage of it. My learned friends told you it was an academic text, and I'll show you it in a moment. It's not an academic text. That's not true. He's telling you something that's not true. It was written by a partner in law firm. And if you look earlier in that book, you will find that the partner in the law firm started his practice in the UAE in 2003, and the book was published in 2009. So it's the benefit of up to 5 or 6 years of practice in the UAE. It's a practitioner text. It's not an academic researched text. The text itself, if we can pick it up, it's at H116, page 3. And we've already seen this page, but I'm going to focus, if I may, just on the first part of it. This is what the thesis really comes down to here, under the heading authors. He says this, referring to the old law. The old law employs both the concept of a natural person as well as that of a legal person. A legal person is a person created by law, such as a company. And then he says, an author is referred to in the ARL 2002 simply as a person without further qualification as to whether a natural or legal person. And then this is really where it comes to. He says, from the point of view of everyday experience and common sense, authors are always natural persons. Only natural persons can be creative. However, the AIL 2002 gives some special attributes to legal persons. A legal person has, according to the law, the ability to direct the creation of a collective work. In what circumstances this might be possible is difficult to imagine. Legal persons usually have no ability to direct, other than as a result of the decisions and actions of natural persons who are themselves potential authors of directed works. And if we go over the page on page 4, please. Accepts that a publisher can be a legal person. You see that at the end of the first paragraph there. A publisher can be a legal person and deemed to be an author. But then 5 lines from the bottom of this first big paragraph, he says that is impossible. And what he says is, on one view, these provisions require the proving of a fact for which there cannot ever be any evidence. It is a category mistake to speak of legal persons directing works. Now, there's no authority relied on. That's just approached by way of from first principles. He just says, well, basically he's saying, because companies can only ever act through natural persons, companies cannot do things that are human, if I can put it like that. But what he's missing is all of the law of attribution. He misses the fact that this is just about whether we can attribute actions to companies. So, and we do that all the time. We attribute human actions to companies all the time. There's always questions about, what did a company know? Now, on one view, we'd say, well, the company can only know things through its human actors. But it's not a category mistake to say, but now the law will consider that the company knew X, Y, and Z. So, of course, companies can be creative. The question is whether or not those creative acts are attributed to the company, or whether they're attributed to the human being, or both. And as we know from, I mean, Your Honour will know the Meridian Global case, where Lord Hoffman looked at these questions of attribution. And his point was, that's not a metaphysical inquiry. It's a question about interpreting the legislation. the answer to what acts you will attribute to a person or a company depends on what rule you are applying. So that's why it's different. You have different rules of attributing knowledge, for example, to a company. If you're dealing with a claim against auditors, or if you're dealing with a claim against the directors themselves. Did the company know about and acquiesce in the criminal conduct? Well, its directors knew about it. Does that mean the company knew about it? Well, it depends what the rule is that you're applying. And now here, what we're trying to do is seeking to identify who is giving a direction for the purposes of collective works. That's one of the requirements. It has to be directed by the author. Is it the natural person, or is it the legal person who's acting on behalf, he's acting on behalf of? Mr. Hansen's argument in this book is that you can never attribute a direction to a company. But that is inconsistent with the statute itself, which, as he accepts, expressly provides for legal persons being able to direct. So if we go to page 8, we get down to his comments on directions. And at the foot of that page, please, he says, bottom paragraph, the director of the work may be a natural or legal person. The idea of a legal person as directors is problematic and has been discussed above. Legal persons such as companies usually act through their employees or representatives. A company as an entity could not, except through the efforts of a human being, direct the creation or creativity of a work. So, I mean, that's a non sequitur. He's just failing to understand that the question is, do you attribute the direction to the company? And he just says there can be no rules for that. But that would be inconsistent with the statute itself, because the statute contemplates that a company can direct. And there's no authority to support his proposition. It's just he's relying on his 6 years or 5 years or 6 years of experience, but he doesn't cite any of that experience. And it looks like he's just missed the point about attribution. Now, under both the old law and the new law, a company can direct, a company can author. So if we go to H16.2, we've seen this. This is the definition of an author who has a work attributed to him. And then page 3, sorry, we've seen that the definition of collective work expressly contemplates companies directing things. It's at the bottom, please. Yeah, so it can be natural. See, it refers in terms to legal person. And then page 6, Article 20, subparagraph 3, that also sorry, maybe I've got that wrong. Could we go down to Article 20, subparagraph 3, please? I'm so sorry, I might have given you the wrong page number. Thank you. So you'll see in the middle of there's the distinction. It's in a slightly different context, but at the third line, it distinguishes between a situation in case that the author is a legal person, but in the case that the author is a natural person, the period will be calculated and so on. So it makes a specific distinction. So my learned friend says, well, you cannot have, under the old law, an author who is a legal person. And that is just can't be right, because the law specifically contemplates that you can. Now, under the new law, that is made also very clear, and that's at H15, page 3, and the definition of person, which isn't defined in the old law, but it says, if you go down, please, person is defined as a natural or legal person. So it makes it very clear that the whole of the Act applies to legal persons. Now, as I've shown you, the new law introduces certain express rules of attribution. So it says if you're an employee, then it'll be attributed to an employer in certain circumstances, and so on. But that doesn't mean that there were no rules of attribution previously. There must have been rules of attribution previously. In any event, we say the new law applies. Now, the upgrading of Medica Plus to MCC clearly came at the direction of Mr. Shehata. He was a director of Health Insights Dubai. He was the CEO of that company. In practice, nothing could have happened if he had not given those instructions. The fact that he did not actually code is irrelevant. Now, my learned friend says something more is required than just saying get on with it. That is also by reference to, amongst other places, the textbook that we've shown you, but in particular on page, this time 116, H116, page 9. And if we just scroll out a little bit, the nature of the direction is important. We see that section. And what he says is, well, you've got to do certain things, got to be some sort of creative input. That's not supported by the language of the statute, which just requires a direction. But we would say that this is satisfied. You see, it says in the middle of the second paragraph, direction must be such that it affects what is creative or distinctive about the work. That is satisfied anyway, because on this premise, what is creative or distinctive is the move to a cloud-based solution. Now, there might be a question as to whether he gave these instructions on behalf of Health Insights Dubai or on behalf of Health Insights Egypt. But that is a question that we would answer. It's difficult for us to answer in the abstract because we were not on the ground. We could not see, my clients could not see the particular communications which gave rise to this. But you can deal with this by inference for the reasons I've explained, that everybody assumed that this was being done for Health Insights Dubai. Amongst other things, it's Health Insights Dubai's software that's being worked on. And what would be the position if somehow he's giving instructions on behalf of another company to take Health Insights Dubai's copyright material and use it to develop a new piece of software? That would just be an overwhelming infringement unless there was some other arrangement in place, which nobody says there is. But fundamentally, we say the legislation just requires direction. So Mr. Shehata has clearly assembled a team. He's appointed Mr. Farhan, and you'll have seen Mr. Farhan gives that email, which is at E83. And so he's delegated the actual supervision to Mr. Farhan, but he was involved. He was copied on everything. He accepted he was copied on it. My own friend said, oh, well, because we say he wasn't involved, that means he wouldn't have access to the documents. That doesn't follow at all and is inconsistent with the evidence. Now, my learned friend says Mr. Farhan was employed by Al-Khalij. That's another false allegation. Can we bring up bundle Q1, please? Q tab 1. And scroll down. You'll see he had been employed by Al-Khalij, but on the 1st of December 2013, you see an email from Mr. Shehata saying Mr. Thamer Farhan will be rejoining Health Insights to ensure the quality of the services that we provide for Al-Khalij customers in Saudi Arabia. Now, in cross-examination, it is fair to say Mr. Shehata simply denied that Mr. Farhan worked or was employed by Health Insights, but he refused to explain who he was in fact employed by. And if we can bring up, please, bundle E83, it is. You'll see at the bottom of that page, this is the email where he sends the sheets around. He signs off as the Medica Plus Implementation Manager, Gulf Region. So he's certainly acting as a Health Insights employee, not an Al-Khalij employee, when he gives these instructions. So my learned friend in his submissions again resorts simply to mischaracterizing my case. One of the things he took you to was my closing submissions, page 99, my closing submissions, and paragraph 181, where he says, oh, well, look, they say it's clear D1 did not work on the development of MCC. And I think he showed you 179 as well. But clearly what we're talking about there is coding, because if you go forward to page 102 of this document, you will see paragraph 183 says, in terms, all of this correspondence is evidence of D1 overseeing the team of developers rather than engaging in development himself. So our position is, he He was not involved to the extent of actually coding, because the case we're meeting at this point, by the way, is he says he wrote it all himself. And our case is, well, no, he didn't write any of it, but he did give the instructions to do it. So one does have to step back and ask, realistically, who is this activity being done for? We don't need direct evidence of a specific instruction, a direction. That would require us to provide something which Mr. Shehata, we say, is withholding. None of this actually requires decision if you accept that the new law applies, because then you attribute all of the work to the employer. And we say you can do that anyway, even under the old law, which means you attribute the work to Health and Sites Egypt and Al Khalij, and then you ask, for whom was this being done? For whose benefit? And again, we're back to the question, was it HI Dubai? Was it HI Egypt? And on the evidence, we say there was an arrangement whereby Health and Sites Dubai paid Health and Sites Egypt for software development during the period in question. And the obvious inference is that that arrangement covered this work, because what else could it have covered? When we get to collective works, when we're dealing with collective works, my learned friend also said there needed to be a pledge in favour of HI Dubai. That is not a fact. There's no such requirement under the new law at all. You'll see tab 15, page 4. It simply requires that the directing party undertakes the publication thereof in its name. This is collective works. There it is. So you see second line, of a person that undertakes the publication thereof in its name, not undertakes to publish. But my learned friend, even when we're dealing with the old law, is simply elevating the language. Even under the old law, there's nothing requiring some sort of written declaration. The mischief that this is intended to meet is to ensure that everybody knows that when the individual developer is dealing with it, that they're not the ones who are going to actually get the copyright in the work. And then the other point my learned friend says, well, to be a collective work, one of the requirements is it's got to be impossible to separate or distinguish each author's work. And he says, well, because the system's modular and you can only copyright source code, it's not possible. It's possible to distinguish each item on my case. That mischaracterizes yet again my case and the evidence and conflates a number of issues. The first point is that, yes, MCC is modular. There's no framework software that needs to be installed on top of which the modules sit. There's just a number of modules. There's nothing else. But the modules interrelate with each other. They call on the functionality of each other. So the electronic medical records module is a requirement for other modules to provide their full functionality. For example, Mr. Shehata accepted that. That's, you don't need to go to it. Day 7, page 61, line 25 to page 62, line 2. So they are modular, yes, but they are part of a whole coherent package. The second point is that the evidence is that much of the work that was done to upgrade these modules was cut across all of them. So if we bring up E83.20, page 1, which is the spreadsheet, the development progress report spreadsheet, when we get there, you will see, for example, that Mr. Ahmed Saleh was the development manager. There's tab 83.20, page 1. So Mr. Ahmed Saleh was the development manager. He's at the top, development manager. His contribution cuts across everything. Mr. Omar Elewa was responsible for ERP, Enterprise Resource Planning. That's about ensuring integration across the whole. Mr. Camber was responsible for HL7 integration. HL7, you may or may not recall this, but that's a set of principles for hospital management systems. So he's ensuring that everything meets the standards set in the HL7 principles. And Mr. Shehata agreed that Mr. Campbell was responsible for integrating those principles across the whole, all of the modules. That's day 7, pages 42, lines 7 to 9. Third, each of these modules was worked on by different people. So if you scroll forward, please, to page 3 of this, for example, under the heading part of, you'll see what these bits were part of. So Mr. Galal, bottom line, is working on chemo medication administration, which is part of EMR. That's the module is EMR. But if we go over to page 5, please, you'll see that Mr. Hefney is also working on various bits of EMR. And so is over the page on page 6. Mr. Wael Sultan is working on EMR. And page 8, Mr. El Shami is working on EMR. And so is Hoda Samama. And you can go through and look at that and see that the examples we've got at EMR, admin setup, pharmacy, billing, all of those modules are distributed across a variety of different people. So you can't say this bit of code belongs to Mr. Whale, this bit belongs to Mr. Marwan Ragab. So that's the third point. The fourth point is that all of the gap analysis and all of the testing that was undertaken by the company fed back into the coding, fed back into how the code was developed. Now, the fact that it is the end result, which is what is copyrighted, doesn't answer the question. This is my learned friend's point. It's only the source code that is copyrighted. But the fact that that is what I copyright doesn't mean that it's only the person who actually wrote the code who gets to have the copyright. If I dictate my novel, it's not the typist who gets the copyright in the novel. But if I'm in a band and there are 4 band members contributing to a song, it's not the person who writes down the song who records it and gets to say that they're the owner. The point is that the coding is just the last step in developing the code. And so saying, well, it's only the code where there's copyright doesn't answer the question of what went into that. My learned friend says it's irrelevant that this approach leads to absurd results. He says that's legally irrelevant. The result, he implies, of my facts is that the ownership is, as I put it on Friday, atomized. It's spread among the individuals who wrote down, who formed the team. But of course, that is relevant because if your legal analysis leads to an absurd result, that is a strong indication that your legal analysis has gone wrong in one way or another. So there is a factual dispute about how MCC was in fact developed, but we say there's a presumption in favour of Health Insights Dubai. MCC was attributed to Health Insights Dubai both by the Interoco certificates and by all the other conduct we rely on, and by the fact that it was Health Insights Dubai that was exploiting, with everyone's agreement, this software. And if you accept my account on facts, then first, MCC is based on Medica Plus, and so it belongs to Health Insights Dubai, either as joint owner, or if you accept the upgrade was done for the benefit of Health Insights Dubai, then as sole owner. And second, because Health Insights Dubai paid Health Insights Egypt to develop it. And third, if necessary, because it's a collective work. All of that is consistent with and supported by Mr. Shehata's conduct before the dispute arose. He consistently said and acted as though HI Dubai owned MCC. Your Honor, that's what I was going to say about ownership. Very, very briefly, just on the purchase order, I won't repeat my submissions, but my central point there is that the purchase order was not intended to do what it purports on its face to do, which is to cause Health Insights Malaysia to hire Health Insights Dubai to develop MCC from scratch in July, between July and December 2016. And we say,
Mr. Montague
yes.
Smith, on the question of whether it was executed at or about the date that it bears, what do you say about Mr. Doherty's point that the bank statements show that there was an amount deposited and that there are invoices which say they're for software development? And do they relate then to that purchase order and show that the purchase order was in existence at least at that time?
We say that at best they can help you show that they was in existence at the date of payment, which is in 2017. So that's after the new regulations come in. So actually, when you look at the bank statements, they don't show payments coming in contemporaneously with the purchase order. The purchase order is justified on the basis that the company needed money, but the money doesn't come in until a year, 15 months, 18 months later in 2017. So that's the first point. So if if they are linked, if the payments are linked to the purchase order, then the best that gets you to is 2017. But the answer to the question is we would say all we've got are redacted bank statements which show some sort of payment for software development. Now, what is clear is that the payments were being asserted in 2017 as being related to software development. They don't refer to the purchase order, and the invoices, we say, are about as worthless as the purchase order. So if you're looking for independent evidence, independent of Mr. Shehata, all you've got is a bank statement showing payment. Is it related to that purchase order? It's very odd if it is, because it splits out these invoices into different chunks. So it cuts one of the invoices almost in half, and then pays them in two kind of consolidated payments. So the payments that are said to justify it don't match the invoices. So we say, in terms of timing, that it's very unclear when that purchase order was created, but the best we can do is that if it's linked to those bank statements, it looks like around 2017. But I think the prior point is it intended to do what it says it does? And the answer to that, I think, was answered by Mr. Shehata. He accepted it. That's not what it was intended to do. It wasn't actually a purchase order for the development of software at all, according to him. It was just a cover for the payment of money, according to him. Because on his case, he'd already developed MCC years before. In terms of whether there was a conflict, he, as I'd understood his evidence, he'd accepted that in terms of where HI Dubai and HI Malaysia were contracting with each other, it's in HI Dubai's interest to get more and HI Asia's interest to pay less. And so there clearly was a conflict, and it seems very difficult to see how he could not understand that, but there we are. In relation to the payments claim, it was said, certain things weren't pleaded, but if the point that he doesn't grapple with is that if a director takes company money, then there's an obligation to account, and he's not entitled to take company money into his own bank account. But if he does that, it's for him to explain why he did it. And if it turns out that there's no legitimate explanation for receiving that money, then that is a breach of duty. And in those circumstances, Article 79 is engaged. And I've explained why we say that. But it's not right that it's not pleaded, because we can't plead out the justifications that he provides. That's for him. So we say, look, you took this money. You can see the pleading. It's at B39, paragraphs 41 to 42. He took the money. There was no legitimate purpose for it. And then it's for him to say, well, these were the legitimate purposes. And then we challenge them. And if those were not legitimate purposes, then the taking of the money in the first place is a transaction in his favor, which needs to be set aside. I wasn't going to go back over that in too much detail because I do need to deal with the counterclaim. So I've got another hour or so, I think, and I've got quite a lot to cover. So I'm going to do my best to cover it. I think my learned friend took a little bit longer, but I'll try to get in on time if I can. So I don't want to keep everyone late on the day, 2 days before Christmas. The counterclaim asserted at least in written closing, we say it bears no real relationship to the pleading. It ignores Your Honour's ruling on the amendment application, and it doesn't really bear any resemblance to the case that was actually put at trial. Now, Your Lordship, Your Honour warned my learned friend that he was not putting his case in this regard. He acknowledged that, said he'd come back to it, but he never did. Now, he tries to get around this, and I'll come back to this a little bit later, but he says, well, actually, unfair prejudice doesn't require the subjective element. But what unfair prejudice claim requires is that you plead it out, and then you have to look at what is pleaded. And the way in which the unfair prejudice is asserted is all on the basis of breaches of duty by the directors. So the particulars of unfair prejudice in this case have, right up until about half an hour ago, or an hour and a half ago, always been put on the basis that my clients were in breach. But there are a number of other manifest, we say, misconceptions in the way the counterclaim is put. There are two parts to the counterclaim. There's the unfair prejudice part, and then there's the Article 79 claim. And that Article 79 claim is that certain transactions were entered into with alcolege without prior disclosure to the board. So that's the second part. So we would suggest that Your Honour should consider the counterclaim in the following stages. First, can they actually bring an unfair prejudice claim at all? Second, what has actually been pleaded against the claimants, and does that give rise to an arguable claim? And then third, in respect of what has been pleaded, has it been put? And then fourth, if it has been put, is it made out? And we say that the defendants fail at every stage. And most of what is in the pleading is advanced under the heading of unfair prejudice. And when we start at the first issue, we say there's no power for this court to grant unfair prejudice relief. If we go to so we know that the claim is made under Article 98 of the regulations. That's quite clear. That's in the pleading at B tab 4, page 23, but we don't need to go to it. Regulation 89 is the one that confers the power to deal with unfair prejudice. That's at H13. Let me bring that up, please, and go to page 46. You may have it. You may be looking at it in a slightly different place. I know my learned friend referred to E100, I think it was, but if we're looking at the authorities bundle, it's at H13, and it's 46, Regulation 89.1, please. There we go, and thank you very much. It goes over the page. Where a company's affairs are being or have been conducted in a manner whereby the conduct is unfairly prejudicial to the interests of its members generally, or of one or more members, and so on, it says, second line down on the next page, the authority may, on application of one or more members of the company, make one or more of the following orders. So it's the authority which has the power to deal with unfair prejudice petitions, and it is the court's powers in this regard derived from the regulations, and the regulations don't confer that power onto the court. The regulations are incorporated into the articles. That brings them with them the language of the regs. Now, the defendants say the fact of the regulations being incorporated into the articles means that the court has power to grant relief under Regulation 89. But that's a non sequitur. The incorporation doesn't change the language of the Regulation 89. And as we pointed out in our closing, taken to its logical conclusion, the effect of that would be that the DIFC court, by agreement, has got power to exercise any of the DDA's powers under the regulations, and that obviously cannot be correct. Now, why is it that they say this court has power? And one of the things they say is that the DBA is not an adjudicative body. That's just pure assertion. We deal with this in our closing at paragraph 371 on page 184. But the DDA is the legislation establishing the DDA gives it the capacity necessary to perform its objectives. So it's constitutionally competent to deal with whatever is in the regulations, and it's been given power to do so. And it's not that surprising, because regulators very often have adjudicative powers. So, for example, the DFSA and the DIFC has a subcommittee which deals with regulatory complaints, as do all regulators in developed legal systems. And the decisions of the regulator are subject to review. And in the case of the DDA, its decisions are subject to the review of the Dubai onshore courts. Now, we set that out in our closing, paragraph 371, subparagraph 4. So the effect of the agreement to the regulations is that there's a separate power conferred on the DDA, which is subject to review in the Dubai courts. Now, the defendants say, well, the DDA can refer things to this court under Regulation 108, and that is wrong. If we go, please, to Regulation 108, see that at page 54 of this, what it actually says, 108.1, is that the third line down, the authority shall be entitled to refer any such matter or question or dispute that it deems appropriate to the Dubai courts. So that's capital D, capital C, Dubai courts. Now, that is a defined term. We go to page 58. You will see firstly the definition of DIFC courts at the top, and then further down the definition of Dubai courts, a few boxes down. So the term Dubai courts does not include, in this context, the DIFC court. And it's also worth noting that court is further defined separately above on page 57 as any court of competent jurisdiction. So these terms are being used distinctly, and the term court, small c, is the one that's used in Regulation 79. So when we're dealing with the application to set aside a transaction, that can be referred to a court, small c. That's on page 42 of this. But what you've got is a scheme that deliberately distinguishes between, firstly, the powers of the DDA, then on a referral, the powers of the Dubai courts. But where it wants to confer powers on courts of competent jurisdiction, that would be a court that parties have agreed to, perhaps, then that is lowercase c. And when you're dealing with the DIFC courts, that's something else. So before they could get to this stage, you would need, firstly, a DDA referral. And it's worth just picking this up, because if you go to page 162 of my learned friend's submissions, this is my learned friend's paraphrasing. Paragraph 448. He says, in other words, where there has been an actionable breach of the regulations, an affected party is entitled to refer the dispute to the relevant court. But the point here is that where your claim is for an unfair prejudice petition, it is only the DDA which is entitled to refer, and the DDA cannot refer to the, quote, relevant court. It can refer to the Dubai courts. And my learned friend says, well, this is a bit like where parties agree to unfair prejudice, agree to arbitration, and they bring an unfair prejudice petition in arbitration. But it is not the same at all, because the parties have agreed that their disputes will be determined by the DIFC courts generally, but they've also incorporated the regulations, which sets out a regime for dealing with unfair prejudice petitions. And that says that it's the DDA which determines these claims. And if the DDA refers, well, then so well and good. And the DDA will send it off to the Dubai courts. So there's an agreed regime. The court has to apply it. The court has to apply the contract. It can't just say, well, actually, I'm going to ride roughshod over this. I'm going to preempt all of this, and I'm going to make all of the factual determinations and all of the legal determinations that the DDA would otherwise take, or if the DDA doesn't want to take them and kicks it off to court, that the Dubai courts would take. So in England, the question was, well, where the legislation refers to the court having power to grant unfair prejudice petitions, does that exclude the power of arbitrators to even look at the question? And the answer was no. But in this case, where you've got a complete regime for dealing with these, which says it can go to the Dubai court or to arbitration, where arbitration has been agreed. So if there was arbitration, you could send it off to arbitration. The DDA could send it off to arbitration. But it doesn't mean that this court can just ride roughshod over that. It's a bit like saying, well, I'll come back to that. Now, so the provision of the regulations which says that the DDA may refer to an arbitral body, which you'll recall is one, I think it's 108.1. That's on page H13, page 54. It says the authority shall be entitled to refer any such matter or question or dispute that it deems appropriate to the Dubai courts, or if all parties to the dispute have so agreed in writing, to an arbitral body. Now, if my learned friend was right, there would be no need for that whatsoever, because there would already be the power just to go straight to that arbitral body. So in short, the parties have not agreed to have unfair prejudice disputes come before this court. This court clearly has no power to grant unfair prejudice remedies, and could never have that power because the regulations send them elsewhere. So that really, it comes down to the question, should this court entertain a claim just for a pure declaration that unfair prejudice has arisen? But A, that's not how we understand the claim to have been put. But secondly, when would it be appropriate to grant that? It's equitable relief, effectively, that's being sought. Why would it be appropriate for this court to go down that avenue at all in circumstances where it's not the designated dispute resolution centre, according to the parties' own agreement? So that's the first point. The second point is what is actually pleaded here. Now, in our closing, if we go please to page 167 of our closing, it's T1167, paragraph 341. We set out some of the principles that come in here, and just to draw your attention to two of these. Paragraph 3.3413, please, on page 168. There are serial reminders of how serious it is to allege a breach of director's duties. They've got to be pleaded out. I won't take you to the authorities, but you can. I hope there's a hyperlinked version of this on the website, so you can click through. And then at subparagraph 4, there's reference to the Dinglis case, and because the unfair prejudice jurisdiction is so broad, it is essential that specific grounds are particularized. Now, in relation to what is actually pleaded and what is closed on, the defendants have simply, we say, ignored Your Honour's decision refusing amendment. And what they've done is they've just thrown in all of the things that they wanted, plus some more, that they weren't given permission for. So it is difficult to disentangle the parts which are legitimately in play and those which are not. You may recall in broad terms the amendments which were refused, but I'll just run through them very briefly. If we could bring up, please, Bundle B, tab 4, page 15. I'm just showing you the actual pleading, and I'll just remind you of the bits where they wanted to add in some parts. So paragraph 66, please. They say the first claimant knowingly caused Al-Khalij to refrain from making payments. So this is the withholding payment stage. And what they wanted to do was add after the first claimant and or the second claimant. So they wanted to introduce the second claimant into this plea about writing off debts. And Your Honour refused that application. But if you look at, we don't need to go to it, we'll stay with the pleading, please, to the operator. But if you go to page 176 of their closing, paragraph 499, you will see that the whole thing is still alleged against both of the claimants. So they're just ignoring Your Honour's orders here. They also wanted to add in reference to the 28th of August memorandum. Your Honour may recall that document. That was a letter that was sent out. And they said, well, that wrote off debts. And again, they just go ahead and that was refused, but they go ahead and argue that anyway. And you'll see that in their closings at page 136, where they set it out. And indeed, at page 137, they run a different case. So paragraph 387, what they say is that actually that letter had a causal effect on Al-Khalija's payments. So they say, actually, it's not clear whether they're still running it as a writing off of debts, but they say by sending the letter, they caused the payments to stop. They caused Al-Khalij to stop paying. And then they refer to it again at page 153 of their closing, paragraph 426. And the 400 and and then at page 182 of their closing, paragraph 538. We said they refer to it again, so you have to sort of go through the whole thing and prize out the bits that are legitimate. And then and then where they get to by the end of the pleading on page 188, paragraph 573, they say, oh, well, actually, that letter, that memorandum, caused the judgment, caused that adverse judgment that went against Health and Sites Dubai. So none of that's pleaded. It's all effectively ignoring your refusal to introduce the memorandum, and then launching a whole new causation case on the back of it, which wasn't even proposed by way of amendment. If we go through going through this pleading, you can see the heading in front of you on the screen is diversion of business from the second defendant, and on page 16 of this document, paragraph 71. They say Al-Khalij has not paid Health and Sites Dubai for various things. And in that context, they wanted to add reference to 7 contracts, orders, payments in the total value of $6.4 million. And the argument was to be, well, this was money which was really owed to Health and Sites Dubai. It's a sort of diversion of revenue argument. And then at B4, page 17, after paragraph 73, they wanted to insert a further paragraph saying that the revenues were diverted. Those were the ones that they'd sought to plead earlier. Second, they contested the claim against Al-Khalij, and third, they said $405,000 had been diverted. So they were trying to backfill that. And then 74D, they wanted to add reference to a travel ban and arrest warrant in Dubai. And then if we go forward to page 21, at 94 after C, they wanted to add a new 94D, which was that they wanted to add a remedy relating to the alleged writing off of debts. Now, the reasons for which Your Honour refused those amendments are important because they apply equally, we say, to the rest of the claim. I was going to remind you of them briefly, but I think I'll just ask you to refresh your own memory in due course because of the timing. But you will find them at Bundle F, page 40. Sorry, Bundle F, tab 14, page 20, paragraphs 113 to 123. And effectively, Your Honour said they were too late. They were inadequately pleaded and particularised. They were legally incoherent, with no proper explanation of how the actions constituted breach of duty as directors of Health and Sites Dubai. There were no particulars of key details, what debts were written off and so forth. There was no explanation of the diversion arguments, no proper explanation of how there was a right to bring a derivative claim, broad and unsubstantiated allegations, no explanation of the legal framework in which this sat. And Your Honour accepted all of that at paragraph 122. And it was all too late and prejudicial anyway. So instead, we just get this, we get the arguments effectively put back in, or a lot of them, and a lot of new case built in closing. And we say all of Your Honour's conclusions in that judgment apply to the allegations in the existing case. So if we go back to page 14, withholding, thank you, at the bottom of the page is the heading, withholding of Al-Khalij payments by the first claimant. And then you've got paragraphs 62 to 67 explain it. And we say that is legally incoherent. It, in the sense that it is an allegation made against the first claimant of conduct as a director of Al-Khalij, in not causing Al-Khalij to make payments. But there can be no duty on another director to use his powers as a director of a different company to behave in a particular way. Then we have diversion of business, which starts at paragraph 68. And you'll see paragraph 68 refers to hospitals which have entered into contracts with Al-Khalij. There's no explanation of what's been diverted, but that implies some form of property. Now, if money was paid to Al-Khalij, for example, by Al-Khalij to someone else, for example, Health Insights Dubai would not be entitled to that money. It would just still have a claim against Al-Khalij. And there's a constant conflation of diversion of business, diversion of revenues, taking business opportunity or diverting revenues. And I'll come on to each of the claims as to how it's now put in closing. B417, you've got allegations about the attempts to remove the first defendant as general manager. And again, it's not explained why that's a breach or why that's unfairly prejudicial. And obviously we say it was validly done in accordance with the articles. And then you've got paragraph 74, 3 things that are alleged. Two of them are not things that are done in their capacity, in the claimant's capacity as managers of Health Insights Dubai. They're not to do with operating the business of Health Insights Dubai. And then you've got page 18, paragraph 79. You've got a series of other allegations. None of this, we say, constitutes steps that could be said to be taken as directors of Health Insights Dubai. So you've got this sort of fundamental conceptual problem here. And then page 19, you've got at paragraph 81 and onwards, the case about failure to declare an interest. And paragraph 81 is second defendant entered into transactions which are not particularized. And then at page 20, you've got allegations that there will be debts written off in future, not that they have been written off, and a claim for an injunction in relation to those. And then at page 22, you've got the unfair prejudice claim. You can see the heading on the previous page, but if you go over 95 and onwards, that is the case. So 96A is removal from management. 96B is the diverting of the revenues, which are said to be a breach of regulation 78D. And 96C is said to be various ways in which the claimants have breached their duty under 78.1A to act honestly, in good faith, lawfully, in the best interest of the company. And then there are 5 which are set out. The first 5 are not actions that they could be arguably said to take as directors of the company. And then the 6th, which is 3 lines up from the bottom, is about diverting business and revenues, which I'll come back to. But we say this is not a properly articulated case. It's so vague as to say, well, there are contracts. And it is not right, we say, for the defendants, having been refused permission to amend late, to simply throw it all back into the closing. The other problem that my own friend faces, which he tries to explain away, is that the case was not put to the witnesses. And this applies, we say, across the board. The majority of the allegations are that the unfairness arises because the claimants breached their duties to act in good faith in what they believe to be the best interests of the company. And you can see that in the passages that we're looking at here. So in C, which is where the diversion allegation comes, for example, which my learned friend says is objective, not subjective, it's pleaded out subparagraph 6 here, but it's all under the banner, top of page C, acted in breach of Article 78.1a of the regulations by failing to act honestly, in good faith, lawfully, in the best interests of the second defendant, in a way which avoided conflicts of interest. Now, those are which are set out at paragraph 80. I showed you 81 to 88. Sorry, 81 to 86. There is a section about conflicts of interest in the pleading, and we say if we put those to one side, the first category, which are complaints about breach of duty to act in good faith in what you believe to be the best interests of the company, those clearly have a subjective element. So it's not enough to say that the actions of the claimants were not in the interests of the company. It must be shown that they were not in good faith. And for example, they did not think they were acting in the company's interests. My own friend accepted this in closing. It's a paragraph, it's page 167 of his closing, paragraph 479. And he refers at 479, subparagraph 3, to a case called Client Earth and Shell, where it says, it remains the case that the state of mind of the director concerned is what matters. An honest but unreasonable and mistaken belief that a particular course of action is in the company's best interest is not sufficient to amount to a breach. So the question of whether a power is used for a proper purpose is also subjective. Again, that is also accepted. This is my learned friend's closing, paragraph 480, subparagraph 2, which appears on page 168 of his closing. He quotes from a leading case, declares, the state of mind of those who acted and the motive on which they acted are all important. And indeed, as he's pointed out, the Article 79 claim, which is the setting aside of transactions, also has a subjective element. It requires the director to be aware of the conflicts. So the short point that we make here is that the relevant assertions about the claimant's state of mind were never put to them. I've set that out in our closing at paragraph 352 on page 175, and where we remind Your Honour of that exchange about part of the allegation that Mr. Shehata was deliberately excluded from Health and Sites Egypt. And you said that had not been squarely put, but my own friend moved on. And then at paragraph 355, page 178 of our closings, we point out the other essential points which we say were not put to the claimants. And we go through that in some detail. And we do say that there are gaping holes in the case. Repeatedly, my learned friend put what I could call the external facts of the scenario to the claimants. For example, that payments had been made, or that the shareholding in Health and Sites Egypt had been diluted, or that Al-Khalij had contracted with other entities. But the claimants were not asked about their state of mind. And as I say, the answer to this that's been given is, well, unfair prejudice is objective. It doesn't require any subjective element. So you can have, in effect, what he's saying is you can have unfair prejudice without having to establish any of these breaches. But the pleading depends on it. The pleading sets it all out. And indeed, his written closing depends on it, because if you go to paragraph 602, issue 14 and 15, unfair prejudice, this is page 193. When it says the breaches of the claimant's duties, which found the first defendant's unfair prejudice claim, are already detailed above. So the foundation of the unfair prejudice claim was allegations of breach of duty. So if you strip away those, what are you left with? You're left with a totally unparticularized unfair prejudice, just all a bit unfair, which is unacceptable and is not the way the claim is put. I've got a little bit more to go, but I'm conscious that I've been going for an hour and a half.
We've hit the 90 minutes.
Yes.
So we should take a break now, probably 15 minutes, come back at 355.
Thank you.
Yes, Mr. Montague-Smith.
Thank you. All right, the unfair prejudice claim itself. What we say is that the counterclaim loses sight of the nature of unfair prejudice. You've got Regulation 89.1, but it arises where the company's affairs are being or have been conducted in a manner which is unfairly prejudicial. So it is directed at the actions of the directors as directors in charge of the company, not at anything else. And in some respects, there is conflation, I think, in my own friend's submissions. If you've got his closing submissions at page 170, he says, for example, at paragraph 487, so it's 170 for that, thank you. Deliberate diversion of a company's business by those in control to another business in which they have an interest and which excludes the minority from full participation in the profits of the company is likely to be unfairly prejudicial. So that's talking about those in control. And obviously the difficulty for my own friend at this stage is that at the time, at least, these pleadings were settled, my clients were not in control of the company. And he refers to Hollington there. And if you go back to 485, he extracts the particular provision of Hollington, and he showed you this as well. But this is about, as you can see from the extract, where the management procures the company to enter into transactions. So this is about causing the company to contract with related parties, that particular provision. So it's always about actions controlling the company, abusing the powers, abusing the status of the director. And page 171 of his closing submissions is this long passage that's recited from the Denning judgment. I think it's the case of Cook, is that right? Sorry, no, it's not. It's Scottish Cooperative Wholesale, that's right. And that's about the closest that he comes to his asserted facts in this case. But even there, the complaint was about what the directors had done or not done in their capacity as directors in charge of the company. So if you look at the top of page 172, and you can see what is said is that responding to the defence to this, these directors were at most guilty of inaction, of doing nothing to protect the textile company, but the affairs of the company can, in my opinion, be conducted oppressively by the directors doing nothing to defend its interests when they ought to do something. Paragraph 491 refers to Vidori and deals with sorry, did I say 491? 490, my apologies. 490 is about Vidori, which again is about using the powers as directors to, in effect, wind up the company, dissolve the company, transfer its ongoing business and goodwill. So it's all about controlling the company to do things that are unfairly prejudicial. And similarly, the Cook case, the passage, if we go over the page to 173 of this document, passage that's cited, if we look at the top paragraph, the final sentence of that top paragraph, this means that while entrusted with the conduct of the affairs of the company, they deliberately designed to exclude and use their influence and position to exclude the company whose interests it was their first duty to protect. So it's about acts taken as directors in controlling the company, and that must be right because it's about how the company is being managed, and that's why it's normally minority shareholders who make these sorts of allegations. So and it's clear from we've cited passages from, for example, Reed Dinglis Properties at H3, page 36, paragraph 169, which analyzes out the distinct elements of unfair prejudice. And requirement A, you'll see at paragraph 169 when we get there. So H tab 3, page 36. It must be about the paragraph 169, please. Thank you. Just, yeah. Yeah. So the requirements analysed out, taken from Hollington, and you'll see it, subparagraph 1 in the indented, to establish a claim, you must demonstrate that A, the affairs of the company in question have been conducted in a manner which was unfairly and prejudicial. So it's about the conduct of the affairs of the company. And we say most of the allegations fail for that reason alone, because the claimants weren't in charge. And the only things we say that could really survive are, firstly, excluding Mr. Shehata from management, using their powers actually as shareholders, not as directors in control of the company, but as shareholders. But that doesn't get off the ground for various reasons, and I'll come on to each of them. And secondly, the allegations of writing off debts, but those are prospective, and when we come to it, actually, they don't appear to be seriously pursued. But we say none of that's available because it wasn't properly put. But we'll go through them. I've taken you very, very rapidly through the pleading, and I'm sorry about that. It's just the way this has developed. But the allegations are put in the same set of headings in the closings and then purportedly approached. So the first category of complaint is about refraining from making payments. So this is about $5 million, which it is said was due from Al Khalij to Health and Sites Dubai. We deal with this in our written submissions at page 187, paragraph 377 onwards. We make a series of points about this. So the allegation is that the claimants, in closing at least, the claimants withheld or took steps to withhold payments by Al Khalij. I just deal with this, if I can, fairly short series of points. First, it is not open to the defendants to advance this claim against the second claimant. That amendment was refused, and the only claim advanced is in relation to the first claimant. Second, it was not put to the claimants that they had acted dishonestly or in bad faith. And the foundation of this allegation is that it's a breach of the duty to act in the best interests of the company. Third, what they believe to be. Third, this is not a complaint about the first defendant's management of Health and Sites Dubai at all. It is a complaint about the first claimant's conduct in his position as a director of Al Khalij. You can see that from page paragraph 66 of the defence and counterclaim at B415. So in essence, it's you should have used your powers as director of Al Khalij to procure these payments, but you didn't. And then fourth, this allegation all depends on the factual assertion that money was in fact owed. And the short answer to that, and could have been pursued by Health and Sites Dubai, and the short answer to that is it was pursued by Health and Sites Dubai, and Health and Sites Dubai lost the case against Al Khalij. You may recall the Riyadh Commercial Court judgment in that case, and they found that Al Khalij had contracted, at least in relation to those services that were covered by those invoices, with Health and Sites Egypt and not Health and Sites Dubai. And my learned friend says that that was a decision on jurisdiction. I think he was trying to find a way to say it's not somehow binding or wouldn't have an effect. We say that's a mischaracterization of the judgment. I won't take you to the judgment, but if you want to look at this, it's at E tab 273, pages 36 to 38. But essentially, the court considered the evidence, including Mr. Shehata's oral evidence, and concluded that as a matter of fact, Al Khalij had not contracted with Health and Sites Dubai, so Health and Sites Dubai had no standing to claim. Now, in closing, this complaint morphs into an allegation that both claimants did not cause Health and Sites Dubai to pursue the debts. That's a different allegation. And that's closing paragraph 526 on page 180. But A, they were not in control of the company at the relevant time. by the time they took control of the company, the claim had been brought and it had failed. And it cannot be a breach of duty to fail to bring another claim in those circumstances. So there's just nothing in this. The breach is actually alleged. We can see it, paragraph 535. They sort of spin off into page 182 of my own friend's closing. This is all under the head of heading of the complaints about the payments from Al-Khalij, said to be due from Al-Khalij. What are the breaches alleged? Well, 535 complains about saying that Al-Khalij will not deal with Health and Sites Dubai further. So it all gets a bit off track, because this was supposed to be about the $5 million debt and about that. But actually, for some reason, this is about the complaint then becomes, well, we won't. Why are you saying we won't deal with HI Dubai further? HI Dubai, that not dealing further is not about payment of invoices. That is about placing further orders. But anyway, this is not about the actions as director of Health and Sites Dubai. It's not about conducting Health and Sites Dubai's affairs. So it's incoherent, we say. And then the second allegation at 537, it says the court has heard evidence that the claimants extended existing contracts with facilities that licensed MCC. So they extended existing contracts and allowed Health and Sites Dubai to license and distribute MCC to other facilities. Now, this is a fundamental change of case that's being alleged here, because and we'll come back to it on diversion, but what was previously we understood being alleged was that my clients had somehow taken steps to ensure that Al-Khalij contracted with other parties, not with Health and Sites Dubai. So there'd been a diversion of contracts. But now in the closing, this morphs into, you can infer that actually the claimants took steps to extend existing contracts, and then those contracts generated revenue, which should have been paid to Health and Sites Dubai, but was not. So it's a diversion of payments. And those are two fundamentally different things. Because if it's a diversion of payments, then there's no diversion. All you've got is Al-Khalij paying other people things. That's not, Health and Sites Dubai has no claim to the money, but Health and Sites Dubai will still have a claim against Al-Khalij. But it's also fundamentally different from the way that it was closed orally, which seems to be on the basis that somebody else has got the contracts. The written closing is on the basis that Health and Sites Dubai got the contracts but didn't get paid. So it's very unclear what's going on here. But none of this really has got anything to do with the $5 million. What has that got to do with $5 million? And then third, they complain about the letter. You'll see that at 538, and that's, we say, is impermissible. It's just reintroducing the amendment. So we say that none of that can work. The next part is then over the page on 183 is the diversion claim. And again, we say that is misconceived, but just to show you at 555 to 556, how this is put. My own friend says he doesn't need to establish a breach of any duty that includes subjective element, but look at how it's put. The claimants owed Health and Sites Dubai duties to act honestly, in good faith and lawfully and in its best interest, and to exercise their powers. 556, the claimants breached those duties by diverting income and opportunities away from HI Dubai. So he does have to put it to my clients that they breached that duty, and that does involve putting to them their mental state. First, we say the allegation is not properly particularized. At the amendment, the application to amend, my learned friend said the contracts being referred to were those which were set out in the defendant's reply. Those, if we can bring them up, are at B64. So when it was anticipated that this was about diversion of contracts, it was said, well, if we go to, sorry, B62, I do apologize, it's paragraph, oh no, it is B64, goodness me. Yeah, so it starts at the bottom of B64, paragraph 12, and there's a list of contracts, and then at paragraph there's a list in relation to M+, and then at paragraph 13, starting on page 7, there's a list in relation to MCC. And I mean, the short point about that is that they are all historic contracts. They are all expressed to have ended. So you'll see from March 2020 to 17 March 2021. They all predate Mr. Shehata's removal as the person in charge. And we said in our closing, well, there's no case put that those contracts were extended past the dates cited. But now, as I say, in closing, that is asserted, and it's asserted as a matter of inference. And that was never put to the witnesses. It's a matter of fact which had to be put. And it makes no sense. It makes absolutely no sense. Health and Sites Dubai is in ruins. So you've heard the evidence about that. Mr. Shehata kept control in the face of Your Honour's decision. And when he was finally extracted, the claimants faced huge problems actually taking control because he didn't hand over. He didn't provide any handover of bank accounts, of documents, or anything else. But it wasn't put that these contracts or any of them were extended. It wasn't put that my clients acted deliberately contrary to the interests of Health and Sites Dubai or against what they believed to be its interests. As I say, it was understood that this part of the case was about diversion of contracts. That's a diversion of opportunities case. Instead of causing Health and Sites Dubai to contract, you caused somebody else to contract. But actually, when you read the closing, what they say, if we can go please to paragraph 551, what they say is that the contracts were not diverted. It's page 184 of that document. They say, 3 lines down, it should be inferred that no new contract terms were entered into between HI Egypt and those facilities, and it ought to be presumed that the continued utilisation of the MCC software was pursuant to the terms that had always existed with HI Dubai. The court should infer that payments made in respect of those extensions were diverted to either HI Egypt or HI Saudi. So the contract, so the case now put in closing is not diversion of contracts. It's just actually those contracts were extended, but the money was never paid. And that doesn't give Health and Sites Dubai a right to payments. It means that there are debts. If it was made out, there would be debts owed by our college to Health and Sites Dubai. And procuring those payments is not about management of Health and Sites Dubai's affairs. That's about non-payment by our college. That's about management of our college's affairs. But the case is pure assertion in any event, and it's raised for the first time in closing that there was extension. And we do say that this part of the case also does depend on the defendant showing that MCC is owned by Health and Sites Dubai, or that Mr. Shehata owned it to get to the partner reseller certification argument that they run. And my learned friend's criticisms of my case on ownership were, as I said previously, essentially that somebody else might own this software. What he says is, well, you can look at the history of Health and Sites Dubai exploiting this software, and you can draw from that it was entitled to do so. And as I say, that's very close to saying I'm right in saying that you can rely on that to find that there was an entitlement. It's just then after that, you just have to ask yourself the question, how did that entitlement arise? And there are only 2 competing theories for that. One is Mr. Shehata wrote this entire program himself. He then licensed it to Health and Sites Asia, who licensed it to Health and Sites Dubai. And we've explained in the many ways in which that doesn't work. And the other is our case, that Health and Sites Dubai owned the software all along. There is then, rapidly moving on, there's then the argument about excluding the first defendant from management. And actually, the pleaded case in relation to that it goes really no further than that, that they removed him as shareholders. But that was their right to vote for him to be removed. and they would have to show that this was a breach of some sort of breach of duty or some sort of breach of an agreement between them, that he was always going to be the one in control. Neither of those things were ever put to the claimants, and indeed the way it was put was very cagily, actually, in evidence and submission, which was that he expected to be the manager. Well, that might be right, but not forever. If you just to remind you, if you can go to B417, there were two other complaints that were alleged: filing criminal complaints and altering the structure of Health Insight Egypt's board and dilution of its capital. These are about things that happened in Egypt. They're not about the management of Health Insights Dubai, and they don't feature prominently in this, at least this part of the closing. What is left is simply the removal as manager, taking steps to remove him as the general manager of the second defendant. And we would say that the experience of this trial rather shows why that was perfectly reasonable. Just because you're appointed at the beginning doesn't mean you get to be the manager. It's not said there's some other way that they excluded him. There was no opportunity to do so because Mr. El-Shafai's position couldn't take it up for a very long time. So it wasn't said that he was in a meaningful way excluded as a result of any other step other than just his replacement as manager, and that is not sufficient. Ultimately, the parties agreed to the Articles of Association, which included the mechanisms for his removal. And a court is going to be very slow to second guess that sort of decision. But for what it's worth, we say it can be clearly explained. My own friend says, well, the business was very profitable, but something like 90% of that revenue came from Al-Khalij. My own friend says, well, clearly wasn't about performance, but you can see in the WhatsApps, and I won't go back to it now, but Q tab 3, page 1, there's reference in the WhatsApps to prior discussions where Mr. Thamer says, I gave you until the end of September. Sorry, you asked for the end of until the end of September. I gave you longer until the end of the year. And then look at what happened after that. If we're right on the facts, there was poaching, wholesale poaching of staff, crippling of the business, taking all of the money. And now a case which is predicated on lies, attempting in effect to get a court decision saying that he owns the software. But fundamentally, this part of the case was not put and is not open. And then there are a collection of complaints about conduct said to be contrary to the interests of the company. These are pleaded at B418, largely at paragraph 79. First, again, the subjective element was never put. Second, none of this was activity in the conduct of Health Insight Dubai's affairs. They weren't in control at the time. Again, they tried to introduce in closing the amendment which was rejected. This is a paragraph 573 and 574, which is about, I think it's the memorandum or the letter that was sent, and that's not open to them. At B419, subparagraph D at the top, just point out they say this was done continuing to license, implement and maintain the MCC software in the territories without payment to or seeking the permission of the second defendant. So compare that to the case now put, which is that actually they cause the second defendant to extend contracts. But what that makes clear is that these allegations are not allegations of their conduct as directors of Health Insights Dubai, because they say they didn't have the permission of Health Insights Dubai. So it's not about conducting the defendant's affairs. They add a new allegation in closing, paragraph 585 on page 190 of their submissions, which is about failure to pay debts. And they describe it as writing off debts. There's no pleaded allegation. There was a suggestion about future debts, that there might be writing off in future, but there was nothing to support it, and there are no particularized allegations of what debts there were. So we say this part of the case doesn't take anything any further. And then there is this point about Regulation 79 and undeclared conflicts. Now, I showed you the pleading in relation to that. In closing, the case completely changes. So page 191, paragraph 587 is where it starts. And the focus of all of this is since seizing control of HI Dubai. And that is a date which postdates the pleadings. So this is all unpleaded, brand new allegations. The pleading is at B419, paragraph 81, which is about transactions which were entered into in the past tense. So the pleading was in August 2024, when Mr. Shehata was still in control. So paragraph 81, the second defendant entered past tense into transactions. So you've got this unexplained, unidentified, unhighlighted shift from past transactions, which is now abandoned, to future transactions or post-pleading transactions, which is brand new. And none of this was put, and ultimately it's pure assertion based on an allegation that there were further contracts entered into. And we say we should just refuse to allow it to be advanced. There's another section then of the pleading at B420, which is about writing off Al-Khalij debts. But as I say, the primary purpose, they say the primary purpose of removing the first defendant and appointing the second claimant as general manager was to write off or extinguish debts. That wasn't put, and it doesn't make any sense because Al-Khalij had succeeded in the claim, so there was no need to write off any debts. In closing, though, if you go to paragraph 597 on page 192 of that closing, they say something different. They say, in essence, the reason the further steps taken to remove the first defendant's general manager was in furtherance of the same goal, enabling a set of circumstances in which Al-Khalij enjoyed uninterrupted use of MCC. And then if you go forward to paragraph 599, the claimant's primary purpose in removing the first defendant as general manager of HI Dubai was a continuation of their efforts to divert revenues owed by Al-Khalij away from HI Dubai. So now we've got two primary purposes which are alleged, one in the pleadings, writing off debts, and one in closing, diverting revenues, neither of which were actually put to the witness. At paragraph 600, they say, well, you can infer certain intentions of the claimants. And again, you've just got an unpleaded inferential case which was never put to the witnesses. So it's just a new case, just sort of shuffle the deck, throw out a bunch of new allegations in closing, don't close on it orally, and just sort of leave it out there for your honour. We say that's not a proper way to advance a claim. So we say there's no arguable case for unfair prejudice. The case is incoherent. It's shifted around, and it was never actually put to the witnesses. And except for the claim under Regulation 79, where the pleaded case is abandoned, it seems, all of the remedies sought are for unfair prejudice, which is a matter for the DVA. Your Honour, those are my submissions on the counterclaim. I had a few very brief observations on adverse inferences.
Yes,
thank you. So my learned friend's written closing, pages 14 to 33, deal with adverse inferences at great length, and we say these are quite misconceived. Now, clearly, if there's a breach of a document production order, the court has power, it's open to the court to draw the inference that the reason for the failure to produce the document is that if there was compliance, documents would have been produced which undermined the party's case. That's the logic. But it's not an automatic conclusion, and it's not a punishment. You don't just say if you breach an order, you lose the case, because we're going to draw endless adverse inferences based on speculation. Now, at trial, there was a lot of cross-examination about request number 10. And you may recall, it's actually recited in the defendant's closing at page 21 of their closing. Request 10 required production of bank statements within a defined period, which showed payments from Al-Khalij to Health and Sites Egypt and to Health and Sites Saudi Arabia. And it was put to Mr. Al-Shafei in a way which we say is confusing, but at the very least confused him. He was never asked at this stage, were there any payments to Health and Sites Egypt? Or it was never suggested to him that there were payments to Health and Sites Egypt from Al-Khalij. And it's only those which, in respect of which there was an obligation to produce a bank statement. Now, in his evidence, Mr. Abdulaihid, Mr. Thamer, he confirmed that there were no such payments in the relevant period. That's day 3, page 140, lines 22 to 23. And the relevant bank statements for Health and Sites Saudi Arabia had been produced. That's day 3, page 131, lines 1 to 16. So we don't accept that there was any breach of that request. The way it was put was to say you haven't produced the bank statements of Health and Sites Egypt, and that was not the obligation, because it was only if there were payments that there was such an obligation. Of the other requests, the only one that was actually put that there'd been a failure to comply with were requests 2 and 3, which you will see. I'll come on to them in a moment. But on request 6, if we go back to that, please, if you can see it, it's helpfully recited here. Just thank you. It was said that the first claimant had not disclosed a contract between Health and Sites Egypt and Al-Khalij, but nothing else was said to have not been disclosed. That was all that was cross-examined on. Nothing at all was put about requests 4, 9, 11, or 14. And so we say it's just not open to my learned friend to make the sort of submissions that he is. He needs to give the witness an opportunity to deal with this. And one needs to recognise that what's being alleged is a deliberate breach of a court order. And the reason for that breach is to suppress material that would be adverse. And there was no attempt to deal with the witnesses on that at all. Now, the inferences which are sought on the back of this are pure assertion. Most of the facts which you are invited to infer were not even themselves pleaded or put. So what the claimants did accept was that they didn't produce Al-Khalij's documents. They accepted that, and they said they didn't feel able to do so. Now, it's open to Your Honour to draw the inference, in principle, that they were suppressing damaging evidence. But Your Honour has to at least consider their explanation for why they didn't produce those documents and what they said about it. And it wasn't put to them. They weren't challenged on that. What's now being said is that the reason why they didn't produce those documents was different, that it was to suppress damaging material. But they weren't given an opportunity to deal with that allegation. And then at page 82 of the closing, you're invited to draw all kinds of inferences. Sorry, page 29, I do apologise, paragraph 82, page 29. So, in respect of request 2, that as I say, that there was only fairly limited respect in which, they were accused of refusing to produce this. But what is said is that subparagraph A, the documents which are produced would have shown that Al-Khalij's contracts were entered into through HI Dubai. It's very difficult to understand what that case is, but ultimately it may be said that they would have shown that there were further contracts between Al-Khalij and Health and Sites Dubai, perhaps. It's hard to know. But that is firstly a non sequitur. Secondly, that conclusion is not pleaded, and thirdly, it was never put. And it's the same for subparagraph 2, which again is just simply asserted for the first time in closing. This is in relation to request 3. What my learned friend needs to do is identify the part of the pleaded case to which the documents would be relevant, explain why the documents would have information about that pleaded case, and explain why or how those documents might be adverse. Now, these documents were all, in request 3, this is still Al-Khalijah's documents, about Al-Khalijah's relationships with its customers and what you get by way of inference of pure assertion. They would have shown various things which go well beyond what were the terms of the provision of services to customers. At subparagraph 3, you get inferences asserted in relation to request 4, and these are payments made by Al-Khalij to HI Egypt from 2021 to date. But that was in relation to payments. And as I said, we say, firstly, the HI Saudi Arabia documents were produced. And secondly, in relation to HI Egypt, there were no such payments. Request 4, as I've said, in relation to, subparagraph 4, in relation to request 6, as I said, it was only put that they failed to disclose the contract between HI Egypt and Al-Khalij. That's at day 1, page 142, lines 6 to 24. And the first claimant said that he had, in fact, complied. But the inferences that are sought, we say, just don't make any sense. So subparagraph A, you just got to read it. There's no proper, the document would tell you, apparently, that there's no proper contractual basis upon which either HI Egypt or HI Saudi came to assume contractual rights that have historically belonged to HI Dubai. I mean, and B, it said the documents would show that had the claimants disclosed the relevant contracts, it would have shown that the contracting party remained HI Dubai at all material times. But then there would be no. But the request is about HI Egypt's documents, not HI Dubai's documents. So if the contracts were with HI Dubai, there would be no HI Egypt documents. So none of this makes a lot of sense. Subparagraph 5 refers to request 9 and 14. None of that was put. And the inferences, again, that you were invited to draw were not put. I don't have time to go through that in much detail, I'm afraid, but I just urge on Your Honour, people regularly come to courts and say adverse inferences save the day, but they can only support a case that is already advanced. They can only, you need to find, it's not a punishment. You need to find that the reason for non-disclosure was actually to suppress damaging documents, and that would need to be put. Your Honour, I've raced rather through that, I'm afraid, but I think I've run out of time, and I've no desire to keep people any longer than I've already given them.
All right. Well, thank you very much, Mr. Montague-Smith. Mr. Doherty, you have another half hour.
Yes, Your Honour, I'll not keep anyone longer than is necessary as well. If I can just pick up first with the last point about adverse inferences and the suggestion that there was no breach in respect of request 10. It just completely ignores the objective evidence that's already before the court. And in particular, Your Honour will remember from trial the tax returns submitted in Egypt and the tax audits which were carried out, in particular at a time when it was the claimants who had control of Health Insights Egypt based on those filing dates. That was the documented E105. And what those tax audits recorded for the year 2022 was that there was consistently provision of funding and debit movements representing the repayment of funds originating from Al-Khalij or payments dispersed on behalf of Al-Khalij to third parties. So what the tax returns say, albeit that in the context of Health Insights Egypt not wanting to pay tax in those funds, they say, well, these weren't sales. But what it clearly records is evidence of receipt of payment. Payments were received, and either they were sent back to Al Khalij or they were distributed on behalf of Al Khalij to third party. That's what the objective evidence established. So when the claimants, given their approach to disclosure in general, come before the court and say, well, we don't accept there was any breach, the evidence is that there were no payments, that's contradicted by the contemporaneous evidence, and they didn't disclose the bank statements. So what's the court to do? Is the court to simply say, well, I accept Mr. Abulaihid's word for this? Or do we look at what is objective contemporaneous evidence in the tax returns and say, well, there was a flow of money in and out from Al Khalij, and no bank statements have disclosed, and I should draw appropriate inferences from that? Clearly, the latter course is the one that Your Honour should adopt. And, lots of criticisms were made about pleadings, which I'm going to come back to. But well, they haven't identified the contract they're referring to. They haven't identified the payment they're referring to. It was expressly signposted in the reply at the point in time when this claim was pleaded that what was envisaged is that following proper disclosure, as should have taken place in this case, the defendants reserved the right to re-plead accordingly once the full details of the transactions were known. But of course, that information is information which is not known to the defendants. The information was held by the claimants and they were ordered to disclose it. They just didn't. So, for example, if one wanted to piece together the full scope of what was going on here, when it comes to Al Khalij's ongoing utilisation of MCC in various different hospitals, the way you would ascertain that is by looking at the contracts that it has with the various healthcare providers. When you want to find out, well, is Al Khalij getting paid for this? And you'll remember in the box, all of this stuff being introduced for the first time about, well, the contracts are back to back, i.e. the contracts we've refused to disclose are back to back. Well, if you disclose the bank statements, we would have seen if Al Khalij had paid money and then refused to pass it onwards, as they were obliged to do. The onward, even putting to one side the Al Khalij documents, I mean, it's a pretty striking feature of this case, I should just say, that, well, what the claimants are saying is this was confidential to the company, so we're not going to provide it, notwithstanding that we have access to this information. Your Honour will recall questions having been asked of Mr. Shehata in relation to contracts that had nothing to do with this case, and a similar assertion being made, and the point being made correctly that this court is not interested in those assertions of confidentiality. And if you are going to assert that type of confidentiality, you have to do it before the order for production is made. They didn't. But even putting that to one side, putting the Al Khalij category of documents to one side, the chain of payments would have been readily ascertainable from documents which the claimants held by virtue of them being directors of both Health Insights Egypt and Health Insights Saudi. So they obviously had copies of bank statements, remittances, invoices, and access to that in that capacity. And there was no suggestion that they couldn't disclose that for confidentiality reasons. But what that would have showed is what money was paid to the various Health Insights entities for the implementation of MCC. You would have also seen that from any contractual documentation. So, for example, what we know as a matter of fact is Health Insights Saudi receives over $3 million in revenue in a 6-month window of time in between 2024 and 2025. Now, what the basis that Health Insights Saudi received that payment for is entirely unclear. But if there were contract terms that Health Insights Saudi entered into with Al Khalij, pursuant to which those payments were made, those were disclosable, and they haven't been disclosed. And there's no explanation of where Health Insights Saudi's underlying right to those payments is said to have come from. Similarly, when it comes to what I think C2 put it during his oral evidence as the restructuring of the business, requests were made for the disclosure of WhatsApp communications between the claimants relating to the payment of sums with respect to the MCC rights, in respect of the marketing and sale of MCC by parties other than Health Insights Dubai. None of that was disclosed. The court extensive disclosure order extensively breached. And the evidence that was given in the box was pretty extraordinary. And to contextualize it, the persistent breaches were pointed out ahead of trial in correspondence. They were the subject of an application, which Your Honour will recall, by Mr. Shehata for a declaration that they breached the terms of your order. Your Honour will also recall saying at the 11th September hearing that you were provisionally persuaded at that time that the claimants had not complied, and that they were on full notice that if they continued in their non-compliance, what the range of options that were open to you were going to be. So, having made those points on the 11th of September, what unfolded at trial, we say is pretty alarming. The second claimant initially sought to suggest that he provided everything he asked for. He then said that actually he was never asked to provide Health Insights Egypt's bank statements. And when that was shown to be incorrect, what he said was, well, nobody told him about the order or what it said, effectively throwing his legal team under the bus, before eventually retreating into what he thought was safer ground of saying, well, he couldn't remember if the documents had been requested. It must be that he had forgotten. And in the context, given the procedural history, that's just implausible. The first claimant's approach was different, but we say no less concerning. He fell back repeatedly on this point that he wasn't going to disclose anything related to Al-Khalij. And there was effectively the suggestion that it was for him to decide what you're entitled to see. So you're not entitled to it because it relates to Al-Khalij. That was what was suggested, which is obviously incorrect and obviously not a basis to ignore a court order for disclosure. But in any event, it wasn't an answer to, well, why didn't you provide the documents you were also ordered to provide when it came to Health Insights Egypt? Moreover, why is it that both claimants separately, and to be clear, the disclosure order applied to them separately, they both had to comply with it. Why is it that between them they've contrived to forget or to overlook precisely the same bits of requested disclosure when it came to documents relating to Health Insights Egypt or Health Insights Saudi? The explanations offered are just ought to be seen by the court as unacceptable. And we say the documents obviously should have been disclosed. If they had, they would have demonstrated what we've set out in written closing. And I think in the interest of time, I'm not going to go through all of the points that we invite Your Honour to conclude from that failure. It's set out at paragraph 82. So that's the disclosure points. On the points taken with respect to jurisdiction and unfair prejudice, I've already given Your Honour my detailed submissions on that. I'm not going to repeat it. We say that Your Honour plainly has jurisdiction conferred by the regulations and the articles. The claimants have put forward a submission that the Dubai courts would have jurisdiction under the regulations if there was a DDA referral. I mean, if that's the case, and this applies to everything that's said by the claimants on jurisdiction, but when the counterclaim in this case was filed, there was no challenge to the DIFC court's jurisdiction under Part 12, either stating that the court doesn't have jurisdiction to deal with this issue, or that it should decline to exercise jurisdiction because the Dubai courts are the most appropriate forum. And the time for arguing, we say that the DIFC court has no jurisdiction, or that it should not assume jurisdiction that it has long passed, and the claimants have in any event acquiesced to you determining this issue. There was another point which we say was incorrect, which is there was an assertion of there
just
being...
a minute. If the court just doesn't have jurisdiction, it can't get jurisdiction by the parties not objecting to it, can they? Can it? We're not talking about personal jurisdiction here. It's subject matter jurisdiction.
Well, I've given Your Honour the reasons why you have subject matter jurisdiction.
Ah, yes.
And one of the points that was raised is that there's a conflict, for example, between the regime that's set out in the regulations, which is at odds with what's set out about jurisdiction in the articles, and the court's jurisdiction is derived from the contractual provisions in the articles. And the point that we address on that is when you look at the articles, they say that where there is a conflict, the articles prevail. So that's Article 29.1. So subject to these articles, the provisions of the private companies regulations shall apply. To the extent there's an express inconsistency, the provisions of these articles shall prevail, provided that such provisions comply with minimum requirements set out in the private companies regulations. So if the argument is, well, there's a different regime specified in the regulations than there is in the articles, the one that is relevant in the present context is the articles. And to complete that submission, I remind Your Honour that Article 108.4 of the regulations expressly says that nothing in this regulation 108 affects the powers that any person or the relevant small c court may have apart from this regulation 108. In other words, if you've got a contract which specifies alternative forum provisions, then there's nothing in the regulations which would prevent the DIFC court from being the appropriate forum. And the second point, again on that, is Article 109, which says that orders made by any court, so that's small c court, or arbitral body, under these regulations, may be enforced as orders made in an action pending therein. So it has to be at least implicit within that a small c court can make an order under the regulations. And so there's nothing within those provisions which prevents the DIFC court from assuming jurisdiction over an unfair prejudice petition. So that's an answer to some of the points that were taken about that this morning. The next point I wanted to address, Your Honour, on is another new argument. Speaking of shuffling the deck, when it comes to the retroactive effect of the Copyright Law 2021.
Sorry to interrupt. This is a reply on the counterclaim.
Well, there's a new point that's been taken for the first time. I'd seek Your Honour's leave to be able to address a point that's been raised, which seems to be pretty fundamental.
I'll let you do it brief. I'll let you do it briefly.
I took Your Honour through the pleadings, and I'm grateful for your indulgence earlier to show you why the assertion of the collective work was only introduced in the skeleton. But I mean, what was introduced in reply submissions on oral closing was effectively, as I count them, 5 new legal arguments.
I think you're addressing one, the question about the retrospective application of the law.
Yes, well, I'm not going to address them all individually. The 4 of them arise through the retrospective effect of the law. So the first point is the law that applies is 2021. And on that basis, a diffuse range of arguments were advanced as to why authorship can be conferred by the payment of fees, or by attribution, or by acts of employees, or that there's some joint authorship of a derived work, all of that being taken from the new law. The point we make is that these are new issues of non-DIFC law, which just can't just introduce that in reply oral submission, particularly where the principles in play are specialist, and particularly when it comes to the retroactive effect of laws, really would need to be the subject of expert evidence. And in particular, Your Honour, just to draw your attention to it, Article 112 of the UAE Constitution says that a law shall only apply from the date it comes into force, and shall not apply regressively. In non-criminal matters, a law may, where necessary, provide otherwise. So you can have some laws which can have retroactive effect if they expressly state that they will have retroactive effect. There's nothing within the 2021 legislation which suggests that it does have that kind of effect. And the case that was introduced to try and explain this really just doesn't share any that issue. So, I mean, just to quote from it, what it says is, it was established that a new law applied directly to events and legal situations that occurred or take place after its enactment, as long as the door for pleading before the Court of Appeal was open, not closed, before the date of its implementation. Now, what that is saying is that a new law applies to legal situations that occur after enactment, not before. Unfortunately, the case that's been cited doesn't really actually explain what its factual scenario is. So, for example, it's quite one thing to say that a piece of IP that was created, let's say in 2005, and someone is taking actions which, as late as 2023 or 2024, are alleged to be an ongoing infringement of someone's intellectual property rights. You could easily see in that scenario why, at least for that period of time postdating the implementation of the law, the new law might apply to claims for infringement. But what it doesn't do, and what the law can't do constitutionally, unless it expressly says so, is effectively go back into history to rewrite the way that a proprietary interest accrues to someone. You can't say, for example, if when the 2002 law was effective, that the interest accrued to an author through them taking certain steps to produce the work, and that situation prevailed up until 2021, but then by operation of law, you're robbed of what are effectively your proprietary rights, because some new provision says that actually on an application of the new law, someone else might have been deemed to have acquired an interest in the work. So employees would be a classic example. If the old law doesn't expressly say if you do work as an employee, the work becomes owned by the company, you're entitled to assume and operate on the basis that you would acquire the property rights under the old law, and your employer would not have any automatic right in them. What an employer can't then now do is reopen every single case of IP acquisition under the 2021 law to say that, well, you were our employee at the time. So notwithstanding what the law was when the right was created, we're now enforcing that right. That just doesn't make sense. And we would say it's inconsistent with fundamental principles of UAE law. And to have it introduced as an argument in this way at the 11th hour and 59th minute is not an acceptable way to go about things. But in any event, and I'll deal with this point shortly, for the most part, the case still seems to be, from the claimant's perspective, it doesn't matter which law you apply. And in a sense, that's correct, because many of the points that were taken, for example, on attribution, and who works are attributed to, for example, if your name is on a painting, the attribution might be presumed to be you. But all of that attribution, as a matter of the statutory language used, applies to authors. And authors are defined as being persons, which has to be natural persons. That's the effect of the law. And
why does it have to be? Why does it have to be natural persons?
Because that is what the legislation says. Authors are persons who create the work. If you completely in order to get to the conclusion that a legal entity assumes entitlement to the work, there are a number of things you have to ignore. But one is the integral nature of the creativeness that needs to go into a work in order for IP rights to be generated. And that creativity, we say, comes from natural persons. The reason you can read that textually as being correct is because where there are exceptional circumstances in which a legal person can acquire rights, it's specified that the legal person will acquire the rights in that way. So when you look at Article 26, and it says that a legal person may acquire first ownership rights through a collective work, the corollary of that is that they can't acquire rights as an author.
I mean, sorry to interrupt again. I mean, my own friend is now rejoinding on an argument that he raised for the first time in his closing, and I had one opportunity to respond to it in a scramble just before Christmas, and now he wants to develop it again. I mean, I do question.
Right. So Doherty, what you wanted to address was the retrospectivity point, but I think you're going back to argue the position under the old law, which you've already put, haven't you?
Yeah, well, I've already put that point, Your Honour. It's the claimant's case, which was only really developed the first time, and the point is that it's changed. New theories of authorship have been advanced in closing oral submissions, which were not there in written submissions, and we say that that's been improperly done, and Your Honour can't find on that basis. But in the event we say it's wrong. But moving on. Some of the, excuse me, some of the submissions that were made when it came to the facts on this, I think it was one of the points put which needs to be replied to is the suggestion that engineer Farhan was...
Again, this is just rejoinding on the claim. This is just rejoinder on the claim. This is supposed to be a reply on the counterclaim. You're not, this is,
Yes.
you know, I mean...
Counterclaim, please, Mr. Doherty.
Right. On the pleadings, Your Honour, one of the things it said is that the foundation... it said the foundation of the unfair prejudice claim is that when you strip away the allegations of breach of duty, all you're left with is an unparticularised unfair prejudice claim. I mean, that's just a way of saying that, well, if you strip away the things that we have actually pleaded, there's no pleading, which is obvious, but doesn't really engage with what's actually pleaded.
All right, Mr. Doherty,
the
I'm going to let you advance all of this, but remind you that you're to finish at 9:03 or even with a bit of leeway 9:05. So use the time as you see fit.
The pleadings, if Your Honour can open them up, so it's B4, I think, is the defence counterclaim. If we go to paragraph 79. Thank you. This is the allegation which I went through the legal submissions on earlier, but it's the claimant's undertaking acts which are contrary to the interests of the second defendant. So that's resisting claims, taking steps to register MCC rights before the Egyptian ministry, taking steps to assert ownership of MCC rights in favour of HI Egypt, and then over the page. Continuing to license, implement, maintain the MCC software in the territories without payment to or seeking permission of the second defendant as the authorised partner reseller in respect of those territories. So,
do you say this is all conduct in the affairs of HI Dubai?
Yes, it is, and it has to be because it's conduct which engages their duty as directors to Health Insights Dubai. It's not a defence to if you are operating in conflict with the interests of the company of which you're a director, to say that the way in which the opportunity presented itself to you is in some other capacity. So you can't just say that an opportunity...
No, but your claim is not one, you don't bring it as a claim of breach of director's duty. It's brought as an unfair prejudice claim, and that must be in the conduct of the affairs of the company.
Yes, and the conduct of the directors here in breach of their duty, which has the effect of negatively or detrimenting Health Insights Dubai, is conduct of the affairs of the company, because what's occurring is that the directors of Health Insights Dubai have been put in a situation where they are preferring the interests of one company, which they are a set of directors, with another. And in doing so, that has the effect of diverting business opportunities and interests away from Health Insights Dubai to others. And it's clear, we say, in the context of an unfair prejudice petition, that this sort of conduct is not permissible.
Mr. Doherty, just to be clear, you say that is so even if they were not in control of the company.
Well, I mean, this point of control is not, it's not properly framed, and it's not sort of, it's immaterial. It's a distraction from what the central issue is. So it is not necessary for a director of a company to be in control of the company in order for them to embark upon conduct, which means that affairs of the business are being run in an unfairly prejudicial way. So, for example, in the classic case, we've got a scenario where the majority of a quasi-partnership wants to exclude someone from what had previously been their management position. That can still be unfairly prejudicial. So even though the person who's the manager is the one that's being excluded, it's by the acts of the directors and of the company.
By the majority using
Yes.
their power.
Yes, that's one example of just to isolate that it's not, it doesn't matter who the general manager of the company was. The fact is that the claimants were directors of the company, and it's as directors that their conflict arose. And just to put this in what we say ought to be pretty clear terms, I referred, Your Honour, earlier to the Scottish cooperative case. And it's probably worth just bringing that up to think about what the conduct was in that case, which was deemed to be in respect of the affairs of the company. So that's H115, page 2. If you scroll down, it's the extract in the middle, which Your Honour might want to go back and read when you're considering this case. But what conflicts the directors here, so they're nominee directors, the parent company that appointed them to the board of the company in which the unfairly prejudicial conduct is said to have arisen, they hold positions for both. The judgment says that whilst everything's in harmony, they can carry out their duties without being troubled too much. But what happens is that once the parent company takes steps to divert the resources of that business to elsewhere that were previously directed to the company, at that point in time, they operated under a conflict. Because on the one hand, they had duties to the company in respect of which unfair prejudice was asserted. And on the other hand, they had a duty to the other company who was diverting the resources. And they were under a duty to that company not to disclose the knowledge that they had acquired as directors there to a competitor. So the conduct, or I suppose the breach that arises is because the directors of the parent company don't disclose their knowledge that these resources are being diverted to effectively someone else. Their conduct, when framed purely by reference to the business in respect of which unfair prejudice was alleged, was that they did nothing. But the court's decision faced with those circumstances where you can't say that the directors are taking an act on behalf of the company in respect of which unfair prejudice is asserted. They're not taking a positive step at all. But what the court nevertheless said is that inaction in that context can amount to oppression. So doing nothing to defend a company's interests when faced with a conflict, or in circumstances where you ought to have stepped in, is in itself injurious to the interests of the company and is unfairly prejudicial, or can be unfairly prejudicial conduct. So if the claimants do something which benefits Health Insights Egypt or Health Insights Saudi to the detriment of Health Insights Dubai, in circumstances where in fact they owed duties as directors of Health Insights Dubai, that's oppressive conduct because they, in those circumstances, would have been caught between their competing sets of duties. One to either Health Insights Egypt or Saudi on the one hand, not to disclose what they were doing with those companies, and certainly that is how they acted. But on the other, if they had been acting properly by Health Insights Dubai, they would have disclosed the fact that revenues that previously fell into the hands of Health Insights Dubai were now being paid elsewhere. and they didn't do that. And so we say that this is a case which is more extreme than the Scottish cooperative case, because this isn't just a case of inaction amounting to oppressive conduct. This is them taking steps on one side, which is leading to Health Insights Dubai losing out. And we say in that context, it's and where the duty is strict, so the no conflict duty is strict, it's impossible not to view that, we say, as conduct which is unfairly prejudicial to the shareholders of Health Insights Dubai. And Your Honour, I think those are the points that I had.
All right. All right. Well, thank you.
Your Honour, before we wrap up, I
Yes.
don't want to come back with any reply on this case. I wondered if you'd indulge me. We just had some rather sad news that Nicholas Carnell has passed away. I don't know whether you knew, Nick. He was a consultant at Davidson's and previously was a partner at Kennedy's and Taylor Wessing. But he has the distinction of having been the first advocate to appear in front of the DIFC courts. I remember it well, because he appeared in front of Sir Anthony Evans, and Sir Anthony said to him, Mr. Carnell, when advocates address this court, they stand. And he responded, well, I'm so short it won't make any difference, and proceeded to sit through the whole hearing, which I had opportunity to tease him about subsequently. But he's a long-standing, very well-respected member of the legal community in the DIFC, and more than that, he was a thoroughly good person, wonderful company, and a great sense of humour. So I just wanted to take the opportunity to express my condolences to his family, and I hope you don't mind.
No, thank you, Mr. Montague-Smith. That is indeed sad news that the court joins you in that acknowledgement. So, thank you. All right, well, we are getting very close to Christmas now. I wish you a safe and rewarding festive season. I will, of course, reserve my decision. And I also thank you, your juniors, and those instructing you for the assistance that you have provided throughout this case. I thank the court staff and their patience in sitting additional hours again today. So with those notes, thank you. The court reserves the decision, and that now concludes today's hearing. Thank you.
Thank you.
Thank you.